Good morning and welcome, everyone. First, let me just check with Michelle. Michelle, is everyone in that had registered?
I believe so. It looks like most everybody's joined, if not all of them. So,
Okay, all right. Just a moment. All right. Good morning and welcome, everyone. I call this evidentiary hearing to order. It is in the matter of application of NextEra Energy Transmission Southwest LLC for a siting permit for the construction of a 345 kV transmission line through Coffey, Anderson, Allen, Bourbon, and Crawford counties, Kansas. This is docket number 23 NETE 585 STG. I'm Susan Duffy, and I'm serving as chair of the commission, and I am joined by Commissioner French and Commissioner Keene and a host of others. So let's begin. May I have entries of appearances, please? And I will start with NextEra. Andrew Schulte.
Good morning. This is Andrew Schulte on behalf of NextEra Energy Transmission Southwest, or NETE Southwest. Also appearing today are Ann Kallenbach and Sean Pluta. We are all with the Polsinelli Law Firm at 900 West 48th Place, Kansas City, Missouri 64112.
Thank you. Next, I'll go to the McGee's. Mr. Kimmel.
Rustin Kimmel appears on behalf of Darren McGee and Rochelle McGee Smart.
Very good. And Evergy, Glenda Kafer.
Good morning. On behalf of Evergy, an appearance of myself, Glenda Kafer, and Trevor Wolford of Morris Lang Law Firm, Topeka, Kansas. With the change of the hearing date, Evergy's in-house counsel, Patrick Smith, was unable to be here today or tomorrow, but if we go into the third day, he will be participating in this.
Very good. Thank you. IBEW, Brian Wood.
Good morning. Brian Wood of the law firm of Wickham and Wood from Kansas City, Missouri, appearing on behalf of IBEW Local 304 in today's hearing.
Thank you. And KCC staff, Hassan Latif.
Hassan Latif appearing alongside Walker Hendricks and Phoenix Anschutz on behalf of staff and the public generally.
Thank you. And of course, we do have our court reporter, Denise Haas, is with us. Good morning, Denise.
morning.
Very good.
Thank you.
All right. Does staff have a recommendation regarding notice?
Yes, thank you, Chair Duffy. The commission's order setting the procedural schedule in this matter was filed on February 2nd, 2023, and set an evidentiary hearing in this docket for April 26th through 28th from 9 a.m. to 5 p.m. On April 21st, 2023, the commission issued a presiding officer order amending procedural schedule and notice of hearing that, out of an abundance of caution to ensure the evidentiary hearing was in compliance with KSA 7275518, moved the evidentiary hearing to today, May 2nd through 4th from 9 a.m. to 5 p.m. to be held by Zoom. The order was issued 11 days ago, thus meeting the CAPA requirements for 10 days notice, and staff notes that the parties are present today and recommends a finding that notice is proper.
Thank you. Are there any objections to this notice?
The McGees object for the reasons stated previously. This meeting should have be held in person in a county in which the transmission line traverses.
Okay, thank you, Mr. Kimmel, and your objections are denied. Thank you. We will proceed. We do have some preliminary matters. First, if any party encounters any technical issue today, please ask to go off the record so that the technical issue can be resolved. Second, Witnesses participating by Zoom, please keep your microphone off when you are not scheduled to talk. Third, if the commission needs to deliberate, we will be going off the record, entering a Zoom breakout room where you can't see us or hear us, and then we will return. Fourth, as we're participating at a distance, please be especially careful to identify exactly what you're referring to when discussing pre-filed testimony and exhibits. We have copies of all of that on hand so that we should be able to follow. Fifth, this is an administrative hearing, not a trial. And so under KAR 82-1-230, I may relax the rules of evidence if I believe it is in the public interest to do so. Sixth, even though this is not a courtroom, I expect the parties and witnesses to comport themselves in a manner befitting a courtroom. Seventh, I am aware that at least one party has chosen not to sign the commission's non-disclosure agreement and will therefore be excluded from any discussion of confidential information. We will do our best to keep as much of our discussion public. If that party changes their mind and signs and distributes the NDA prior to any confidential discussion, they will be allowed to participate. Eighth, Mr. Kimmel, you've indicated you have a conflict hearing tomorrow. Have you been able to resolve your conflict?
I have not.
Okay, can you give us some additional information about the nature and time of the conflicting matter?
It's a hearing that's going to last several hours tomorrow afternoon, starting
Beginning,
at 1 o'clock in Coffey County.
and when do you expect this to end?
Do I expect what to end?
The hearing, the conflicting hearing
In Coffey County.
I
in
hope
Coffey County?
at some point, I hope it ends. I'm not following your question.
You said a couple of hours. Should we assume 3 p.m., 4 p.m.?
I think that we should, to be safe, I think that we should recess for the afternoon tomorrow.
Do you have a case number for that hearing?
I do.
Okay.
Would you like it?
Yes, please.
Give me a second, Commissioner.
Okay. While we're waiting, I did neglect to say that I find that notice was proper. I apologize.
CF -202 DM -000006.
Okay. CF 202 DNZ 00006.
No. CF -2023 DM -000006.
Okay, thank you. I appreciate that. Also, I anticipate that we will have short 10-minute breaks approximately every 90 minutes. Lunch will be 30 minutes long. And I also anticipate ending the day's proceedings at 5 p.m. This is all subject to change, but just that is what we are anticipating. Thank you. Are there any other preliminary matters that need to be addressed? Okay.
Chair Duffy.
Commissioner.
Glenda Kafer, yes, you spoke.
Yes, Evergy had requested that administrative notice be taken of a couple of documents in the certification docket in this for NextEra on this line 22 NETE 419 COC. The two documents were Evergy's petition for reconsideration that was filed on September 13th, 2022. And then the commission's order on that petition for reconsideration that was issued September 29th, 2022. We did provide those in advance and we marked them as Evergy Hearing Exhibit 1 and 2 respectively. So however the commission prefers to handle it, I just wanted to make sure that that was specifically addressed.
Okay, do I hear any objections? Hearing none, it's so ordered. Mr. Kimmel, yes.
Yes, I requested to have tomorrow afternoon recessed. I don't believe that there was a resolution to that request.
Mr. Kimmel will take that under advisement. Thank you. All
A
right.
couple of other issues that I would like to raise, Commissioner.
Other objections?
Well, preliminary issues.
Oh, okay. Preliminary issues, please.
Yes. Given that this is an evidentiary hearing, I'd request that the commission invoke the rule and sequester the witnesses. I'd also like to ask the commission to, I think there's several stipulations that we could come to an agreement on, perhaps on the record, that would reduce the length of this hearing. And I think that we should consider those stipulations.
Okay, I don't know what those stipulations are, but we'll take this under advisement. Thank you. All right, now procedures during the hearing, if we could. We will begin with opening statements.
I have one, staff has one more.
Oh, I'm sorry. Okay,
okay.
Staff, I apologize.
That's okay. Staff requests the commission make official notice of two items from the 22 NETE 419 COC docket. They are staff's R&R, which was filed May 17th, 2022 in that docket, as well as the commission's order on application for certificate of convenience and necessity that was issued in that docket on August 29th, 2022. Both those documents were provided when we circulated exhibits on Friday, and we would just ask the commission to take notice of those going into the hearing.
Okay, do I hear any objections?
I didn't understand the first thing that you were asking to take judicial notice of.
Mr. Latrice, could you respond, please?
It's staff's report and recommendation in that docket, which was filed May 17th, 2022. One of the authors of that report and recommendation is the staff's witness in this hearing, so he can answer questions about that during his testimony if they're needed.
No objection.
Okay, so no objections. Are there any other objections? Hearing none. It's so ordered. Mr. Kimmel, back on your request for a need to sequester witnesses, can you refer to the specific rule regarding this, please?
The rule for sequestration is a rule that the courts invoke in evidentiary hearings. It's not a statutory rule. It's called the rule for a reason. It is the rule where a party can ask for witnesses to be sequestered. And I think it would be appropriate in this matter.
Is it a court rule then? You're referring to a court rule?
Yes, it's a like I said, it's not a statutory rule. It's a.
Mr.
it's
Kimmel,
a-
Mr. Kimmel, could you provide me the number for that court rule, please?
That's what I was trying to explain. It's called the rule for a reason. It's not a statutory rule. It's a rule of general procedure that courts invoke generally as a matter of course to sequester witnesses at a trial prior to their testimony.
Okay, other parties, do you want to weigh in on this, please?
Well,
I will
I think-
recognize Mr. Schulte.
thank you,
You're
Chair
on
Duffy.
mute. There we go.
Thank you, Chair Duffy. Yes, sorry, my audio is running through another speaker. We would object to any sequestration of witnesses. First of all, we don't know what rule is being invoked and what the parameters of that sequestration would be. So it seems to be too vague to be enforceable. The other objection we would note is that this is an administrative hearing, as the chair noted at the outset. The rules of evidence are relaxed, and there has never been that rule invoked, to my knowledge, in a KCC proceeding.
Staff also has arguments.
Okay, staff, please.
Staff would also point out that much of the testimony has been pre-filed in this docket, and so other witnesses have been able to review those pre-filed testimony. So the purpose of having sequestration of the witnesses during this hearing seems to be unnecessary. And also, we second the argument made by NextEra that I'm sorry. That the rules of evidence are relaxed in these hearings, and that it's not necessarily necessary for those to be through that rule to be invoked here. Thank you.
Thank you, Mr. Lateef. Anybody else want to weigh in on this before I believe I'm going to send us the commissioners to a breakout room unless somebody else of the parties have a comment? Seeing that there is no others, we're going to leave for a breakout room. Thank you.
Well, they don't, they don't see our face.
And after that, no snack for you. Get in the corner.
Okay, I believe we have everyone back. Looking for Commissioner Keen. Okay, are we all back? Commissioner Keen?
I think we've lost Commissioner King. He's rejoining now.
Okay, we have everyone back. All right. Mr. Kimmel, we are going to object to your requirement on sequestration. This is, we're going to deny it. It is an administrative proceeding that we're in. And secondly, we will be adjourning the meeting at 1 p.m. tomorrow so that you can attend your hearing.
Thank you.
All right. Also, under KAR 82-1-230 and KSA 77-524, the commission may take administrative notice of its own records. Given the relevance the CCN docket has to this docket, had NextEra not raised the issue, the commission would have done so on its own volition. And so there we go.
Chair
So we're
Duffy.
taking administrative notice of the entire record. Thank you. All right. Anything else, folks, before we move on? All right, we're going to begin. Oh, Commissioner French, did you have something?
Well, you said we're taking administrative notice of the entire record. I just wanted to be clear what we're taking administrative notice of.
The CCN docket.
Okay, thank you.
All right, very good. All right, folks, we're going to begin with opening statements and then move on to witness cross-examination. The commission on cross will go first and last with an opportunity for recross. Redirect will be limited to the scope of questions from the initial cross-examination. All right, so we will begin with NextEra and Mr. Schulte.
Chair, I apologize for interrupting here. I had asked for the commission to consider some stipulations. And I don't believe that request was ruled upon.
There are no stipulations.
You're not going to allow stipulations?
No, you haven't presented anything. So at this point, we're proceeding onward.
Oh, I was intending to right now. That's the reason why I asked.
Okay. Proceed, Mr. Kimmel.
Thank you, Chair. The first stipulation, like the commission or the parties to stipulate that the commission held a public meeting in Iowa, Kansas on March 1st, 2023, in an attempt to comply with KSA 66-1178B's mandate to hold a meeting in a county through which the electric transmission line is proposed to traverse. That's the first stipulation.
May I ask a question about the stipulation?
Yes, Mr. Schulte, please.
Is the requested stipulation that the commission agree to these statements?
That the parties agree. That is what the stipulation is. The parties agree. If one party doesn't agree to a stipulation, then it's not established.
Okay, we have not, this is the first that we have heard of these stipulations. And so we're not in a position to analyze them and agree to them.
Why don't we proceed with why don't we proceed with opening statements? We can take a break and Mr. Kimmel can present these to the parties during the break.
I think that sounds like a good idea. So, Mr. Kimmel, if you could, during opening statements, get that ready for all parties to see, I'd appreciate it. Okay, so we are proceeding to opening statements. And Mr. Schulte, I will begin with NextEra and you. Thank you.
Thank you. On behalf of NextEra Energy Transmission Southwest, or NETE Southwest, we thank you for your consideration of this line siting application. On August 29th, 2022, the Commission issued an order granting NETE Southwest a certificate of convenience and necessity, or a CCN, to construct, own, operate, and maintain the Wolf Creek to Blackberry 345 kV transmission project through Coffey, Anderson, Allen, Bourbon, and Crawford counties, Kansas. On January 24th, 2023, NETE Southwest filed this application for a transmission line siting permit, along with the direct testimony of 5 witnesses. Those witnesses included 3 in-house experts at NETE Southwest and 2 experts from NETE Southwest routing consultant Burns and McDonald. It has been nearly 10 years since the Commission considered a line siting application for a greenfield transmission line, but the legal standards and the procedures have not changed. KSA 66.1,178 through KSA 66.1,180 set forth the standards by which the Commission reviews line siting applications and states that the Commission, quote, shall make its decision with respect to the necessity for and the reasonableness of the location of the proposed transmission line, taking into consideration the benefit to both consumers in Kansas and consumers outside the state and economic development benefits in Kansas, end quote. The necessity for the Wolf Creek to Blackberry project is addressed in the direct testimony of Becky Walding, which is adopted and supported by Jacqueline Blakely in this case. As explained in that testimony, the CCN proceeding established that Kansas will benefit from the project by reducing overall electricity rates, increasing local tax revenue, and increasing system reliability. The project will have a beneficial effect on customers by lowering overall energy costs, removing inefficiency, and relieving transmission congestion. And it will improve the reliability of the transmission system. Ms. Walding's testimony, as adopted by Ms. Blakely, resubmits to the commission the evidence required to make the necessity finding in this case, which includes the SPP 2019 Integrated Transmission Planning Report, or ITP report. Ms. Walding's testimony also explains the Kansas-specific benefits that will accrue as a result of this project, consistent with the findings in the CCN case. As for the reasonableness of the proposed route, that element is established primarily through the routing study and environmental report attached to the direct testimony of Dusty Worth, which we will refer to as the routing study for short. Staff reviewed the routing study and determined that it provides a reasonable approach to evaluating options for siting a transmission line. To be clear, the proposed route is not equivalent to the route that was submitted by NETE Southwest to SPP as part of its bid. Rather, the proposed route before the commission includes several adjustments based on landowner discussions and additional diligence regarding environmental, cultural, and engineering issues. Most of those adjustments were incorporated into the routing study filed with the application in January. However, there were additional adjustments as reflected in the rebuttal testimony of Dusty Worth filed on March 21st, 2023. So to summarize, NETE Southwest is seeking the commission's approval of the proposed route as set forth in the routing study and as further adjusted by the rebuttal testimony of Dusty Worth. Mr. Worth's rebuttal testimony includes an updated set of maps identified as Exhibit DW5, which show the exact route that is before the commission today, including all updates to date. In addition to Mr. Worth's testimony, the reasonableness of the route is further established by the public outreach efforts, which informed the routing adjustments made to date. NETE Southwest witness Kara Rye discusses those public outreach efforts in her testimony. The application submitted by NETE Southwest also addressed a condition in the CCN order, which required a comprehensive evaluation of the potential to co-locate, otherwise known as double circuit, approximately 25 miles of the Wolf Creek to Blackberry transmission line with an existing 161 kilovolt transmission line owned by Evergy. The direct testimony of Jacqueline Blakely and Daniel Myers addressed this condition, and a double circuit report was included as Exhibit JB-1 attached to the direct testimony of Ms. Blakely. The double circuit report was developed with input from Evergy and SPP and reaches the conclusion that the double circuit option would cause between a 12 to 45 month scheduled delay for the Wolf Creek to Blackberry project. And given Evergy's uncertain timing for rebuilding the 161 kilovolt line, a completed double circuit project would not be in service until 2030 at the earliest. After thoroughly evaluating this option, NETE Southwest and Evergy all agree that the double circuit option is not practical or reasonable and should not be adopted. With regard to the procedure followed in this case, NETE Southwest's application triggered a process and procedure that is defined by statute for the commission to collect public input and to consider the proposed route and necessity for the line. Pursuant to KSA 66(1,178) and 66(1,179), the commission is required to hold at least one local public hearing on a line siting application. This local public hearing is in addition to the present evidentiary hearing. The commission satisfied the statutory requirement by holding two local public hearings, both within 90 days of the application filing. The first on March 1st in Iola, Kansas, and the second on March 2nd in Girard, Kansas. The local public hearings were part of a larger public comment period established by the commission to collect input from the public. During this public comment period, which lasted through March 9th, 2023, members of the public could submit comments at the public hearings or through email, written letter, or phone call to the commission. The public hearings were noticed through newspaper advertisements and direct mail to landowners along the proposed route. Other options for submitting public comments were included in the direct mailings and posted on the commission's website. This thorough process resulted in significant participation at the local public hearings and 50 additional comments received via email, mail, and phone. The commission's hearing process continues today with the opportunity for NETE Southwest staff and interveners to present evidence and argument and cross-examine witnesses. The commission's process has been thorough, fair, and compliant with all applicable legal requirements and consistent with past practices. Turning now to the issues raised by staff and interveners in this proceeding. There are only a few that remain outstanding. There are several others on which NETE Southwest and staff agree, beginning with the agreements. As recommended by staff, NETE Southwest agrees to notify easement grantors of their right to appeal to the commission to resolve restoration issues, including contact information for the commission's public affairs office. Such notification will be provided to landowners when exercising easement options and/or prior to the start of construction. As further recommended by staff, NETE Southwest agrees to file its permit and reclamation plan with the commission as part of a compliance filing. NETE Southwest and staff are also in agreement that the line will meet proposed ground clearances over cultivated fields, which will accommodate agricultural combines operating with grain bin extenders. Finally, NETE Southwest has resolved numerous routing adjustments requested by landowners and detailed in the rebuttal testimony of Dusty Worth, filed on March 21st, 2023. Turning now to the small number of disputed issues. There are 4 conditions recommended by staff that are not necessary or in the public interest. First, regarding the use of guide structures, you will hear evidence from Mr. Myers that there are only 27 guide structures anticipated to be constructed on cultivated land in Kansas. Those 27 guide structures impact a total of 3.8 acres, which is 0.6% of the total project easement area in Kansas. Guide structures simply will not have a major impact on farmland in Kansas and are a widely used, reliable, and cost-effective engineering solution. Second, staff recommended the use of dead-end structures at highway crossings. However, the evidence demonstrates that there are no material safety or traffic concerns resulting from NETE Southwest's currently proposed crossings, and there is no need to mandate additional dead-end structures at those crossings. Third, it is not necessary or appropriate to mandate an electric and magnetic field study after the line is operational. Not only is there no evidence of health effects related to EMF, which is short for electric and magnetic field, Burns and McDonald produced a model of anticipated EMF values for the project, which shows EMF levels at the edge of NETE Southwest right-of-way will be well below expert guidelines and well below the most restrictive state standard in the country. Further, the commission has previously found that it does not regulate EMF and that such issues do not address the necessity of the line or the reasonableness of the proposed route. Finally, there is a threshold legal issue with staff's recommendation regarding NETE Southwest's reimbursement of counties for pre-construction and post-construction inspections of county roads and bridges. First, the commission does not have jurisdiction over county roads and bridges. The counties do. Second, the use of county roads are not related to the necessity for the line or the reasonableness of the location of the transmission line. To be clear, NETE Southwest has already offered to reimburse counties for pre and post-construction inspections. So NETE Southwest is not opposed to the concept of reimbursement. However, there is simply no legal basis for it to become a mandate of the commission. Evergy has also recommended a condition that NETE Southwest opposes as unnecessary and contrary to the public interest. Evergy recommends that the commission mandate a buffer of 100 feet between the edge of NETE Southwest right-of-way and the center line of the existing 161 kV line owned by Evergy. However, there is no material engineering advantage to doing so, and such a buffer would create additional landowner impacts. Staff and NETE Southwest are in agreement that NETE Southwest right-of-way should be adjacent to Evergy's right-of-way wherever engineering and land conditions allow. Finally, the commission will hear about certain alternative routes beyond those that are already incorporated into the rebuttal testimony of Dusty Worth. While some alternative routes are possible, NETE Southwest does not yet have enough information at this time to know if such alternatives are feasible and reasonable. Our request continues to be for the commission to approve the proposed route with the adjustments described in Mr. Worth's rebuttal testimony. But NETE Southwest has also asked for flexibility to continue to work with landowners on minor modifications so that it may continue to explore the alternatives that are both feasible, reasonable, and agreeable to the landowners. In addition to the foregoing issues, the possibility of generally applicable setbacks or routing standards have been raised by staff and landowners in this proceeding. To the extent the commission wishes to explore those concepts, this is not the appropriate forum. Generally applicable standards must be addressed in a generic docket or a rulemaking proceeding that is properly noticed so that all interested stakeholders have the opportunity to participate. Additionally, retroactive application of setbacks or routing standards to NETE Southwest in this case would be discriminatory and legally problematic. On the other hand, NETE Southwest and its witnesses are prepared to discuss how the proposed route impacts landowners on a case-by-case basis, which is appropriately within the scope of this proceeding. NETE Southwest certainly appreciates the concerns of individual landowners, and the record in this case demonstrates that the company has done its best to address and mitigate those concerns. However, NETE Southwest has an obligation to balance the concerns not only of individual landowners, but also concerns such as environmental, cultural, and engineering considerations. The commission has a similar obligation. The difficulty of this task lies in the fact that there is no perfect route. Every route has impacts, and every route alternative requested by a landowner has yet a different set of impacts. For example, moving the route to be further from a residence may negatively impact other landowners, wetlands, sensitive species habitats, and myriad other considerations. Accordingly, a route cannot be deemed unreasonable simply because it negatively impacts a landowner. Instead, the commission must determine if the overall process employed by the applicant is reasonable. In this case, the routing study was reasonable because it applied generally applicable routing principles, while also incorporating the specific obstacles and opportunities presented by the study area. And the commission staff agreed. Further, the refinement of the proposed route through public outreach and landowner discussions has been reasonable and has resulted in additional improvements to the route. NETE Southwest is committed to continuing landowner discussions and route refinement within the bounds of a commission order approving NETE Southwest's application. NETE Southwest's commitment to this process is further evidence that the process is reasonable. Accordingly, the commission should have no hesitation finding that the proposed route is reasonable, that the line is necessary, and that NETE Southwest's application should be approved. Thank you.
Thank you, Mr. Schulte. We will move to the McGee's and Mr. Kimmel, if you would, please.
You're muted, sir. Mr. Kimmel, you are muted.
Sorry.
There we go. I think we can
Commissioner.
hear you.
Okay, Commissioner, at some point in my opening statement, I'd like to share my screen. Is that possible?
Yes, you
Yes,
should be
it
able to
is.
share.
Michelle can help you with that.
It
If
should be
you-
just in a control at the bottom to share screen and choose your PowerPoint or whatever it is you want
Do it.
to
Okay,
be viewed.
thank you. Good morning, Commissioners. Thank you for the opportunity to address NextEra's proposed transmission line route through Southeast Kansas. NextEra purports that its routing study and that line was designed to provide as much distance as possible between the transmission line and individual homes, residences, businesses, and other public facilities. The evidence in this case will show that NextEra considered 729 different routes between Wolf Creek and Blackberry. 720 of those routes had a lower residential proximity score than the proposed route. The evidence will show NextEra did not give adequate consideration to the impact their line is going to have on residences. It didn't give adequate consideration to the impact its line will have on farmsteads in this great state. It did not consider the impact the line has on machine sheds that farmers use to work on their equipment daily, or their barns in which they hold their cattle. If a machine shed, a farm, or other building on that farmstead did not fall within the 150-foot easement that NextEra proposed, NextEra ignored the impact of that line on those farmstead buildings. That is not giving adequate consideration to the impact of its lines on the farmers and ranchers of this state. Furthermore, NextEra's proposed lines run at a diagonal across many of the row crop fields and pastures, significantly impacting how these farmers operate their businesses. Staff, KCC staff itself, indicated that NextEra failed to give sufficient weight to the proposed impacts, the route's impact on residences and its impact on row crop fields. The evidence in this case will show that NextEra failed to perform an adequate environmental and routing study. And the process that got us to this point has failed to comply with the mandatory requirements set out by the Kansas Administrative Procedures Act. All of these facts should have been brought to the attention of the public at the March 1st and March 2nd public meetings that were held in Iola and Girard at the 1st of March. However, the evidence will show that KCC staff prohibited the McGees from presenting evidence on the same footing as staff and NextEra. Evidence will show that staff and NextEra spent nearly 40 minutes over 2 nights presenting their show, promoting and supporting the virtues of this transmission line, but limited the McGees to only 3 minutes. There's been no explanation as why the staff prohibited the McGee's from sharing this information with the public on the same footing as staff and NextEra itself. Instead of allowing a fair hearing in Iola, the McGee's, farmers and ranchers of the public and the public as a whole were met with this scene in Iola. 3 commissioners sitting at a table with NextEra's attorneys. The implicit message that goes along with that scene speaks volumes. The process that has gotten us to this point has been a travesty. But it's a problem that this commission can fix. It can send NextEra back to the drawing board to come up with a proposed line that does not have the impact on the residences, on the farms and ranches of this state. When this commission sends NextEra back to that drawing table, that's when this commission will be protecting the public interest. At the close of evidence, I will ask that this commission deny the permit, protect the people, the good people of Southeast Kansas, the farmers and ranchers that make up a huge majority of the economic development in this state. Protect the citizens of this state, please. Thank you.
Thank you, Mr. Kimmel. We'll move to Evergy and Glenda Kafer. Good morning, Glenda.
Ms. Kafer, you are muted still.
You are muted.
Okay, just have to hit it twice. Good morning again. I'm Glenda Kafer, counsel for Evergy. The proposal in this case is for NextEra's single circuit 345 kV line that was the winning bid through the SPP competitive bidding process. Evergy was not selected to construct, own, or operate the Wolf Creek Blackberry line, so we're not the applicant in this case, but as our testimony explains, we're involved as an intervener primarily for 2 reasons. First, because the commission might consider as one option for the line, the possibility of ordering Evergy and NextEra into a business relationship to somehow co-locate, co-own, cooperate, and co-maintain NextEra's line with Evergy's existing 161 kV line along a 25-mile stretch where the 2 lines are proposed to parallel each other, what we refer to as the double circuit option. Our second concern or reason we're involved is because the line, as it's proposed by NextEra in their application, will place NextEra's easement so that it directly abuts Evergy's existing easement on the stretch where the 2 lines parallel each other. So as the first reason, the double circuit, in the certification docket, the commission ordered Evergy to cooperate with NextEra to provide information that was used to create the double circuit option report that was submitted as Exhibit JB1 to the direct testimony of Ms. Blakely, NextEra's witness. Evergy complied with that directive. The report is clear that the co-location option creates more problems than it solves, and that ordering the double circuit line would result in unreasonable and costly consequences. And there are a number of reasons for this, but I want to start by pointing out first that the cost estimates in that report, they in and of themselves are speculative because an actual detailed design hasn't been vetted or agreed upon between Evergy and NextEra. But even if those estimated cost savings were considered reliable, the savings expected from a double circuit line are very minimal compared to the economic loss that would result from the delay needed to redesign the project and pursue that option. So the reasons the double circuit option is not viable is first, there are federally imposed requirements for competitively bid projects that this option would conflict with. And for example, the use of Evergy's existing easement would violate SPP's competitive project criteria. There are a myriad of legal implications hovering over a situation where two separate utilities share the same easements and structures. And the resulting litigation from something like this wouldn't just involve Evergy and NextEra. There'd be cost allocation and cost recovery disputes at SPP and FERC. It would be a battle between utility customers from Kansas and the entire SPP region over who doesn't want to be assessed for the split of these costs. And as we explained in Evergy's PFR in the certification docket that we requested administrative notice be taken of, this would trigger litigation from the utilities that bid on the project as it was noticed up by SPP and who didn't win that bid. The second reason is that Evergy and NextEra operate with differing design criteria that would have to be resolved. Having a single utility responsible for multiple lines on a single structure is one thing, but requiring two separate utilities into a joint venture of sorts is quite another. And that's especially true under SPP and FERC competitive bidding and cost allocation processes. And the third reason is that the project itself would likely be at risk due to the restudy requirements and potential rebidding at SPP. Delays in the project schedule would threaten the estimated $14 million a year in economic benefits that we're expecting from the project. And then any substantial modification to NextEra's proposed single line could threaten the project in its entirety. So as shown in the earlier certification docket, as well as the testimony that's been presented in this case, this line is needed and it provides both economic and reliability benefits to Kansas and to Wolf Creek and to the SPP region. But there isn't sufficient evidence in the record to support a co-location design and route. The report itself is evidence of why a co-location option is not a just and reasonable outcome in this matter, due to the circumstances of the project. So NextEra, Evergy, and staff have all recommended against the direct or the double circuit option in their testimony. That's the double circuit option concern. Evergy's second concern expressed in testimony is that NextEra's proposal places NextEra's easement so that it directly abuts on Evergy's existing easement where the two lines parallel each other. Evergy's primary concern about that is safety due to NextEra's design structure height and its proximity to Evergy's existing line. The evidence that we present will show that NextEra admits that if certain of its structures were to fail in the direction of Evergy's line, there would be contact with Evergy's conductor. Allowing for a reasonable amount of additional distance between the center line of each company's transmission lines would alleviate this concern. It would also allow for slight adjustments on either side of Evergy's line if needed in the future, that would have a limited impact on landowners when Evergy eventually has to rebuild its 161 kV line. The Evergy will direct the presentation of its case over the next few days at these two issues. We support the project being approved for routing either as proposed by NextEra or along a modified route as long as it does not involve the double circuit option. One final comment before I close, as NextEra's council indicated, staff has recommended the commission establish the routing principles and weighting factors that could be used in potential future routing model studies. And Evergy doesn't oppose the commission doing something like that, but we agree that it should be done in a generic docket where everyone with an interest has an opportunity to participate. And it's not a citing docket like this where participation is limited and we're under such a condensed schedule already. So I'll close and thank you for the opportunity to participate in the proceeding and provide input.
Thank you. We will next move to IBEW. Brian Wood, if you please.
Thank you, Chair Duffy, and good morning to all again. My name is Brian Wood. I'm here to represent IBEW Local 304. IBEW Local 304 moved to intervene in this matter and was granted leave to do so by the commission on April 13th. Part of the basis for that motion was that the union's interests are intertwined with those of Evergy, which were just very well stated by counsel for Evergy. And they're intertwined via the relationship through collective bargaining agreements between Evergy and IBEW Local 304, including one specific to the Wolf Creek nuclear facility. Our interests are to see that those bargaining agreement provisions are respected and followed, whichever option may be approved, and however Evergy's participation and cooperation may be required as a result of that order. And to the extent that the project does require involvement of Evergy, it's very important to note that the boots on the ground performing that work will be those of the hardworking men and women of IBEW 304. And I would encourage the commission not to lose sight of those folks who would be doing the cooperative work and the rights that they have via the collective bargaining agreements. That's all I have. Thank you.
And thank you, Mr. Wood. KCC staff, and that would be Mr. Lateef.
Thank you, Chair Duffy. Good morning, commissioners. My name is Hassan Lateef, and I, along with my co-counsel, represent commission staff in this proceeding. And as you have already heard, we are here to discuss NextEra's application for a line siding permit. Commission staff has conducted an independent review of NextEra's application, including submitting discovery requests to the applicants as well as the interveners, and filing direct and rebuttal testimony in this docket. Staff also participated in both public hearings on this application and met with landowners and interested parties prior to and after the public hearings on the days they were held. Staff conducted field research, attempting to follow part of the path where the proposed transmission line would be built. And additionally, staff has reviewed all of the oral and written public comments made in this docket and filed a response to several general issues raised by the public. In staff's testimony, KCC's chief engineer, Leo Hanios, evaluated NextEra's application and generally found the route proposed to be reasonable. However, Mr. Hanios's findings came with a number of critiques of the application and included recommendations that staff proposes the commission consider in its evaluation of whether or not to grant a line siding permit to NextEra. In this opening statement, I will discuss staff's findings and recommendations, beginning with NextEra's compliance with the applicable line siding statutes, staff's concerns about the proposed transmission line, and their recommendations for alleviating those concerns. So I begin with staff's evaluation of NextEra's compliance with Kansas statutes. KSA 66 1,178 and 1,180 describe the commission's standard for reviewing line siding application. The statute states two bases for reviewing the application. The commission shall make its decision with respect first to the necessity and for the reasonableness of the location of the proposed electric line, taking into consideration the benefit to both consumers in Kansas, consumers outside of the state, and economic development benefits in Kansas. Additionally, the commission is tasked with protecting the rights of all interested parties and those of the general public. The necessity of this line has been determined and approved in the commission's order in 22 NETE 419 COC. In that docket, the commission issued NextEra a certificate of convenience and necessity for the purposes of operating a public utility in Kansas, with the express goal of building this transmission line that is being considered in this docket. Staff, as well as the applicant, have filed testimony in this docket stating that NextEra's application already complies with the statutory requirement of necessity. Specifically, NextEra's witness, Becky Walding, in her role as Executive Director of Development for NextEra, testified to the necessity and benefits of the transmission line. And some of those benefits included, or some of those necessity reasons and benefits included that the current electricity infrastructure in Southeast Kansas has diminished capacity to support bulk power transfers to the east, including lines that have among the highest outage rates for their voltage class. The transmission line is the subject of this docket would divert bulk power transfers to relieve that congestion and transport power east to major load centers. The current system routinely experiences high system flows during times of elevated wind power output from Western Kansas, but installation of this line would relieve that stress and the stress that additional generation imposes. Also, the installation of this line would provide further stability for the Wolf Creek nuclear plant by adding a fourth 345 kilovolt outlet. This would relieve congestion locally and allow for more available transfer capacity to local long-term transmission customers. And there are quantifiable benefits to customers from the project, including additional choices in transmission service throughout the area that is being constructed. The commission acknowledged the necessity of the line in the 22419 docket as well, stating in its order approving the company's application that, quote, when the benefits of the transmission project are considered, ratepayers should see a net reduction of $1.48 or $3.36 for every dollar spent over the 40-year life of the transmission project, unquote. Ultimately, the commission agreed that Kansas will benefit from the transmission project by reducing overall electricity rates, increasing local tax revenue, and increasing system reliability. Given the evidence of the line's necessity, as determined in the 22419 docket and as testified to in pre-filed testimony in this docket, what is left for the commission is to decide the reasonableness of the location of the proposed electric line. And to that end, staff has identified several issues for the commission to consider. The first issue is the proposal for NextEra and Evergy to construct a portion of the line as a double circuit that runs along Evergy's existing 161 kilovolt transmission line. In the commission's order in 22419, NextEra was directed to consider the double circuit option for a 25-mile portion of the project. Staff's support of the double circuit option was based on a number of factors, and that included, first, the staff's understanding at that time that Evergy planned to rebuild its existing line within the next few years, thus creating an opportunity for both lines to be constructed simultaneously. Subsequently, staff has learned that Evergy is not set to rebuild that line in the near future. Second, staff's continued belief that running two lines as a double circuit for the 25-mile portion that they are parallel to one another would minimize the impact on landowners and the environment. And third, staff's support for the double circuit option was matched by public commenters who spoke at the public hearing and filed comments in this docket. Staff, in reviewing NextEra and Evergy's testimony, believe the companies have provided an objective and critical evaluation of the double circuit option in compliance with the commission's order in 22419. NextEra and Evergy identified several problematic issues with the double circuit option, which I will briefly summarize those issues. They included that a double circuit portion of the line would require the commission to work with the parties on establishing appropriate construction standards, as the companies currently have divergent construction preferences. For example, Evergy builds its lines using steel poles, and NextEra uses and won the bid in this contract through the use of concrete poles. Determining what type of poles would be used on the double circuit line operated by both companies, as well as the effect that determination would have on NextEra's ability to fulfill its bid as it was proposed, are difficult issues to overcome. Additionally, the companies outlined many unknowns for how two utilities operating a shared line would coexist. For example, which company bears the responsibility for correcting outages or damaged lines? Would the Southwest Power Pool require a double circuit line to be rebid? And how would Kansas law treat two utilities sharing the same right-of-way? And finally, the double circuit option in each of the three alternative versions that were proposed by the utilities would result in increased costs. In the least costly estimate, the increase would be at least 12% rise in costs over the estimated bid price. These increases, which would benefit landowners along the line, would also be borne by all ratepayers within the Southwest Power Pool. It is worth noting by staff that the SPP bid process was focused on overall project cost and the cost to all SPP ratepayers, and that appears to have ranked very highly in the analysis of the bids. And staff notes that what did not rank highly was the value of the impact on landowners. And this was not lost this fact was not lost on public commenters who noted that SPP, NextEra, and Evergy's cost estimates did not consider the cost of landowners in potentially devaluating the property or the cost of farming operations that would need to be revised by working around 2 sets of poles through their farmland. And it's noted that there are not good studies or empirical evidence on what those effects would be. Nonetheless, staff, based on their review, concluded that the cost and complexity of the double circuit line operated by 2 utilities make it an unreasonable alternative. Although the double circuit option appears to be unworkable, staff requests the commission approve a route that minimizes to the extent possible the amount of land between the 2 parallel lines. The proposed route would require in certain situations to create a buffer strip between the 2 lines that would, because of its placement between 2 transmission lines, render the land unusable to landowners. And staff requests the commission consider requiring a route for NextEra's transmission line that would directly abut Evergy's line, unless the landowner prefers there be a buffer space for some reason that's between the 2 lines. This would prevent the 2 lines from creating a buffer strip that is unusable by the landowner, but for which they would receive no compensation or consideration. The second issue involves the determination of the reasonableness of the proposed route pursuant to KSA 66(1)180. NextEra employed engineering firm Burns and McDonnell to develop the routing study that was used to establish the proposed route. The route selection process the firm developed was based on 11 routing principles, ranging from minimizing the length of the transmission line to maintaining as much distance as practical from residential areas, among several other considerations. Public commenters raised concerns that NextEra potentially asserted bias or gamed the routing study in assigning values that, in their eyes, minimized capital cost. Public commenters argued that social factors should be given a higher consideration than engineering costs because the general public will live and work in close proximity to the line. Staff, in evaluating the constellation of factors considered and their various weights, testified that it did not have evidence that NextEra asserted bias in the way that it weighted the different criteria, but noted that it is the commission's obligation in the end to balance the interests of all parties. Staff notes in particular that KSA 66(1)180 does not specify a weighting criteria. The only criteria explicitly addressed in the statute is to consider the benefits to both consumers in Kansas and consumers outside the state and economic development benefits in Kansas. Those considerations are not statutorily assigned weights for use in the determination of the potential route. So in the end, staff advises the commission that it can consider the route proposed by NextEra and rely on the weights assigned, or if it wishes to adjust those principles to ones that it more highly ranks that are championed by a couple of public commenters, it can adjust those weights. The only statutory criteria for evaluating the route is for staff and the commission to determine its reasonableness. As stated before, staff finds the route as proposed to be reasonable, subject to the concerns and recommendations that follow. Several speakers at the public hearing and at the as well as public comments and some of the testimony expressed concerns about the dangers of electric and magnetic fields. In some of the cases, comments referred to staff's testimony about the dangers of EMF exposure. We'd like to reiterate that staff has expressed that there are no conclusive tests or studies that link EMF exposure directly to adverse health effects such as leukemia. Staff acknowledges that inconclusive health risk is not the same thing as non-existent health risk. That is why staff recommended that the commission require NextEra to measure the EMF emissions at the edge of the right-of-way in very specific situations. And those situations are when a home is within 200 feet of the right-of-way after the line is operational in order to establish a reference point. Should future studies determine EMF exposure at the measured levels is a concern, solutions to mitigate the effects can be determined at that time. Due through the discovery in this docket, we have determined there's a limited number of homes which would be within that range. So this is not a major requirement to put upon NextEra, but it is one that we think is helpful in the cases where there's a transmission line that's within 200 feet of the line of a home. Public commenters and intervener testimony in this document also raised concerns about the proposed transmission line being constructed in close proximity to homes. Commenters recommended that the commission consider requiring the line be at least 200 to, in some cases, 3,250 feet from a residence. As staff has testified in this matter, neither the commission nor the Kansas statutes establish a minimum setback distance for transmission lines with respect to homes or businesses. In urban areas, there are 345 kilovolt transmission facilities within as close to 80 feet of a residence. In staff's review of rural areas, it found no routes that were closer than 150 feet. Ms. McGee-Smart in her testimony references a previous docket 10 ITCE 557 MIS, where a utility agreed to modify the route around a specific home because the cost was minimal. This was one of several options presented to the commission in that docket, and the commission in the end selected a route that moved the line a distance of 1,970 feet from the home, not 3,250 feet as the homeowner requested. In this case, NextEra and several landowners have proposed alternative routes for the commission to consider, as well as taking the line further from individual residences and farm buildings. While each route has a different effect on each party, staff does not find it practical to set a one-size-fits-all rule for how close a transmission line can be constructed to a residence. While setback requirements would help alleviate the issue of building transmission lines near residences, it also would increase the cost of building transmission and may prove especially difficult to site a line in a more urban setting. So where economically feasible, staff recommends the commission proposed routes that take the line further from residences. NextEra has been negotiating with landowners to adjust routes through a process known as micrositing. Staff in our discovery for this proceeding requested information on a list of landowners it believed would have residences within 150 feet of the transmission line, and NextEra provided that information as well as alternative routes they have been discussing with landowners in its DR 42. Staff recommends that the commission, in approving the line siting permit, approves the path that incorporates the alternative routes proposed in DR 42. This will give landowners a benefit in knowing that even in the worst case scenario, the route would give them more room to their residents than the originally proposed route. Staff also testified that line siting statutes charge the commission with protecting the general public, and accordingly, staff made several recommendations regarding the commission's authority to mandate certain types of equipment and construction practices. And that includes, as discussed already, the use of standalone structures. Evergy and NextEra have different construction standards for how they approach transmission lines. NextEra intends primarily to use guidelines that support their angled structures and dead end structures. And I just want to show a picture of the guidelines. So as you can see, we have a picture of a guy line. We have a picture of a line, transmission pole, and the guy line, and showing the additional room that is taken up by having guy lines included as part of the line. As you can see, the pole is supported by wiring that extends from the top of the pole down to the ground, taking up more space on the ground than just the pole. Staff testified that using guy lines in this fashion may create hazards for farm equipment, pose a risk of damage to transmission facilities, and require additional right-of-way to accommodate the structures. So this is another example of a guy line and the amount of space it can take up in addition to the pole. The use of guy lines makes farming difficult and maintenance of the vegetation growing around the guy lines to be precarious in certain cases. Additionally, livestock that graze near such guidelines would be inclined to rub or scratch against the guy lines in a manner that may be detrimental to the livestock or the transmission line. Staff recommended that unless the landowner agrees to accept guide or guide angle or guide dead end structures, the commission should consider requiring the use of base-plated steel poles that do not require such guidelines. I have another picture here of an aerial view that shows the impact of the guidelines and how far they extend from the pole. We've heard from the NextEra and from testimony from Dan Myers that there are a very small number of poles that will be using guidelines, and that for that reason, NextEra believes that is not a major issue for farmland and farm owners. But we believe that because there is such a small amount in their case, and what they're claiming that that use guidelines, that it should not be a major requirement for those poles to be changed to these single poles, they're standalone poles. Additionally, staff has testified that the proposed route will cross 5 arterial highways for the region. And although the highways in the area are generally smaller than in some of the state's large metropolitan areas, these roadways carry the majority of traffic traveling through southeastern Kansas, with a number of large vehicles passing through. NextEra's proposal did not include the use of dead-end structures to support the span of the transmission line across highways. The picture I'm showing has an example of one with dead-end structures. These on the line by the pole that look like springs are the dead-end structures. And so we're asking for these to be installed on the crossings across highways in that area. In this testimony, Mr. Haino stated that dead-end structures prevent cascading tower failures that could lead to a conductor draping across a highway. Unless dead-end structures are used, the nearest dead-end structures to US Route 54 crossing are 11,000 feet away, or 12 spans to the northwest, or 45 spans to the southeast. For the crossing on US Route 69, the dead-end structures appear to be 25 spans to the west, or 6 spans to the east of the highway. Staff noted that NextEra has already agreed to install dead-end structures in instances where it would cross existing Evergy lines. Staff requests that NextEra be required by the commission to extend the same courtesy to the general public, making use of the busy highways their lines will come across.
This is clear.
Mr. Latif, are you?
No, I have just to give you a thing. Sorry, I was switching off the share.
Okay, thank you.
During the public hearing of the transmission line, we heard from landowners who noted that a large part of living with the lines is dealing with construction and maintenance on the lines by the company. Utilities enter into their property and landowners are not always happy with the intrusion. Thus, to ensure vigilance of NextEra when entering into landowners' property, staff recommends that the company file its permit and reclamation plans with the commission when they are completed. Although NextEra has stated that it plans to restore the affected land and as already required, staff maintains that the commission should include language ordering NextEra to make its best effort to restore conditions to those that existed prior to construction, viewing this as part of the commission's obligations under statute to protect the rights of all interested parties and the general public. In that role, the commission should make a strong effort to require NextEra document its labor to comply with the restoration requirements. Staff notes that the legal sophistication in the relationship between the company and landowners is disparate, and landowners may not realize the need to document all the items that should be addressed when considering land restoration. Requiring the plans to be filed in the docket would create a record of the compliance and would protect both the landowner and the company. Finally, reimbursement to affected counties. Staff recommended the commission require NextEra reimburse affected counties for any costs necessary to perform pre and post construction inspections of roads and bridges that may be affected by the construction project. NextEra has responded by stating it already plans to reimburse affected counties. Staff maintains that including language regarding reimbursement creates a backstop that ensures that standards are met after a line siting permit is granted. And our last recommendation was regarding future policy recommendations. While staff does not recommend changes to the NextEra routing methodology in this present matter, as it finds it to be reasonable, staff does recommend that the commission consider a future discussion of a routing model study similar to the one presented in this matter for future transmission line siting dockets. This would allow the commission to establish routing principles and weighting factors, which can be used for potential future modeling studies. To that end, staff also recommends the commission coordinate with Southwest Power Pool to allow states the opportunity to participate in developing routing parameters for inclusion in a request for proposal for future transmission lines. In conclusion, with regard to the commission's statutory responsibility in reviewing line siting permit applications, staff is satisfied with the application contained substantial and insufficient information to permit an in-depth review of the reasonableness of the proposed location of the electric line and an inquiry into the necessity of the project. Staff is also satisfied that the written testimony in this docket contains sufficient competent evidence in which to support the commission finding that the proposed project is necessary and the proposed location of the route is reasonable. Therefore, staff recommends the commission approve the application for the line siting permit contingent upon the recommendations of staff as we have outlined them. Thank you, commissioners, for your time.
Thank you, Mr. Lateef. It's just about 10:30. We're due for a break. What I'd like to do is have all parties go to a breakout room with Mr. Kimmel so that you can discuss these stipulations that he has proposed. Michelle, can you make that happen? And the court reporter does not need to be there. Okay, Michelle? Okay, so there will be a breakout room for folks, and we will take 15 minutes. So we will come back on the record at 10:45. Thank you.
And so, okay, now I'm on.
Okay, folks, it is 10:45. And we're going back on the record. Mr. Kimmel, do you want to share about your discussion, please?
I provided a proposal, proposed stipulations to the other parties. I have not.
Pardon,
Provided
you're
in
breaking up. Could you repeat that? You're breaking up.
I provided the parties with written
Okay.
stipulations via email. And I have not heard back from them as to whether or not they object to those stipulations.
Okay, all right, thank you. We'll check back in later. All right, moving on. We're going to start with our witnesses. Our first witness is Jacqueline Blakely from NextEra. Denise, you will be swearing in the witnesses today. Thank you.
Okay, please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Okay. I'm getting some feedback here. All right, it's good. All right, we'll begin with the commission. Oh, I'm sorry. NextEra?
Yes, thank you, Chair
Is that
Duffy.
you? Yes.
Yes, yes, if we could introduce the witness and then send her
Please.
for cross-examination.
Yes, please. I would appreciate that. Thank
Good morning, Ms. Blakely. Please state your name and your business address.
My name is Jacqueline Blakely, and my business address is 700 Universe Boulevard, Juno Beach, Florida, 33408.
And by whom are you employed and what is your title?
I'm employed by NextEra Energy Transmission LLC, and my title is the Executive Director of Asset Execution.
Are you the same Jacqueline Blakely who filed in this proceeding direct testimony on January 24th, 2023, rebuttal testimony on March 21st, 2023, and response to public comment testimony on March 28th, 2023?
Yes, I am.
Do you have any additions or corrections to make to that testimony at this time?
No, I do not.
And if I asked you the same questions again today as appearing in those testimonies, would your answers remain the same?
Yes, they would.
Thank you. I move the commission to enter all of Ms. Blakely's testimony into the record, as well as exhibits JB-1 and JB-2.
Any objections?
The McGee's
Hearing-
object.
Pardon?
The McGee's object. I'm sorry, I apologize. I thought he referenced a separate exhibit.
So you're not objecting, is that correct, Mr. Kimmel?
I object to some of Ms. Blakely's testimony on the fact that they have failed to establish the foundation for the expert testimony that she provides in that testimony, in particular testimony regarding farming.
Sorry. I didn't catch the last
Mr.
word.
Schulte, would you respond, please?
I didn't catch the last word. Testimony regarding.
I said the line on farming.
I'm not sure which testimony in particular is being referred to, but I would note that Mr. Kimmel has an opportunity to cross-examine Ms. Blakely and ask about the basis for those findings, and the commission can give them the weight that they're due. I'm sorry, not findings, but testimony, and give them the weight that they're due.
Commissioner, what I would respond with is that the McGee's do not have the obligation to lay the foundation for expert testimony. The party that's submitting the testimony has the obligation to lay that foundation. And they have not done, and NextEra has not provided that foundation for Ms. Blakely's testimony regarding the impacts of the line on farming.
Mr. Schulte, would you respond to that, please?
Could Mr. Kimmel identify with some precision which testimony he's referring to?
Could you be more specific, Mr. Kimmel?
Ms. Blakely provided testimony stating that the project would not have a significant impact on farming operations. NextEra has failed. That knowledge about farming is scientific or technical information that's not generally known by the public. And Ms. Blakely has not provided, or NextEra has not provided the adequate foundation to establish Ms. Blakely as an expert to testify on those issues. Simply asking them to establish the foundation as a proponent of the testimony.
Again, it would help to have
Schulte?
a specific testimony reference, but I can still respond by stating that Ms. Blakely is presented as a company witness with experience on transmission development, and that statement is provided in that context. I don't think we're presenting her as a farming expert and have not, and then that's not required in order to make that statement.
If she's not, if Ms. Blakely is not going to be opining regarding the impact on the lines on farming operations, that's fine. I would ask the commission simply to strike that portion of her testimony.
We still don't have a page number or a testimony reference.
Mr. Kimmel, can you be more specific, please?
Ms. Blakely provided testimony regarding the impact of the line on farming operations, in particular, farming around structures in the row crop fields. So Ms. Blakely, if she's going to provide this opinion, I would ask that NextEra lay the foundation for that testimony.
Okay. Commissioners, let's go to a breakout room, please. At this time, and we are off the record. Whoops. No, I don't have a breakout room. Okay, we're back on the record. Are all parties present? Yes, they are. Mr. Kimmel, we're going to deny the objection. I'm denying the objection. And during your cross-examination, you can, I think that's the opportunity for you to raise whatever issues you have. With that, Mr. Schulte, will you continue on with tendering your witness, please?
Yes, just to confirm, Chair Duffy, was my motion to enter all of Ms. Blakely's testimony into the record, as well as exhibits JB-1 and JB-2 approved?
Yes. So,
Thank you.
okay.
And then I have a couple other questions for Ms. Blakely before I turn her over for commissioner questions.
Please go ahead.
Ms. Blakely, are you adopting the testimony of any other witness?
Yes, I am adopting the direct testimony filed by Becky
I'm going to
Walden.
object.
Mr. Kimmel, what's your objection?
It's inappropriate for Ms. Blakely to adopt any other witness's testimony. The parties have the commission has an obligation to give the parties an opportunity to cross-examine a witness. That witness is apparently not available in this case, or excuse me, not available. She's not appearing today in this case, but NextEra has not provided any indication that that witness is unavailable to provide testimony. There's been no subpoenas issued in this case for her appearance.
So
They could have done. Sorry.
go ahead. Is that
NextEra could have brought the witness to the hearing, but failed to do so. As such, my client is prohibited from cross-examining the witness. It's simply inappropriate for NextEra to attempt to adopt the testimony of someone who they have not identified or provided evidence is unavailable. It'd be the equivalent of having a deposition, and instead of bringing the witness to trial to cross-examine that witness, simply submitting the deposition testimony without demonstrating unavailability or the ability to cross-examine the witness.
I could continue my.
Mr. Schulte, will you respond?
I would actually like to continue my questions so that I could lay the foundation before I move to submit the testimony, at which point an objection would be allowed. But at this point, I have not so moved.
Okay. Yes, you were interrupted. So go ahead and continue, please.
Ms. Blakely, have you reviewed the direct testimony and exhibits of Ms. Walden, and are you familiar with their contents?
Yes, I am.
And do they fall within the scope of your job responsibilities and obligations?
Yes, they do.
And if I asked you the same questions today that appear in Ms. Walden's testimony, would your answers remain the same?
Yes, they would.
Do you have any corrections to Ms. Walden's testimony?
Yes, with one correction. At page 17, lines 3 through 4, the total number of parcels should be 260 rather than 270. And the total number of landowners should be 172 rather than 200.
Thank you. And just to confirm, with that correction, you would answer the questions the same as those reflected in Ms. Walden's direct testimony?
Yes.
Thank you. At this point, I move the commission to enter Ms. Walden's direct testimony into the record, as well as exhibits BW1 through BW7. And I would like to clarify that Ms. Walden is available, Ms. Blakely is available for cross-examination on all of the topics covered by Ms. Walden's direct testimony.
Thank you, Mr. Schulte. Okay, Mr. Kimmel, I'm supposing you want to register your objection at this point. Is that correct?
I do, Commissioner.
Okay.
NextEra has, in addition to the unavailability issue associated with Ms. Walding's purported testimony, to suggest that Ms. Blakely would answer the questions exactly the way Ms. Walding answered it is simply absurd. Furthermore, it'd be inappropriate for the commission to admit into evidence statements made in Ms. Walding's testimony, first because she's failed to lay the foundation for exhibits BW2 through BW6, as those are not NextEra documents. And furthermore, Becky Walding's testimony references and summarizes the commission's prior order and the certificate of convenience and necessity, and thus simply instead of providing that document, and simply violates the best evidence rule. Thank you.
Thank you, Mr. Kimmel. I'm going to overrule your objection and admit Ms. Blakely and evidence as described by Mr. Schulte. All right. Any other objections? Hearing none, let's move on to commissioners. And we're going to lead off with Commissioner Keene, please.
Chair Duffy, did you wish to have the witness sworn?
I believe she was sworn in already. Yes, she was.
My apologies. Okay.
We're doing it right as we identify them, so we don't forget.
Okay.
But thank you, Commissioner Keene.
I'm back in the boat. Thank you. Good morning, Ms. Blakely. Your microphone's off.
Good morning, Commissioner Keene. Can you
Yes,
hear me
indeed.
okay now? Okay.
I can hear you well. Thank you very much. I do have several questions for you. I think the first question is your title. I think Mr. Schulte had indicated, or you indicated your title was Executive Director, Asset Execution. I'm thinking that I had read somewhere along the way that your present title actually is Executive Director, Development. Which of those is correct?
Of asset execution. So I am part of the development organization for NextEra Energy Transmission.
Okay, very good. Thank you for that. For the record, let me ask you this. As of today, has NextEra commenced construction in any respect with respect to the Wolf Creek to Blackberry line?
No, it has not.
All right, thank you very much. I think my next question was procedural, and I believe through the introduction and approval of your testimony, the introduction certainly by Mr. Schulte, it's been covered. But I think, as I understand it now, with respect to Ms. Walding's testimony, you are familiar with and can answer questions about the various exhibits that accompany and are attached to her testimony. Is that correct?
Yes, sir.
Okay. And I take it because of the tenor generally of your own direct pre-filed testimony, you are prepared to answer as well questions about the double circuit option.
That is correct.
Okay, very good. I want to focus on three of the exhibits to Ms. Walding, her direct pre-filed testimony. And let's begin first with exhibit BW3. If you could take a look at that. Screen share is not required here. If you could just find it. Okay, what in essence this is, as I see it, this is the SPP request for proposal, or the so-called RFP for the Wolf Creek to Blackberry line. Is that correct?
Yes, it is.
Okay. Are you familiar with this RFP?
I am.
What in essence, for the benefit of those who may be listening in, is the purpose of this RFP?
So the purpose from SPP in managing the grid, they had identified a need for a competitive project to help balance the congestion in its territories. And so it solicited those, excuse me, those bids in which NextEra Energy Transmission submitted a bid into that request for proposal.
So basically, if I'm understanding you, this is what this is in essence, if I could kind of rephrase what I understood you to say. The RFP is sort of the process by which the bidding on a proposed line that the SPP would like to see constructed commences. Is that essentially correct?
That is correct.
Okay. I want to now call upon your knowledge of the contents of this a bit. I cannot find within this RFP any reference to the fact that roughly 25 miles of the proposed line would be parallel to an existing 161 kV line. Is that correct?
That is correct.
There is no such reference, right?
That is correct.
Okay. My observation would be that such an acknowledgement could permit bidders submitting their RFP for the Wolf Creek to Blackberry line to, among other factors, note and consider the potential consequences that parallel lines could pose for the utility construction and operation, and for affected landowners and others having uses or interests in the affected lands. Is that a fair statement in your judgment?
It would seem so, yes.
Okay. I also don't see within the request for proposal any reference to a cooperative state regulatory involvement that was elicited in the RFP review process. Is this also correct?
Not to my knowledge that I see here, no.
That there is no such effort to elicit state regulatory involvement within the RSP. That's what you're answering correctly?
As far as requirement, no, sir. Yeah, I do not see that.
Okay. What I'm concerned about here is that this RFP process, by lacking formal, direct state regulatory involvement, may fail to elicit and take into consideration important input regarding state, landowner, and local concerns, and tend to limit its consideration strictly to the traditional cost and technical considerations customarily reviewed by the Southwest Power Pool. In effect, what I'm concerned about is that it may give the appearance that the state, local, and landowner interests are of secondary consideration. Before we leave the exhibit BW-3, I want us to look at one of the recommendations being made by Mr. Leo Hanos, who is the KCC chief engineer. And what we need to do is turn to Mr. Hanos's direct pre-filed testimony. Michelle, I don't know, were you able to extract from that testimony page 29? We can screen share.
I believe I have that. I will pull it up for you.
If you would, please.
Is that what you were wanting, Commissioner King? With the map?
No, it's not, no, it's of Leo's testimony. It's page 29. It's his list of recommendations.
Shall I edit it to the file share?
What's the name of that one?
It's labeled Leo, page 29, I think.
I'm not seeing anything called Leo, page 29. I have staff R&R, staff exhibit list, Evergy response, public version attachments.
Back out of all the folders.
Okay,
I can do it if need be.
I got it.
What I think I could do to maybe expedite the process along, if we can't screen share, that's fine. I will just pull, I'll just read into the record now his recommendation number 3. Let's see.
I've got it.
You do have it. Scan
Yes.
down just a little bit so we can put recommendation number 3 in the middle of the screen. That would be lines 18 through 20. That's fine, Michelle, right there. Ms. Blakely, can you see that?
I can, and I have it here as well with me.
Okay, very well. I wanted to focus on recommendation number 3. And I'm going to read that into the record for the benefit of the record here. Beginning on line 18, number 3, I recommend the commission consider approaching SPP to allow states the opportunity to participate in developing routing parameters to include in a request for proposal any future competitively bid transmission lines, period. Those are lines 18 through 20 on page 29 of Mr. Haynes's pre-filed direct testimony. Dated February 21st, 2023. My question, Ms. Blakely, to you is this. Do you agree or concur with this recommendation?
I have no disagreement with it. I do believe that although this is part of SPP's process, that as far as the current RFP and the way NextEra responded to it, we are still working with the states and our local communities as we developed the bid that we did respond with. So I do believe that that process has occurred ultimately to make sure that we had feedback regarding how the transmission line has been routed so far. But in this case, I see this as speaking to involvement prior to a request for proposal being submitted. So that would be different.
That's right. And it has to do with a recommendation that would have prospective effect, correct?
It would, yes.
Yes. All right. If you would, Michelle, thank you for your help. You may remove the screen share. All right. Ms. Blakely, I want to turn next to Exhibit BW4. Again, this is another of Ms. Walding's exhibits. And in essence, I believe this is the final public report of the Southwest Power Pool's industry expert panel regarding this. This is designated as RFP-00003. And this is for the Wolf Creek to Blackberry 345 kV line dated October 12, 2021. Have I correctly identified this report?
Yes, you have.
All right. Is it safe to say that this report is very exhaustive in the subject matter it considers in its 195 pages, in your opinion?
It is.
All right. Again, for perspective, this is a major report in the process of selecting a preferred utility to construct a transmission line, in the sense that the recommendation to the SPP Board of Directors by this industry expert panel is a major precondition to the final award of the SPP notice to construct. Is that correct, in your opinion?
It is.
All right. And in this instance, the industry expert panel recommendation to the SPP board was to accept or approve the NextEra RFP for the Wolf Creek to Blackberry line. Isn't that correct?
That is correct.
All right. As noted in this exhibit BW4, which is attached to Ms. Walding's testimony, as I see it, there are several criteria that are identified for scoring and ultimately determining the industry expert panel's recommended winning RFP proposal. Would you agree with that?
I do.
And now to my main question about this exhibit BW-4. As I review this lengthy report, even with all of the redactions in the public version, I cannot find within the report of the SPP industry expert panel any references acknowledging that roughly 25 miles of the proposed Wolf Creek to Blackberry line would be parallel to an existing high voltage transmission line. Am I correct in reaching that conclusion?
Yes, you are.
My concern in this regard is that, in my view, this factor and its potential impact on affected landowners, I believe, should be a factor considered by the industry expert panel prior to its making a recommendation to the SPP board. And the question I would ask to you, and I'm not trying to lead you down any garden path here. I'm really interested in just straight answers to my questions. I appreciate the fact that that's obviously where you're headed. Isn't the potential impact of two parallel lines on their property a significant factor for landowners with respect to their subsequent ongoing uses of land, regardless of who ultimately wins the bid for the Wolf Creek to Blackberry line?
So what I would offer there, Commissioner Keene, first off, I would say when SPP evaluates a bid, they are not dictating the route. So they wouldn't know some of those details, nor would the bid necessarily have all those details yet, because there needs to be that routing study performed. They dictate the endpoints. What I would say generally, and we have other witnesses that can expound on this further, around the industry practice of paralleling right-of-ways with other transmission lines, that generally speaking, that tends to be an incremental impact, having parallel sets of poles as opposed to routing further from existing infrastructure and further fragmenting the landscape and creating really more of an impact to landowners than abutting right-of-ways. So as I said, that was a consideration as NextEra put their line routing options together as a general practice. That is considered when routing lines, is to look at just an incremental impact as opposed to further fragmenting the landscape.
Thank you very much. I appreciate the granularity of that response very much. I think that's very instructive. Thank you.
Thank you.
Commissioner Keene, do you have further questions of the witness?
I have a lot of further questions for the witness.
Good. All right, proceed. I'm sorry.
Am I not going quickly enough?
No, I'm sure you were gathering your thoughts. That's fine.
I am. This is a fairly complicated undertaking here, and I'm trying to do justice to the questions and give the witness an opportunity to answer as well.
Thank you.
Again, in looking at the industry expert panel report. Nowhere in that report do I find any references or criteria or standards that evidence that the industry expert panel has worked or coordinated with or encouraged the working or coordinating with the relevant state utility regulator, in this case, the KCC, to determine whether there are any unique, complicating, or important state or local considerations that should be evaluated in advance of the industry expert panel recommendation to the SPP board. Is that a fair statement?
It is.
What I'm thinking is that these would be the kind of factors that may be beyond, again, the traditional cost to construct criteria considered by the industry expert panel. In addition, again, within this industry expert panel report, I do not see any economic analysis within the report that indicates any extensive consideration of the economic impact that this line will have on landowners and others having interest in the lands covered by the route of the line. Am I correct in that conclusion as well?
It is not part of the rating criteria that I see here now.
That's fair. Thank you. All right, and with respect to Ms. Walding's exhibits, let's turn next to exhibit BW-6, please. Ms. Blakely, if I'm correct, this is an economic impact analysis of the Wolf Creek to Blackberry transmission line project. Is that correct?
That's correct.
Was this analysis either commissioned or performed at the behest of NextEra and conducted by the Strategic Economic Research LLC?
Yes, NextEra did hire Strategic Economic Research to conduct this study.
Okay. And what was the purpose of conducting this economic analysis?
It was to identify the economic impacts associated with the project.
Okay. Let me ask you to maybe provide a little more granularity with respect to that. What was the intended scope of that economic analysis?
The scope was to take what NextEra had provided in terms of its bid cost, as well as expected job creation, and have this independent study be able to confirm the impacts to Kansas specifically.
Okay, thank you. For purposes of summary, let's take a look at the table of contents for this analysis, which appears on it's identified as Exhibit BW-6, page 4 of 37. Tell me when you're there.
I am there.
Okay, very good. In terms of the consideration of economic impacts within the scope of this study, I'm looking under Roman numeral 5, which indicates from pages basically 16 through 21 or on the economic impact results. And as I look at that, I see that it addresses transmission line impacts, correct?
Correct.
It addresses substation upgrade impacts, correct?
Correct.
And it addresses the combined transmission line and substation impact upgrade impacts as well. Isn't that correct?
That is correct.
My question is this: where within this economic analysis is there an analysis of the economic impacts to affected landowners and others having a vested interest in the lands affected by the proposed route?
What I can't say is whether that specific information was included in this study by
Okay.
this, by this entity, by Dr. Loomis.
Well, there's a lot of demographic information about the counties that are affected here.
That's correct.
I couldn't find within the body of the analysis any analytical consideration of the economic impacts to the affected landowners and others having vested interests in the lands.
Yes, I do not see that written, correct.
And it may be that it was beyond the scope of the economic analysis that you were requesting. I'm guessing.
And I will say, I don't have personal knowledge as to whether or not that was actually provided as part of the scope or not.
Very, very, very fair. I appreciate that response as well. Let's now consider the double circuit or the co-location issue with respect to this proposed Wolf Creek to Blackberry transmission line. I want to acknowledge at the outset that I realize that NextEra and Evergy and their advisors, as well as the KCC staff, have all recommended that under the facts and circumstances of this docket, the commission should consider the double circuit option to be an unreasonable alternative. Nevertheless, before I begin my cross-examination on this double circuit issue, I think it's important to put into perspective the significance of the landowner interests and concerns in the Wolf Creek to Blackberry line and the significance of considering double circuiting as an option. Generally, my concern in this docket and the companion CCN docket is that there appears to be an absence of adequate SPP consideration of important state and local interests and concerns. And I believe that the excerpt from Mr. Haynes's testimony and his recommendations evidence that in part. I'll reserve that for him, and I'll ask questions of him about that when his time for cross-examination comes. More specifically, in conjunction with the SPP request for proposal process that initiated the competitive bidding for this project, I'm concerned about the absence of adequate SPP communication and coordination with the state utility regulator, in this instance, the KCC, to permit the state to assist in providing input, assuring a more thorough consideration of important state and local effects and consequences associated with this proposed transmission line. Importantly, the SPP transmission line consideration and approval process does not appear to formally and routinely elicit state input from state regulators on local issues. In this instance, primarily including line routing. In this instance, if the Wolf Creek to Blackberry line is sited as presently proposed, there will be two parallel large transmission lines on lands covering 25 miles, or roughly 1/4 of the proposed route. Affected landowners will then be required to cope and live with this circumstance forever. In my opinion, the SPP transmission line evaluation process did not adequately take this factor into consideration from the perspective of the affected landowners. At the behest of the commission, the consideration and evaluation of the double circuit option was undertaken by NextEra and Evergy as a means of exploring whether this alternative could potentially mitigate important and consequential adverse effects on landowners. As I have noted, that effort concluded that in this instance, double circuiting was not advisable. However, with respect to the prospect of having two large parallel electric transmission lines crossing lands on 25 miles of the proposed Wolf Creek to Blackberry route. Major questions and concerns remain. Namely, what alternative steps could have been taken by the SPP or could now be taken to avoid the adverse effects to landowners associated with the prospect of having two large parallel transmission lines on some portion of the affected lands. In sum, I am concerned about the thoroughness and the adequacy of the SPP transmission line approval and vetting process, and the extent to which these processes adequately consider state and local concerns before granting the SPP notice to construct. On the one hand, we have an SPP notice to construct process for a large transmission line that profoundly affects many important state and local stakeholder interests, prominently including the directly affected landowners. Yet, on the other hand, serious consideration and evaluation of many of the important effects and consequences to these stakeholders and landowners have been deferred until the last major step in the regulatory approval process. That is, in my opinion, this line siting and approval process that is now before the KCC. Unfortunately, in my opinion, a more thorough consideration of these important state and local issues and concerns was not undertaken at a stage prior to the SPP grant of the notice to construct, and was only undertaken prior to the initiation of this line siting proceeding, largely at the behest of the commission. To be sure, the benefits of the Wolf Creek to Blackberry line were addressed, I think, in great detail in the CCN docket. And I approve that docket. However, of all the costs associated with this proposed transmission line, I'm concerned that many aspects of the long-term effects and consequences and costs to affected landowners have thus far not been fully or adequately considered or evaluated. I appreciate your indulgence, Ms. Blakely, on your time as a witness here to allow me to make that statement. I did that by way of overview because what I want to ask you now is, for the record and for the benefit of those who again may be listening into this hearing on YouTube, what is meant in a nutshell in your experience by co-locating or double circuiting with regard to electric transmission lines?
The definition would be allowing two different conductors on the same set of poles. Rather than having single circuit and single circuit separately, they would be together on one pole.
I think it's very, pardon me, I think that's very articulate. Thank you. My understanding is NextEra is one of the largest, if not the largest, electric utilities in the United States. And I'm thinking that you construct and operate transmission lines throughout the continental United States, do you not?
We do, yes, over 11,000 miles of transmission.
Thank you for that. So in this regard, does NextEra utilize double circuiting in any areas of its operations within the United States?
I presume there are, but not necessarily in the circumstance in which we're describing here, which is double. We're not aware of any as well in Kansas or other places, but double circuiting between two different utilities.
I appreciate the granularity of that question, but actually what I was really asking, you went beyond actually the scope of my question. I'm really asking with respect to your own operations, do you double circuit?
Yes, you can double circuit, and we do, yes.
Okay. What are the advantages of double circuiting?
So there would be advantages rather than, and depending on the circumstance, rather than having the two sets of poles that you already identified, you only have those one set of poles and one route.
Okay. At the time NextEra submitted its bid for the Wolf Creek to Blackberry line, was NextEra aware of the fact that if you won the bid, the proposed Wolf Creek to Blackberry line could be constructed parallel to an existing Evergy 161 kV line for roughly 25 miles of the 94-mile scope of the route?
Yes, that was one of the options that was considered in the line routing process.
Okay. And so in that regard, I guess you're saying, yeah, I don't want to anticipate your answer. I'll ask the question. Did you anticipate that this could create complexities in line siting, construction, and or operating the Wolf Creek to Blackberry line?
Honestly, what was considered, and kind of back to something I'd said earlier, is generally speaking, and Mr. Worth can also provide more detail around work practices around general routing, but putting similar structures like that and abutting the right of ways generally is preferred in some cases. And it also, again, is an incremental impact to the land rather than routing further away and creating a further fragmented landscape. So putting those similar structures together is generally a good practice.
All right, thank you for that. So I guess one other aspect of this I'm looking for is, were these factors anticipated and included within the total amount of your bid?
Could you clarify what exactly?
Yes, the factors I'm talking about would be the fact that there may be complications associated with having a line running parallel to an existing 161 kV line for 25 miles. Was that complication built into the amount of your bid?
I don't believe we viewed there to be complications with paralleling the existing Evergy line as far as part of the bid.
Okay, I'm probably not using the right adjective. Did you take into consideration the fact that you would quite probably have a line of your own construction parallel to an existing line operated by a different utility, and any costs associated with that, were they built into the bid?
I don't know that there were any identified incremental costs associated with that. The cost is built upon the construction of that line. So, okay. and where it was proposed to be routed.
Okay, I'm going to move on. I appreciate your answer. I think you've answered as best you can. So now, for the record, with regard to the line siting matter before the commission in this docket, if you would, please summarize why NextEra opposes utilizing double circuiting in conjunction with Evergy and their existing 161 kV line.
Thank you, Commissioner King. Yes, so we respect and recognize the commission's concern about encumbrance of the land. And so as we analyze the time frame in which if we were to co-locate, could be done based upon Evergy's uncertainty around when they would be able to rebuild their 161 kV line, it essentially places two sets of poles regardless for 5 years or more there. So the schedule uncertainties, as well as we work together with Evergy on a combined and collaborative design criteria, that design criteria for the double circuiting poles increased the cost from and ultimately did not result in what we were expecting to save any costs there associated with the project. So due to those additional costs, the delays in the original project service date, but also having those poles in place for 5 years or more, and then the complexity as we talked about along the way of two utilities sharing those poles and all of the really precedents that we do not have about sharing right-of-ways associated with that really led to our recommendation of not considering the co-location.
Thank you very much for that answer. I appreciate your indulgence on the question. I'm trying to just get this on the record for the benefit of those who are listening in and don't have access really in any real-time way to the written record that's developed here. I appreciate your response very much. In the double circuit analysis in this case that Evergy conducted together with NextEra, did you analyze or consider the impact upon or various costs that could be incurred or borne by landowners or others involved with the affected lands as a result of either utilizing or not utilizing the double circuit approach?
We discussed costs potentially associated with easements and obtaining shared easements. If
Okay.
you're speaking of land, if you're speaking of farmland impacts, costs to landowners, I just want to clarify the.
I'm speaking with respect to any cost that may be associated with landowners, regardless of the ultimate uses of those lands that are affected by the route of the line. Either the implications that may accrue to the value of that property, or the economic uses of that property that may be affected by having these lines on those lands. That's basically my question. Did you take those matters into consideration?
Not specifically. The way that we address, generally speaking, impacts to landowners is in how we approach our easements with those landowners and how we ensure that, depending upon the acreage that is impacted, that we address that through ensuring that we pay at or above market value for an outright purchase of that land, while the landowner still has the ability to farm in that same space within clearance requirements, of course, of the National Electric Safety Code. But that's generally how we manage the entire route, not just this route, where easements are involved.
Okay, thank you. I'm about done. My cross-examination of you is pretty much down to a couple of questions right now. Let's move away from double circuit. Let's talk about something else. Along the proposed route of the Wolf Creek to Blackberry line, do you know how many oil and gas leases are affected by the proposed route?
I don't know that I have that at my fingertips. If we need to determine that, we can certainly get that for you.
I would appreciate it if you could find out that information for me. You can either offer it yourself in some way. I'll leave this pretty much up to Mr. Schulte, or perhaps Mr. Mayor or some of the other witnesses to follow you for NextEra. If they could volunteer that information, I would appreciate that. If you could get that information. The related question I have for you, and I may ask from another NextEra witness as well, is, in your opinion, are oil and gas leases a significant alternative land use that involves important economic considerations that should be evaluated for route siting purposes?
I would have to say it depends on, really how much impact and there is to the routing of that specific line and whether they are relevant to the routing process. I know that that's part of what we consider as we are routing a line, is to avoid those types of structures. Those one of many, but that is one of the areas that we attempt to mitigate.
Well, the reason for that question is because oil and gas leases, by their nature, are these are long-term contractual arrangements for the uses of the land. They involve a complex series of legal rights and obligations that in most instances are going to be pre-existing to the construction and operation of your line. These oil and gas leases contain express and implied covenants. And one of the implied covenants is the implied covenant to develop. And that could potentially be very constrained, especially along the route of the 25 miles that may be parallel to an existing 161 kV line, especially depending upon how much separation there is between these two rights of way. That could have a major effect on some pre-existing contractual rights and these implied covenants to develop, and in fact try to basically explore for and produce oil and gas. That was the reason for my question. So I may reserve that for another witness too. Ms. Blakely, I want to thank you very sincerely for your indulgence of my questions. I appreciate very much your answers. This concludes all of the questions I have, Chair Duffy, for Ms. Blakely. Thank you.
Thank you, Commissioner Keene. I'll move now to Commissioner French. Questions of the witness.
You know, I'd mostly like to reserve until after the other parties have cross-examined, but I think I do have a few general questions, if I could be allowed. I will try to be brief because I share many of Commissioner Keene's concerns about landowner impact issues and how those may or may not have been considered in this process. But I think what I want to get at is, I suppose you are at least somewhat familiar with SPP's competitive bidding process and the industry expert panel that they employ, since those are attached as exhibits to Ms. Walding's testimony, correct?
Correct.
I guess the first thing I would ask, and I believe this was your all's position, was that NextEra would not have been allowed to propose a double circuit option under the bidding rules because you could not submit that you were using another utilities right of way. Is that correct?
That is correct.
Okay. And the paralleling of the line, I think you said was not necessarily at the SPP RFP proposal. That was the outcome of your routing study. Is that correct?
That is correct.
Okay. Those were just a couple general ground rules. As we turn to the issue of impact on local landowners, impact on the local area, I guess what I'm struggling with is whether that is a disagreement. Let's just assume, for argument's sake, as a hypothetical, that I do not believe those issues were adequately addressed in the competitive bidding process. I think the question I'm trying to get at is whether that is a disagreement with the metrics that are used in the competitive bidding process. I see in the report, those metrics are, pull it up, engineering, design, project management, operations, rate analysis, and finance, or whether it would be a disagreement with the way that the independent expert panel analyzed those items. So the question I guess I have for you is impact on the land and local landowners. Do you, within your experience, can you tell me whether you think those items can be considered adequately by the independent expert panel given the metrics that they are given? Or do you think the metrics confine them in a way that those can't be adequately encapsulated or valued in a bid?
I would offer that in this case, it's complicated. And I would say, because when we think about the competitive transmission portion, it is a regionally allocated cost among, so when SPP puts out the RFP, they intend on taking that cost and distributing it among its participants in its region. Whereas the incumbent utility existing line in this case is zonally allocated to the Kansas Central Zone. So I think it would be difficult in a bid process like this to be able to recommend or that be an option to explore, particularly in this scenario where those two, the way those two costs would be distributed would also be in some way unfair to either one, in one circumstance or the other, where when Evergy goes to rebuild their line, is that cost going to then need to be distributed among SPP's customers, all of SPP's grid customers? And so I don't know how necessarily it could be considered. I'm sure there are opportunities for that, but in this case, I think it would not have been appropriate because of the complexities that we have, particularly with the cost sharing.
Okay, I think you actually jumped to my next question. Let me go back real quick. I was speaking maybe more toward burden on local landowners and diminution of property values, use of the land by having two separate parallel lines versus sort of maybe a difficult to quantify value of only having one right of way. Do you think that sort of value judgment can be taken into consideration under the metrics that are laid out in SPP's attachment Y, the competitive bidding process?
I think it can be supplied, right of way impact, acreage, along with the length of the line. It certainly can be provided by bidders in their proposed route.
And there is flexibility for the independent expert panel to consider that?
I cannot say as far as the process, SPP's process.
Okay.
Currently. Yeah.
Well, you can only tell me what you can or can't offer an opinion on. And then I did want to jump to the other issue, that you raised. And I think my question, I think you answered it, but let me just rephrase my question. My question would have been, is there an opportunity in that competitive bidding process or enough flexibility for that panel to consider creative solutions or perhaps more overall optimal financial solutions that perhaps meet multiple needs, beyond the initial line? So for instance, if they had, do they have the flexibility to consider something like a double circuit option, even though that was obviously went beyond the scope of what their RFP was? I think your answer was that you think that would be inappropriate and probably too complex from a financial standpoint because you're cost allocating two different types of lines. But I guess I'd just like an opinion on whether they have the flexibility to consider whether that's a more optimal financial solution.
Yes, so my original comment was based upon when bidding and it being part of the criteria to wait. However, SPP has indicated from our conversations with them as part of this co-location evaluation that they would technically evaluate the co-location. And there were comments made regarding that based upon how the original project was bid, that it would potentially be a scope change to how we bid the project. And so they would have to restudy all of the technical components of the project once double circuited and give us an outcome, which could take within their regular cycle sometime in late 2024. So they can study those options, but in this case, it certainly there would be a lot to consider.
Okay. I've got, I have other thoughts, but I think perhaps they are more appropriate for other witnesses and perhaps maybe even if we enter a session to talk about confidential information. So I'm gonna hold the rest of my questions for now. But thank you so much for the answers.
Thank you, Commissioner French.
Thank you, Commissioner French. Yes, Ms. Blakely, if I could. This line that we're talking about from of Evergy's, does it, are you aware, does it come from the nuclear facility? Is that its start point?
I do not believe so, but I don't have the specifics at hand, but we can certainly get the description of the line.
Okay. Also, do you participate in your company's RFPs and other entities similar to SPP like MISO and PJM?
Yes, my team is consulted as part of developing RFPs.
In your work with those other entities, are you aware if the commissions in the affected states are part of the process in terms of evaluating a line from the onset instead of our process where we are not included?
Yeah, I'm not aware if they are.
You don't know.
I do not know.
Okay. In your deliberative process, as you responded to the RFP, did your company go back to SPP and question any aspects of the paralleling or simultaneous use of a pole?
Not to my knowledge, no.
Okay, all right. I will hold my questions till the end as well. So I am looking at the time. It is noon, but I do believe Mr. McGee or Mr. Kimmel, I'm assuming you have a line of questioning for the witness, correct?
I do, Chairman.
Yeah, and will it be extensive?
Perhaps.
Perhaps.
Not.
Okay, we'll start with you and then we may take a break for lunch after that. Okay, so Mr. Kimmel, if you will address the witness, please.
Yes. Good afternoon, Ms. Blakely. We've met a couple times in the past, have we not?
That's correct.
I'd like to ask you a couple of questions regarding your rebuttal testimony. And in particular, the map that is presented on page 5 of that rebuttal testimony.
We are pulling it up now. Yes, I'm there on the map.
The figure on page 5, it's not labeled by any figure number. However, there's only one figure on that page. It is also illustrated apparently on as exhibit JB2. Is that correct?
That is correct.
And exhibit JB2 illustrates a distinction between NextEra's proposed route, NextEra's alternative route, and McGee Smart's proposed route for the electric transmission line, correct?
That is correct.
And NextEra's proposed route essentially parallels the McGee's route. Let me back up. Are you familiar with where the McGee's live in this case?
Yes, it's not noted on this map.
And where could you describe where you're?
Let's see, give me Yeah. It shows where the, yeah, right there. Do you want me to identify the county within
want you to
Anderson County?
I would like for you to identify her home.
Okay, so if you see where
Perhaps
the,
we could just, I apologize for interrupting you, Miss Blakely. Could you show your screen and show what you're looking at, please?
I can show.
can you see my mouse?
Yes.
Okay, that, yes, right there. Yes, that is the home. Can you see the arrow?
And directly to the west of the McGee's home are the two proposed routes, one of which was proposed by the McGee's and one of which is proposed by NextEra, correct?
That is correct.
And you, in your direct testimony, you indicated that NextEra's proposed route is going to cost NextEra approximately $75,000 to adjust the location of its proposed line, correct?
To the incremental cost from the blue line that you see to the red line was approximately 75,000.
And is it fair, Ms. Blakely, to state that NextEra has placed the contingency of its alternative route in this case to the McGee's allowing NextEra to come onto their property?
I'm sorry, what was your question?
Is it fair to say that NextEra, though, has proposed an alternative route for the McGee's, it is indicated that construction of that route is an agreement to construct that alternative route is contingent upon McGee's first providing access to their property?
Yes, so we have been working to work on an access agreement so that we can verify conceptually what we have provided here with the red line.
I will refer to you, Ms. Blakely, to page 7 of your rebuttal testimony, starting at line 22, leading over to line 8. You state, and tell me if this is incorrect, depending on the results of the field surveys, impacts avoidance, minimization, and permitting strategy, additional environmental costs, and compensatory mitigation costs, the project schedule also needed to be evaluated, and an additional agency coordination may be necessary due to the additional impacts. You go on to say field assessment is necessary. Do you see that?
I do.
When NextEra proposed the route that comes so close to their house, NextEra didn't come onto their property to conduct that field analysis, did they?
In the original proposed route?
That's correct.
The blue line. No, that's correct.
There was no need for NextEra to come onto the McGee's property to make a determination of what NextEra believes was the appropriate proposed route initially, correct?
So the blue proposed route was conceptual as well. And there are places along the route where if we were concerned about environmental issues, wetlands impacts, critical habitat, et cetera, part of the process after developing the conceptual route is to ensure if there are any concerns along the way, that we are able to analyze those on the ground.
And you can conduct the same analysis on the proposed that you conducted on your originally proposed route from the desktop, correct?
Well, what you have here is, oh, I'm sorry. Finish your question.
Your testimony is your original proposed route designation was a desktop analysis, correct?
Correct. And what you have here as well, the red alternate route is a desktop conceptual where the next step would be to go and verify whether there are any potential impacts or incremental impacts as stated in my testimony there.
So you could have done the very same analysis for the alternative route that you did for the initial route, correct?
We developed a desktop conceptual alternative here where we have been working to gain access to verify that it is appropriate.
So NextEra's proposal to the commission and the movement of the line significantly west of the McGee's property is not dependent upon actual field analysis, correct?
I'm sorry, could you repeat the question? Your audio was coming in and out for me.
I apologize, Ms. Blakely. I have a poor internet connection today for some reason. I'm trying to wrap my head around the reason why you're demanding access to the McGee's property and making your agreement to move the line contingent upon obtaining access across the McGee's property. When NextEra originally identified a line without going on the McGee's property. Could you explain that?
My first comment would be, I would not characterize how we've been attempting to work with the McGee's through you, Mr. Kimmel, as demanding access. We have met several times and had meaningful conversations about the concerns that the McGee's have, and have been willing to offer, as we noted here conceptually, an alternative to where the original line was routed, which was over 760 feet away from the home, the original blue line that you see there, and tried to work with the McGee's to be able to offer an alternative. So it was actually expected of us, even though we've offered everything to escorting us so that we can look and see are there wetlands impacts, that we were required to have an access agreement in order to do so.
Your originally proposed route was not contingent upon access to the McGee's property, was it?
Not contingent on, no.
Right. On line 10 of page 8 of your, starting on line 9 of page 8 of your rebuttal testimony, you say, thus, NETE Southwest's ability to implement its proposed alternative is contingent upon confirming that there's no environmental constraints, geotechnical constraints.
I'm sorry, what line? I was on page 8. Is that what you referenced?
Yes, starting on line 9, where it begins, the sentence begins with thus. Essentially, what you're saying is that the
Okay,
is
I'm sorry.
contingent upon maintaining access to the McGee's property, correct?
As mentioned here, what we want to make sure of is before we can confirm and agree to a route that wasn't part of our original study and analysis, that we don't have any constraints that otherwise would make this route unreasonable.
And you've testified previously, correct, that you conducted your proposed route without doing any of these tests that you're saying are necessary now to implement the alternative route, correct?
There are areas along the line that have and need to be and will be analyzed further as well that may require minor adjustments, which is part of the process. But here, when we looked at what has been proposed, there are some desktop concerns about whether there are wetlands in these areas. And we want to be sure that we aren't, we're being prudent about how we reroute the line.
And you've been, you do agree that that the McGee's have asked you for the criteria that you're going to use to evaluate that alternative line, correct? Are you aware of that? Are you aware of the information request that NextEra has submitted to?
Could you clarify exactly what you're referring to?
Are you aware of any information requests that NextEra has submitted, or excuse me, that McGee's has submitted to NextEra?
I am aware that we have transmitted various forms of the routing files that were requested back and forth, but I'm not exactly sure specifically what you're referring to.
Okay. I'm asking you, do you recall answering or NextEra answering any information requests submitted to NextEra by the McGee's in this docket?
I believe as part of the access agreement, is that in that process of us wanting to take the opportunity to come look and make sure that this alternative works? Is that what you're referring to, Mr. Kimmel?
Commission, I'd like to, I guess, you have access to my exhibits that I submitted prior to the beginning of this testimony, don't you, Ms. Blakely?
Yes, we do.
Will you please pull up exhibit number 21?
Okay. Okay, I have exhibit 21.
Will you please scroll to page 4 of that exhibit? Date's labeled McGee X-21_0004.
Okay, 210004. Yes. I'm there.
Is that your signature?
It is.
So you did that's this to the McGee's information request. This wasn't answered by someone else.
No, I just asked you, I wasn't sure what you were referring to, so I appreciate you pointing me to this.
If you scroll down to 0005 of McGee Exhibit 21.
Yes, I'm there.
The McGee's requested that you submit or provide a copy of the environmental impacts of the original proposed route to the McGee's. Do you see that?
Yes, I see that request.
So it indicates that, and is a fair summary that NextEra's response in this case is that it hadn't actually done any field analysis of environmental impacts on the McGee's property when it proposed the original route.
So this is what I was referring to earlier, the various electronic files and shape files that were transmitted. And as it says here, the shape files that we provided of the original proposed route indicate where we have sensitive areas and where we may have interpreted wetlands and other cultural resources. And so, as I mentioned, there will be continued evaluation of those areas as noted in those files.
Okay, I want to move on to another aspect of your testimony, Ms. Blakely. You adopted Becky Walding's testimony and the exhibits associated with testimony. I'd like you to pull up the final exhibit. Excuse me. The easement agreement, BW7.
Yes, I have that.
Please let me know when you have that pulled up.
I do have that.
BW7 is an option agreement that you're proposing to landowners, correct?
That is correct.
And I believe it was your earlier testimony in regard to Commissioner King that you indicated that you're providing compensation to the landowners for the value of the property impacted by the easements in this agreement, correct?
As part of, yes, our negotiations with landowners, correct.
You're agreeing to compensate the landowners for the impact of your easements on their property. Is that that was your testimony, correct?
That is correct.
And this easement agreement, are you familiar with this easement agreement, Ms. Blakely?
I am.
Have you negotiated these option agreements and transmission easement agreements with landowners?
So I do not negotiate with landowners directly. So we do have Ms. Powers as well, which is our land manager, that we have Doyle Land Services as our land agent that has had direct impact with landowners regarding their input around what is being offered from easement to easement. So all those could be different from parcel to parcel.
Well, you have approved through your adoption of Becky Walding's testimony this option and easement agreement, correct?
That is correct. This is the
And
standard.
it's your testimony that you're going to compensate the landowners for the impact of that easement on that landowner's property. Is that correct?
That is correct.
And the property that these easements impact are generally broadly defined by the parcel owned by the landowner, correct?
Are you wanting me to look at a specific point in the easement agreement?
I'm asking you this, you define, excuse me, if you want to look on exhibit VW7, page 2 of 10, paragraph A, you identify in and of itself an exhibit A, and you define that exhibit A as the property. Correct?
Correct. Certain tract of property.
Exhibit A is defined as the property, correct?
Correct.
And exhibit A is, in general, the legal description for the entire parcel of the landowner's property, correct?
Which would be included property to property specifically, yes.
It include the entire parcel, not just the parcel that easement, excuse me, that your transmission line, that 150-foot easement that your transmission line runs across, correct?
The legal description of the property, and then there is the easement area, which is exhibit B.
Exhibit A illustrates the entire parcel of the landowner's property. Just want to make sure that we're on the same page here.
That is correct. It is describing the tract of property.
And I ask you to scroll down to BW7, page 3 of 10, in which you define two types of easements. A transmission easement, do you see that in paragraph 2A?
And you are on page 3?
I believe it's 3 of 10. There are two sets of numbers.
Oh, I see. I'm sorry. Okay. I'm there now. I'm sorry. Repeat your question.
This easement agreement includes a couple different types of easements, doesn't it? A transmission easement.
Correct.
And an access easement.
That is correct.
And that access easement gives NextEra the right to go across the entire aspect or geographical scope of the property. Correct?
So it is defined here, and it depends upon where. So it says existing roads, maintaining those roads for the purpose of construction, removing and operating facilities. And so it's yes.
I'm going to interrupt you here for a second, just so we can hopefully speed this up a little bit. BW7, paragraph 2B.
Sorry, we need to allow the witness to complete her answer to the previous question.
My only other point to make about the access easement here was that it does grant the ability for vehicles or pedestrian ingress and egress over the property. And that could be from time to time. So depending upon what is needed related to roadways, etc.
The access easement is perpetual, correct?
Yes.
And the language of your proposed access easement provides that you get vehicular and pedestrian ingress and egress across and along the property, correct?
Well, part of this, again, is parcel to parcel and very unique to landowner negotiations and what's important. So this is an area in which this could be a part of the negotiation with the landowner of what constraints they have working around their farming operations, as is many other conditions in this easement. And so if I would just offer, if there are detailed questions around what specifically has been negotiated with landowners, that is confidential. But if there are some information related to some specifics that Ms. Powers could address as well, if you have questions there.
You adopted Ms. Walding's testimony. You indicated that this is a common easement agreement that is presented to landowners, correct?
That is correct.
Okay. And that easement agreement provides that the landowners giving this to NextEra across the entire property, correct?
The property as defined, correct, the parcel.
NextEra is only paying a property owner for that area of the property identified for the transmission easement, correct?
I'm going to object to this continued line of questioning because it's getting into issues regarding specific negotiations between landowners and NETE Southwest that are beyond the scope of this proceeding, which is about the necessity for the line and the reasonableness of the route, while the standard option agreement was provided as a point of reference and information. That does not necessarily open up this line of questioning which gets into specific landowner negotiations between NETE Southwest and landowners.
Mr. Kimmel, do you want to respond to that?
That's number one. There's not I don't see a legal objection to what Mr. Schulte just objected to. The access agreement is clearly relevant to the matters in this case. Otherwise, I don't know reason why it would have been incorporated into Ms. Walding's testimony. And I'm simply asking questions about that easement agreement because it plays part on one, the routing location, the location of the transmission lines, and it addresses Ms. Blakely as far as their NextEra's compensation of the landowners for the easements that they're obtaining. So my questioning addresses exactly Ms. Blakely's prior testimony in this case. It is relevant. And the easement agreement, if it is executed, is documented. It is simply not confidential.
Yeah.
My objection was not to confidentiality. It was to relevance to the issues in this case. And it wasn't, I'm not objecting to the information that's in the option agreement itself. I'm objecting to the specific questions that are getting into landowner negotiations.
Okay, so here's
Chairman,
the
I
deal.
haven't asked.
I am going to overrule the objection, but Mr. Kimmel, you need to move along a little bit more quickly. You have brought our attention to this. We're noting it, but let's move the questioning along, please.
It may be helpful as well.
Excuse me, Mr. Kimmel. Go ahead, Mr. Schulte.
Just to note, for the benefit of the parties, although the option agreement is included in the direct testimony of Becky Walding, which is adopted by Ms. Blakely, The option agreement is, developed and utilized by the company as a whole, by the team of people that are involved in this proceeding. And as Ms. Blakely indicated, a lot of these questions will be more appropriate for Sarah Powers. And so that may help move things along as well.
Thank you, Mr. Schulte. I hope you note that, Mr. Kimmel, and you may proceed, but please move it along. I think you have noted concerns and
I have one final question for Ms. Blakely.
thank you.
Ms. Blakely, how much are you offering to pay landowners for access to the across their property that does not include the transmission easement?
Object regarding the relevancy of individual negotiations with landowners.
Oh. All right, Mr. Kimmel, would you respond, please?
Sure. It's relevant because it addresses Ms. Blakely's prior testimony that says that that NextEra is compensating the landowners for the easements that they're obtaining. She testified previously that those easements valuations were based on the amount of land within the transmission easement area. I'm asking her what transmission is directly addresses the testimony she presented earlier. What is the that NextEra is going to pay or has offered to pay? Or I guess the better question would be, if they're offering to pay compensation for that access across the non-easement area of the property. Very relevant.
To be as general as I can, and then I would say defer.
We need a ruling on the objection.
I'm going to allow Mr. Kimmel to continue on and overrule the objection.
Then to be as general as I can, and I would defer probably into a confidential session if needed, or to Ms. Powers. But this is part of a landowner negotiation. So there are conditions and circumstances that are discussed in that negotiation that incorporate other factors than strictly acreage calculation of the transmission easement proper.
Under your easement agreement.
I thought that was your last question, Mr. Kimmel.
Well, a couple more came to my mind, Chairman.
Well, okay, why don't we try and wrap it up here so we can, I'm looking at breaking for lunch at 12:45.
Ms. Blakely, how is under your easement and access agreement, NextEra proposing to compensate landowners for damage to their property?
So I believe there are details provided associated with the industry standard on how croplands, whether it be during maintenance or during construction, are compensated. Those details are included and discussed with the landowners.
Your compensation is limited to simply cropland, correct?
I'm not sure as it relates to what exactly when you say just cropland.
You understand that this transmission line crosses not only cropland, but pasture land and hay meadow land, don't you?
Yes, correct. Beyond farmland, ranch land. Yes, there are other types of property, correct.
And my question to you is, how is the damage, how is NextEra proposing to compensate property owners for damage that it's going to do to land that's not cropland, in particular, pasture land and hay meadow land?
Yeah, there are specifics available that I believe would be best directed to Ms. Powers. She has those details. But if your question is, do we? Yes, we do. As I mentioned, pay for any crop damages associated with construction or maintenance of the line.
Mr. Kimmel, I don't know if you're frozen on your screen or,
Keep blinking.
I'll pass the witness, Commissioner.
okay, thank you, Mr. Kimmel. The time now is 12:40. We will break for a 30-minute lunch. That means we will resume at 1:10. I would appreciate if everybody would make sure your microphones are off, and we will reconvene at 1:10. Thank you. Okay, folks, we're coming right up on 1:10. We're going to resume our hearing. Miss Blakely, are you back? Denise is back. Good. Commissioner Keen. Okay, so it looks like folks are back. And Miss Blakely, just to remind you, you're still under oath. We will turn to Evergy for their examination of the witness. And Ms. Kafer, I do believe that's you.
Yes, it is.
All right, thank you.
Yeah.
Oh, wait,
Morning or good afternoon.
before we get started, folks, hold. We are considering, we know the court reporter will be gone at 5 o'clock. We are considering going an hour extra to 6 o'clock. The recording will then be transcribed at a later date. But that is what we're considering right now to make up for some of the lost time tomorrow. So thank you. I'm sorry, Ms. Kafer, if you want to continue.
Okay. Ms. Blakely, you're the primary witness for the co-location report that's submitted with NextEra's application, correct?
That's correct.
And that's your exhibit JB1.
Correct.
And you've already talked a little bit in your direct testimony on pages 4 and 5. You go over the considerations that the commission requested NextEra and Evergy to look at as they prepared that report. And I won't go through all those again. And but on page 5, then you talk about you summarize kind of the issues and the problems that you identified as a result of that report. So one of those problems that you identified was that doing the double circuit option would add 12 to up to 45 months delay to the in-service date on the project, correct?
That is correct.
And for each one of those 12-month periods, that's a loss of production cost savings of about $14.5 million.
That is correct.
Evergy had also indicated that the exact timing of their 161 kV line rebuild isn't known at this time, but they're looking at probably 2030, the end of 2030. That's correct, right?
That is my understanding, yes.
So even if NextEra were to build the double circuit structure, Evergy's line wouldn't be relocated on it until potentially the end of 2030. Is that how you understand it?
That is how I understand that.
And if that double circuit was built, if it was designed to what is Evergy's criteria for the construction, that's an overall cost increase of $10 to $22 million, right?
That is correct, depending on what right of way it would be constructed in.
And if it was designed to NextEra's criteria, then am I correct that was calculated as an estimated savings of $1.8 million as compared to you doing the project as a single line like you've proposed in the application?
As opposed to both projects being performed independently. Yes, correct.
Then it's a $1.8 million savings.
Correct.
And but the delay of just 12 months is a loss of $14.5 million. So that $1.8 million is quickly eaten up by any delay, correct?
Correct. And actually it would be an additional, besides 1 year, I believe it says here that the in-service date potentially would be first quarter of 2027. So that would be an additional year of delay, or almost 30 million.
It'd be even more than the 12 month. Okay.
Correct.
In your discussions with Evergy, did NextEra and Evergy ever reach agreement on a concrete pole design that met Evergy's design criteria?
It did not.
So on page 6 of your direct testimony, on line 12, you say NETE Southwest expects that any coordinated design criteria for concrete monopoles would increase the cost of this option significantly. So am I correct that the only option that might have a cost savings here would require Evergy to hang its line on a concrete pole structure that doesn't meet Evergy's criteria?
Based upon our discussions, that's correct.
And even with that, there'd be the delay that would cause us to lose the $1.8 million savings very quickly and a lot more than this, correct?
That is correct.
On page 6 of your testimony, then you go into describing the likely reevaluation process at the SPP, and that is going to cause additional delay and uncertainty. No matter what, that will cause additional delay and uncertainty, correct?
That is correct. From the original project schedule, yes.
In the collaboration with Evergy, did NextEra thoroughly vet all the potential complications and delays you might experience, like the project redesign delays, real estate acquisition delays, shared right-of-way complications, and the shared future operation and maintenance issues?
We did.
I'm on page 8 of your direct testimony, where you talk about your meetings with SPP and your coordination with them regarding the potential double circuit option. SPP advised you that they would have to approve an adjustment to the regulatory approval date of January 1st, 2023, if the double option was pursued, right?
That is correct.
And that what is it? Their SPP Oak Business Practice Manual 7060, it would require a technical reevaluation of the possible change in scope to the NTC, right?
That is correct.
And would that trigger a restudy of the project versus the original RFP?
So not necessarily. That technical restudy, the purpose of it is to determine whether or not the co-location would be a change in scope.
All right. In your opinion, is it your opinion that a change from a single circuit to a double circuit with another utility, as they're contemplating here on the double circuit option, with a different utility and a different design criteria, do you think, in your opinion, that would be a significant change?
I do.
And if it's a significant change in scope, then SPP would have to restudy the project in a special off-cycle study or in its next 2024 ITP evaluation, right?
If they agreed, yes.
The SPP process, all of that is under FERC jurisdiction, correct?
That is correct.
Do you believe that other non-winning bidders on this project would probably file complaints at FERC if the commission in Kansas were to order the double circuit option be pursued?
It's possible, yes.
Could they argue that they were aggrieved of the opportunity to propose an option with the double circuit with Evergy?
I'm sorry, what was your question?
Could the other non-winning bidders argue that they were denied the opportunity to propose an option of doing a double circuit with Evergy?
That is possible.
But do the SPP criteria not allow you to include any?
I'm sorry, we're having audio problems.
Sorry, Ms. Kafer, I didn't get that last question by Ms. Kafer.
I'll start.
Ms. Kafer, I think it's coming from your area.
It is, we're
He just joined us.
We off? Sorry about that. I think we got it.
All right.
Okay, so, but the SPP criteria, when you all were putting your bids together, it prohibits you from incorporating into that bid the use of another utility's existing easement, right?
That is correct.
So when everybody was putting their bids together, they were not allowed to include in their bid the potential of doing a double circuit with Evergy. Is that right?
That is correct.
And on the cost sharing and cost allocation issues, you already talked a little bit with Commissioner Keene about how the 345 project of NextEra is regionally funded and Evergy's 161 kV line is only funded. That you agree that's going to make it more difficult to allocate the cost of the combined line regionally versus zonally, correct?
I do, yes.
And that isn't something that Evergy and NextEra can agree on to resolve the issue, is it? That's something that would have to be taken and litigated at FERC.
That is correct.
If the double circuit line was constructed on Evergy's easement, existing easement, Evergy's existing easement would require a significant expansion, wouldn't it?
It would, to accommodate the 345 kV circuit, yes.
It'd have to go from the existing 75 to 100 foot width up to the 150, correct?
That is correct.
And if the double circuit was put on NextEra's new easement, it would still be 150 feet wide.
That is correct.
Right. So either way, whichever way we go, there's going to be a significant amount of new easement that has to be negotiated and acquired from landowners. Agreed?
Correct.
And if we built the double circuit on NextEra's new easement, would Evergy then have to abandon its existing easement that it negotiated with landowners and was operated under for 50 years?
Assuming so, yes.
Easement that Evergy's land customers have already paid for?
Correct.
I'm skipping over what you've already done with the commissioners, so if you just give me a second here. If NextEra, on the double circuit option, if you were to construct on Evergy's existing easement, expanded as necessary, would there be additional complications building adjacent to the existing 161 kV line, such as Evergy having to take that line out of service while you did your construction?
Yes, that's correct. Noted in my testimony and in the study report, the complications associated with constructing in a right of way where you have an existing line in operation.
Do you have any idea what the impacts would be to the system when that line had to be taken out of service?
I don't know how to quantify that. I just know that, you know, our criteria that we were to work within were the expected outage timeframes, work around those timeframes that Evergy would designate for us.
All right. Thank you, Ms. Blakely.
Thank you, Ms. Gaper.
Thank you, Ms. Kafer. We'll move to IBEW. Brian Wood, do you have questions of the witness?
Just briefly.
Thank you.
Proceed. Ms. Blakely, I'm wondering specifically with regard to the double circuit option on Evergy property. Was there any agreement or discussion regarding which party would be responsible for the labor to complete that cooperative effort, or how that would be allocated?
So the concept would be that NextEra would provide the labor. So we would be contracting who would build the line. And we do have the bid list associated with bidding not only to union but non-union labor associated with the entire construction of the project.
And your testimony is that applies to the work being done on Evergy property as well as work that would be done on non-Evergy property?
If we were co-locating, yes.
Thank you. That's all I have.
Thank you, Mr. Wood.
Thank you, Mr. Wood. We'll turn to staff. Mr. Latif, is that you?
It's going to be Phoenix doing it.
I will be
Oh,
handling
Phoenix.
Ms. Blakely for the staff commissioner. Can everybody see me? I can't see on here. Can everybody see me?
Yes, we can. Thank you.
Excellent. Ms. Blakely, we've never met, correct?
That is correct.
My name is Phoenix Anschutz, and I'm an attorney for commission staff, and I'm going to ask you a few questions today, okay? Some of these questions are going to require only yes or no answers. Some are going to require a little bit more elaboration on your part. Are you able to do that? I would assume so, given your, the previous testimony you've completed today, but I just want to make sure that you're up to that while I'm questioning you today.
Yes, I am.
Okay. Do you have staff's exhibit 1 available in front of you, Ms. Blakely?
We will pull it up. If you will give me just a minute.
And it should be, for convenience purposes, it should be the public version of NextEra's response to KCC DR42. And let me know when you get there. Oh, if you would, please.
We will. Okay, we are there.
Okay. Now, are you familiar with this document?
I am.
What is this document?
So it is a response to a request by KCC asking about certain homes or structures that were identified within 300 feet of our proposed center line of our route, and a request for us to provide whether any modifications could be made to each of these individual structures and distances identified, whether or not the modifications could be made, why or why not, and whether we've achieved an agreement with any of the landowners associated with these parcels.
Attached to Exhibit 1, we see attachment KCC 42, and that consists of various maps. Do you see that as well?
I do.
Now, how did you come to be familiar with the contents of staff's Exhibit 1?
So our internal team, along with our engineer of record, Burns and McDonald, reviewed each of the parcels that are involved with where these structures are and were located, and looked at where we were currently with the line and what potential shift could be made associated with each of the specific locations made for us to review.
Now, did you provide any of the information contained in staff's Exhibit 1?
Your question is whether I personally developed the information?
Yes, did you assist in the information that is contained in that exhibit?
Yes, in the summary of where we are with each of these properties, yes.
Yes, so this is not new to you, correct?
No, it is not.
Okay. Now, we see that if you go to the bottom of the actual responses, the one not containing the maps, we see that it's actually signed by Dusty Ward, correct?
That's correct.
But you are familiar with the contents of this exhibit.
I am.
And would you say you are familiar enough to co-sign the contents of this with Mr. Dusty Ward?
I am.
Commissioner, we would move for the admission of staff's exhibit 1 and the attachment there too.
Any objection? Hearing none, it's so ordered. Thank you.
Ms. Blakely, there are several homeowners and landowners involved here, and we see that that there are possible route modifications to the proposed line, correct?
That is correct.
Has NextEra worked with those homeowners to get to that modification contained in there, or at least specified in staff's exhibit 1?
In some of these locations, there were already some discussions, but I would like to point out, if we want to get into further detail, we may get into confidential conversations.
And it's my intention, Ms. Blakely, not to get into confidential communication such that that a breakout room will be necessary. I guess the purpose of my question was more along the lines of, is NextEra, have they been working with these landowners, and are they continuing to work with these landowners?
Yes, we are.
Now, if you look at the attachment that contains the maps on staff's exhibit 1, I think there's approximately 8 of them there. Let me get so there's 8 pages there. As staff, or as NextEra rather, have they worked with each of the landowners identified in this exhibit regarding these specific proposed modifications?
I believe, and I want to make sure yes, we have been in contact with all of the landowners. Yes.
But you have not reached a resolution with each one of the landowners, correct?
Not necessarily in every case.
Is NextEra committed to continue to working with these landowners regarding those modifications? I apologize, I didn't mention, I interrupted you there. So I'm going to re-ask that so you can answer in whole. Is NextEra committed to continuing to working with these landowners regarding their proposed modifications?
Yes, we are.
Just one moment, Commissioner, if you don't mind. Anything else? Commissioner, I don't believe we have any further questions for Ms. Blakely at this time. I would like to thank you, Ms. Blakely, for your time and answering our questions.
Thank you, Mr. Ancients.
Thank you, Phoenix. We'll turn to commissioners, and I will start with Commissioner Keene. Do you have some questions, please?
Actually, just one. I was listening carefully to the colloquy that you had, Ms. Blakely, with Ms. Kafer. And here's what struck me in one aspect of that. I'm going to be very direct. I don't mean to be offensive, but I'm going to be direct here. All of the cost considerations that you and Ms. Kafer discussed in your colloquy, in terms of building the lines or all the hypotheticals in conjunction with the double circuit option, and any delays in the construction and operation that may arise for any reason to the Wolf Creek to Blackberry line, these costs are largely costs to be borne by the utility and ultimately by the ratepayers, are they not? If they were to be incurred.
Correct.
Okay. Again, I think we have another set of interest holders that I'm concerned don't receive short shrift. So that's the reason for my question. We're in the process of considering costs. Do we give some recognition or consideration to the effects and costs to the landowners and others that are using or have interest in the affected lands?
Are you, is that I'm sorry, was that a question?
That was a question. It seems we have a balancing proposition here. This commission, we're involved. We're about the business of dealing with balancing propositions. We have the balancing proposition, I would propose in this instance, of certain costs for these reasons we just enumerated that could add to the costs of for the utilities and in turn be passed on to ratepayers. But I'm concerned about, in the course of considering that, how adequately are we balancing the costs and effects on the landowners? That's my concern.
Well, I would reiterate, I think, we address costs associated with landowner impacts within the right of way of the line, regardless of whether we're speaking of the co-location or other areas. And we currently, within the co-location area, have acquired approximately 55% of the easement options within the co-location area. And I would say, and Ms. Powers can also expound on this, but there are many landowners within that co-location section that are awaiting the results of and the outcome of the KCC's determination of the line and whether co-location is required or not. But to date, we've acquired approximately 43 out of the 77 parcels of option easements needed within the co-location section. So we have been working with landowners in that area. They are aware of the considerations, and we will continue to work with them through the process.
What sorts of landowner costs do you take into consideration?
Well, again, the costs associated with ensuring that we have recognized the right-of-way acreage that any landowner would be impacted by, and any croplands associated with that. So at or above market value through a negotiation with each individual landowner.
So this would be a basically one-time damage consideration. Is that essentially what you're saying?
So it is an outright.
I'm sorry, pardon my interruption. A liquidated damage consideration.
I'm not sure I would term it as that, but it is a purchase, an outright purchase of the land. Although it's an easement, we're paying for what that acreage would be on the market, but still the landowner has access to be able to farm, with the exception of where the pole locations or guide locations might be.
Okay, well, I appreciate the honesty of your answer and your frankness. Let's go back to the question I raised about oil and gas operations. I can't let you off the hook completely on that. To what extent can non-firming operations like oil and gas operations be conducted within what proximity to the line right-of-way can they be conducted? They can't be conducted on the right-of-way, I'm guessing. Maybe they can, but within what proximity to that can they be conducted, or are they denied access?
So our team did look and do some research during our break, and we may speak with Ms. Powers as well later, more specifically. But it was determined that while we do know of some leases, we're not quite sure of the status of those leases currently, whether they are active. And so those details we would have to look into. And Ms. Powers could address that.
That's fair enough. Do you understand the concern I'm expressing here?
I do.
It's a matter of access, and through access, the realization of the terms basically of the lease, which is a contractual relationship between the landowner and the operator, the oil and gas operator, in a dissimilar way, but in some ways analogous to the relationship that you, having a right of way, are going to have to the landowner also. Again, with different sets of rights and obligations to each party in each circumstances. So that was my nature of my concern. That's all the questions I have for Ms. Blakely at this time. Thank you again.
Thank you, Commissioner King.
Thank you, Commissioner Keen. I turn to Commissioner French for questions of this witness.
Just one quick clarifying question. Thank you. And Ms. Blakely, I'm only asking you this because I believe you're the witness that did the underlying calculations for the double circuit option. But if you need to refer me to another witness, that's fine. Did the calculation of costs for these options include any unrecovered amounts associated with an abandoned Evergy transmission line? So for instance, if they abandoned the 161 kV line to perform the double circuit option, did we assume that they would continue to recover any remaining revenue requirement associated with that abandoned line?
I do not believe so. No.
So the assumption, can you tell me whether the assumption is that that it's been fully amortized and there is no remaining unrecovered revenue requirement, or was the assumption that that would be written off as a loss?
That may be a better question for Evergy
to
define for you, Ms. French.
Okay, very good. That's all I had. Thank you.
Thank you, Commissioner French. So along that line, on the incremental cost to double circuit, the $10 million 12% increase, did that include Evergy's portion as well in putting their 161 with this? So that is the complete dollar amount if this comes together as a project, right? There's no separate amount for Evergy's portion. That is the total, understanding that how that's paid has to be discussed.
That is correct.
And we best ask Evergy if there's any unrealized expenses on their end. Okay.
That's correct.
All right. Thank you. That's all the questions I have. So now we will go to NextEra to redirect. Andrew.
Thank you, Chair Duffy. I just have a few brief redirect questions. Going back to the beginning of your live testimony, Ms. Blakely, Commissioner Keen and Commissioner French asked you some questions regarding the independent expert panel report that was issued by SPP. Do you recall?
I do
that line of questioning? Could you turn, and that independent expert panel report is identified as Exhibit BW4. Could you turn to Exhibit BW4 and page 18 of 195?
Mr. Schulte, could you repeat that page number?
Certainly, page 18 of 195. And there are two sets of page numbers. I'm looking at the one that's at the very bottom right-hand corner of the page.
Yes, I'm there.
And there's a table 7 on that page. Do you see that?
I do.
And at the top left-hand corner, it says section 2, project management. Do you see that?
I do.
Is project management one of the handful of high-level criteria that the IEP report reviewed?
It is.
And so the high level, is it your understanding then that the high level criteria is then broken down into sub criteria?
It is.
Okay, and is table 7 the sub criteria for project management?
It is.
And do you see that includes an environmental subcategory and a right of way acquisition subcategory?
It does, yes.
And then even within those sub criteria, there's sub criteria that include regulatory components in both of those areas. Okay, thank you. And then if I could staying within exhibit BW4, page 33 of 195. Let me know when you're there.
I will. Okay, I'm there.
Okay, and do you understand this? There's an environmental. Well, actually, looks at the top of the page. It says project management.
It does,
And
yes.
that's the high level category of criteria. And
Yes.
then there's an environmental section, which is one of the subcategories. Do you agree with that?
I do.
I'm just going to read the first sentence under that subcategory. All respondents indicated that they have retained or are planning to retain experienced contractors, consultants with firsthand knowledge and experience with the area expected to be traversed by the new line, as well as familiarity with the various regulatory permitting processes and agencies in Kansas and Missouri, which experience will assist in routing and environmental permitting. Did I read that accurately?
You did.
And so did NETE Southwest include a discussion of that permitting process in their bid?
Yes, we did.
And did that include consideration and evaluation of the KCC siting process and the standards imposed by the KCC?
Yes, it did.
Okay. Thank you. I'm finished with exhibit BW4, and I'm going to turn now to exhibit BW6 because there are also some questions about that. And Commissioner Keen asked you some questions about BW6, which is the Strategic Economic Research Report.
Correct.
And one of the questions, I'm going to paraphrase, so apologize if I don't state it exactly as Commissioner Keen did, but I think he asked whether the cost to the landowners or the impact on the landowners was considered as part of this study.
Correct.
That you recall that?
I do.
And so I'd like to turn to page 18 of 37. Let me know when you're there.
Yes, I'm there.
And there's a table 4.1 estimated total transmission construction costs. Do you see that?
I do.
And the grand total, it adds up to the 85.2 million, which is the estimate that everyone's familiar with.
Correct.
And part of that, one of those line items to get to that total is right of way.
Correct.
What does that budget category entail?
That category, as I mentioned, involves the easement options and payments to landowners associated with the right of way needed for the line.
And what was the estimate included for that line item?
9.5 million.
So that's 9.5 million in payments for easement agreements with landowners.
Correct.
So that was, would you agree that that number was considered one of the economic impacts in the report?
Yes, I would.
Okay. Okay. So I'm finished with the exhibits in Becky Walding's direct testimony. And I just have one more line of questions on redirect about the cross-examination by Mr. Kimmel regarding the McGee's proposed reroute. And it relates as well to the staff exhibit 1, which is the response to DR 42, which includes some other potential reroutes. And do you have staff exhibit 1 pulled up, or can you pull it up?
Yes, I have it.
I'm looking at the column labeled B, which states any explanation of why route modifications are not possible. And it looks like, scrolling through, there's a couple non-applicable, but otherwise, it looks like the statement under each is the same, that they're all subject to review for engineering, environmental, cultural, tribal, and right-of-way access. Is that accurate?
That is correct.
And is that the same type of review that would be is that the same contingency that the McGee's proposed reroute is subject to?
It is.
And might you need access to these landowners on staff exhibit 1? Would you potentially need access to their property to resolve that contingency?
Yes, we potentially would.
So is your treatment of the McGee's with regard to an access request, is that any different than how you treat other landowners?
No, it is not.
Okay. That is all my redirect. Thank you very much, Ms. Blakely.
Thank you. I'll turn back to commissioners. And again, I will begin with Commissioner Keen.
Thank you, Chair Duffy. Just one question, if I might, and it goes back to, we'll go back to the exhibit BW4 again, please, if you would. And turn to, it's page 33 of 195. The subheading I'm looking for is entitled Environmental. I'm looking at the very bottom, Ms. Blakely, to determine, it's page 30 of the document, or 33 of 135 of 195, EW4. Are you there? I don't think your mic is on. Are
Okay,
you there?
I'm there. Yes.
Okay, great. You'll recall that in his redirect, Mr. Schulte read essentially the first sentence of that paragraph into the record. Am I correct?
I believe that's correct.
Yes.
Mhm.
Beginning, all respondents indicated. Yes, he read that into the record.
Yes,
And
correct.
I think he was offering it. And again, don't mean to mischaracterize him any more than he wants to mischaracterize me. But I think he was intending here to indicate that that was some evidence of consideration this report was giving to regulatory input being provided. I think that's what it was. Anyway, I'm going to there's going to be the underlying assumption behind my question to you, because when I read that, yes, I see that there's an attempt to hire experienced contractors and consultants with firsthand knowledge having to do with permitting and regulatory processes in Kansas. I get that. But the real concern I had was that, and I think that this does not address it, is that this has nothing to do with this expert panel affirmatively addressing and eliciting input involving possible concerns and issues the KCC may have. I don't think that's a part of that. What I read into that sentence. Do you read that into that sentence? Do you read the eliciting and soliciting of input into that sentence?
It just states that the respondent is to be familiar with the regulatory process and follow it. So no, I do not.
But it doesn't call for in a direct way for eliciting those comments. Okay, I have no further questions. Once again, ma'am, I sincerely appreciate your indulgence in my questions. Thank you.
Thank you, Commissioner King. Thank you.
Okay, I believe that completes all our questions for this witness. Ms. Blakely, you may virtually step down. Thank you.
Thank you, Chair Duffy.
Next, we'll turn to our witness, Dusty Worth. Ms. Haas, if you will swear him in, I would appreciate it.
Commissioner, this is Rustin Kimmel. I'm sorry to interrupt, but before we start the new witness, the commissioner had asked me to submit stipulations to the parties at the beginning of this hearing. I haven't, and I've done that. I haven't received any response from the parties. That may be helpful as we move forward with the questioning if we entered into stipulations. So I was wondering if we could address that issue briefly.
So, Mr. Kimmel, what about on our next break? You meet with all parties and let's see what we have, but I would like to continue with our next witness, please.
We'll just need, just very briefly, we need to rearrange the witness so that the witness can be on camera, but that should not take long.
Okay, I'm not hearing that. So you're saying Mr. Worth is not available?
No, I'm sorry.
Oh, you're moving bodies around. I gotcha.
Moving bodies.
Okay.
around
Okay,
so that the
that's
camera
fine.
Pointed in the right direction.
As soon as he appears, Ms. Haas, if you'll swear him in, that would be wonderful.
Okay. Mr. Worth, if you could please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Okay,
Worth.
Mr. Schulte, if you will continue.
Thank you. Mr. Worth, could you please state your full name and business address?
Yes. It's, Dusty Worth, and my business address is 9450 Ward Parkway, Kansas City, Missouri, 64114.
And by whom are you employed and what is your title?
I am employed by Burns & McDonnell Engineering Company, and my title is Senior Environmental Science.
Are you the same Dusty Worth who filed or caused to be filed direct testimony on January 24th, 2023, rebuttal testimony on March 21st, 2023, response to public comment testimony on March 28th, 2023, and rebuttal testimony regarding public comment on April 7th, 2020?
Yes, I am.
Do you have any additions or corrections to make to your testimony at this time?
Yes, I have one correction. In Exhibit DW1, the routing study, there was a typographical error in the text of the routing study at page 3-8. Under the heading Residential Proximity Score, the second sentence, the number 101 should read 151. Accordingly, that sentence should read, to determine the residential proximity score, the number of residences within 150 feet of the center line was multiplied by 3. The number of residences between 151 and 300 feet was multiplied by 2, and the number of residences between 301 feet and 500 feet was multiplied by 1. Then all the results were added together.
Thank you. So could you confirm that that was just a typographical error, and before it was corrected, it appeared that residences within 101 feet to, I'm sorry, it would appear that, yes, residences between 101 and 151 would have been double counted, and that is not what occurred?
Yes, that's true.
Okay. Hopefully I got the numbers correct there. With that correction, if I asked you the same questions again today, would your answers remain the same?
Yes, it would.
Thank you. I move the commission to enter Mr. Worth's pre-filed testimony into the record, along with the attached exhibits DW1 through DW5.
Are there objections? Hearing none, it's so ordered.
Thank you, Mr. Worth. I have no further direct questions and will make the witness available for commissioner questions and cross-examination.
Very good. Commissioner Keen, I turn to you first to see if you have questions of this witness.
Thank you, Chair Duffy. Just 2 questions, if I might. Good afternoon, Mr. Worth. I think your microphone is off. Can you hear me?
Yes, sorry. Good afternoon.
That's fine. Great. Thank you. I can hear you now. Have you been listening in throughout the morning to this hearing?
I have.
Okay. My question is going to have a familiar ring to it then. This is an important study and environmental report. This is pretty much, I think, at the heart of what NextEra is advancing as the basis for the route they're proposing. It's quite a thorough report, to be sure. So my first question is this: where within this routing study and report is there an analysis of the economic impact on landowners and other users of the lands affected by the route of the proposed line?
Directly, there is no economic analysis done in the routing report. However, we do have certain criteria that were looked at that correlate to economic impact on landowners and on the general area. So some of those would be the amount of cropland within the study or within the right-of-way, the amount of forested land within the right-of-way. Those type of things. We're recognizing that there are potential impacts there, and those were measured in that way. And considered that way.
Okay. And where within the report could I find that?
I believe chapter 3 of the report goes into the analysis of the alternatives, the evaluation criteria and how those were factored in.
Okay, thank you for that. My second question for you is pretty open-ended. Obviously, there is a lot of adverse discussion. It's probably an understatement, actually, with respect to the double circuit option and a lot of objections to that as an option here. So my question to you, because you're the expert now on routing at this hearing, is there no other route that could avoid even raising the question of the double circuit option and fulfill the objectives of the and purposes behind the line?
I think hypothetically, yes, there could be a route that does not parallel any existing infrastructure that could be developed. However, I believe most, if not all, of the alternatives that we looked at did parallel existing transmission lines to some extent. And largely that is because these are large substations with multiple lines coming in and out of them. So as you get closer and closer to the substations, you almost have to parallel existing lines. So I think that option would potentially come up no matter what the route is.
What you're saying, it would just be a different line from the Evergy 161 kV line, but something analogous to that would still create a problem in terms of parallel lines, basically.
Correct.
Okay.
I believe all of the 729 some routes that we looked at had a substantial amount of paralleling existing lines.
Okay. With respect to this 25-mile I'm going to have, I'm sorry, with your indulgence too, Commissioner Day, I'm going to go a little bit beyond the two questions now, but I won't go far. So with respect to this 25-mile interval, is there any way that some of the egregious aspects, and that's my word, it's kind of loaded, I grant you that, but some of the really harmful, potentially harmful long-term effects that can happen to landowners by having two sets of these big poles running diagonally through their lawn, through their property. Is there any way with respect to this proposed Wolf Creek to Blackberry line that there could be, during that 25-mile interval at least, an exclusive use of public rights of way? Or if you will, and I'm not an engineer, so excuse the lay language that I use for this, some kind of stair-stepping procedure that can avoid the land interference that the line as presently cited might do.
I'm not exactly sure what you mean by exclusive use of public right-of-way. Are you meaning road right-of-way?
Yes, exactly. But for example, you in your knowledge and domain of engineering and the likes, you're going to have much more knowledge than I. But that's exactly what I'm thinking. If you were using other publicly available rights of way to avoid intrusion on private lands.
So that is one thing that we looked at as part of the study, is utilizing existing roadways and paralleling property lines. So that leads to more of the quote unquote stair step approach as opposed to the diagonaling or paralleling of the transmission line. That is somewhat of a feasible option. However, it does introduce additional issues. And part of what this study that we completed does is try and balance out all of the different criteria and impacts. So for instance, while paralleling the existing line would put another set of structures in fields potentially running diagonally through the field, stair stepping along to follow the property lines or field boundaries would introduce more heavy angles, which are larger structures, can potentially require guying, and also require more structures in the field potentially. Because if you take the hypotenuse of the triangle, the diagonal across the field, you could potentially only have one structure in that field for that. But then if you're trying to put angles to step around the edge of the field, you would end up with a minimum of 3 structures there for the 3 different angles.
And that's to accommodate the right angles, basically.
Correct. And also the other issue with utilizing field boundaries and especially roadways is you end up closer to homes more often because people like to put their home next to the road and on the edge of the property as opposed to out in the middle. So you end up with less flexibility to get around homes, and you typically pick up additional residences there.
Okay. It's a Rubik's Cube, isn't it?
It is.
Obviously, the shortest distance between 2 points is to pick point A, the point of beginning, and point B, the terminus. Put a straight edge down there, and there you have the line. But obviously, that encounters a whole lot of practicalities in real world application, does it not?
It does.
I think that's for the time being all the questions I have of you. I appreciate your indulgence of my questions, Mr. Worth.
Thank you.
Thank you, Commissioner Keen. Moving to Commissioner French.
I don't believe I have any questions for Mr. Worth at this time, but I'd reserve the opportunity after the party's questioning if something sparks. So thank you.
Of course. Just let me ask a brief one, if I could, Mr. Worth. So refresh me on right-of-way. The right-of-way of the line that NextEra proposes as a standalone 345 line. What is that again?
I believe the right-of-way width is 150 feet.
Yes. And if you co-located with the Evergy 161 line, what is the right-of-way there? What would the total right-of-way from including Evergy, what would that be?
I believe Evergy's right-of-way varies from, I believe, 75 feet to 100 feet.
So let's use 100 as the max.
So worst case scenario there, it would be 250 total, 100 for the Evergy line and 150 for NETE's line.
Okay, all right. And the issue of the co-location, from your perspective, I think you shared that the time frame. Well, Ms. Blakely shared that they had already received communication and my words escaping me, with 43% of the landowners, is that correct? On a co-location agreements with 43%?
I believe it's 55.
55, so 55% on the co-location. Okay. All right. And that is agreeing to the 250, approximately 250 feet of right-of-way?
I believe so.
Okay, all right, thank you. Why don't we turn next to Mr. Kimmel? Do you have questions for this witness? And you're on mute. Okay, there we go.
Thank you, Commissioner. Thank you. Good afternoon, Mr. Worth.
Good afternoon.
I'd kind of like to make sure that I have a really good understanding of the process that you use for your scoring criteria in your routing study. Okay, so I hope I don't get too far into the weeds, but we're going to get into it, I guess. It's my understanding that you looked at 729 different possible routes from Wolf Creek to down to the Blackberry station. Is that correct?
Yes, I believe that's correct.
I'm sorry, I didn't hear your answer.
You've got me. Yes, that is correct. Can you hear me?
I can now. Yes, thank you. And you evaluated those 729 routes based on 3 general criteria: social impacts, or social criteria, environmental criteria, and engineering criteria that are illustrated in table 3- of your report, correct?
So there were more than 3 criteria, but they can generally be classified into those 3 overarching aspects.
Sure. There are actually 25 criteria initially identified for evaluation of the various 729 routes, correct?
Yes, that's correct.
And as part of your analysis, you only included 15 of those 25 as part of the actual weighting criteria, correct?
I believe that's correct.
And those 15 criteria are identified in Appendix B of your report, correct?
I believe they're outlined in a table in the report in chapter 3.
They're also identified in Appendix B, are they not?
Yes, I believe so.
And the process that you used for you developed what's called a Z-score for your analysis for
That's
each
correct.
one of those 15 criteria. Is that correct?
Correct.
So for each route, to develop that Z-score, you took the value for the particular route, you subtracted the average of all the routes, divided that difference by the standard deviation of all the routes, and then multiplied by a weighting factor, correct?
That is correct.
Okay. So for instance, in table 3- if we refer to tables 3-3 and 3-4 of your report, in table 3-3 on Route 65, you have the total length of Route 65. That's the initial route that you eventually made some modifications to, correct?
That is correct.
So to develop the Z-score for Route 65, you took the total length, which is 94.3 miles, correct?
Correct.
And if you look in Appendix B, Appendix A, you provide the maximum, average, minimum, and standard deviation for total length of all the routes, correct?
Yes.
Could you speak up just a little bit, Mr. Worth? I can't hardly hear you.
Sorry. Yes.
So for the Z-score for Route 65, the process that you used in table 3-3, the Z-score for total length for Route 65 was negative 9.31, correct?
Negative 9.31, correct.
And the way you got to that number, that z-score number, that negative 9.31, was you took the length of the line, the 94.3 miles, subtracted the average for that line of 101.6 miles, correct?
That sounds correct, yes.
And then you divided it by the standard deviation of that difference by the standard deviation of 4.7, correct?
That sounds correct, yes.
Okay. And then you multiplied the quotient by a weighting of 6, correct?
Correct.
And that's how you came up with negative 9.31, correct?
Correct.
And you went through that entire exercise for each of the 15 criteria identified in Appendix B, correct?
Correct.
After you calculated the z-score for each criteria, you added those z-scores together to come up with a total impact score for a particular route, correct?
It was totaled to be a total z-score, yes.
So in other words, you calculated the z-score for in table 3.4, you calculated the z-score, total z-score by adding the negative 9.31 associated with total length with the negative 3.98 z-score for angles over 30 degrees and the negative 12.49 z-score for length not along the existing transmission line. And so forth, and for the rest of the criteria to come up with a total z-score of Route 65 of negative 52.83, correct?
That is correct.
And then you ranked all of those total z-scores from low to high and identified the top 5%, or excuse me, those routes with the lowest 5% of z-scores for further analysis. Is that correct?
That's correct.
And from table, and I just so that we make sure that we're on the same page, the lower the z-score for the particular criteria, the less impact that criteria has on the total route on all the, I guess the lower the ski score, the more appropriate the route. Is that fair?
The lower the z-score for any given criteria, the less impacting it is on that specific criteria.
Thank you for clarifying that. So for those top, or we'll just call them the top 5% of routes. And do you understand what I mean by the top 5%, the ones with the lowest z-scores? Is that fair?
Yes.
Okay. Those total z-scores range from negative 52.83 to negative 38.76, as illustrated in table 3-4, correct?
That is only for the top 5% of routes. That's what's shown in that. The z-scores would rank roughly from negative 52 to 52 if you looked at the entire 729 routes.
So but for the routes that you considered, the top 5% that you carried forward for further evaluation, the total z-scores range from 52.83 to negative 38.76, correct?
Correct.
In Appendix A, you calculated residential proximity scores for each of the routes, correct?
Correct.
Routes 1 through 729. And as we're talking about this, Mr. Worth, I'd ask you to take a look at McGee Exhibit 16.
I have that up.
Thank you. Commissioners, I'd like to share my screen so that I make sure that we're talking about the same thing.
Okay,
Can you see it?
no. Now
Can
I
you see
think
it?
we can.
Wonderful.
There we go.
So, Mr. Worth, I'm going to represent to you that there's on Exhibit 16, it represents routes 1 through 5, number 65, and the proposed routes using the criteria that you used to calculate, or excuse me, that it's a summary of those data points in your Appendix B. Would you please review Appendix A and compare and contrast it to the entries on the top table of Exhibit 16?
I've done that.
Does Exhibit 16 accurately represent the values in Appendix A for those routes 1 through 5, 6, and 65?
So are you, just to clarify for the record, are you, Mr. Kimmel, are you just asking about the, I guess, first 6 rows, including plus the top row, which includes the labels, but the first 6 rows of numbers, is that the only thing you're referring to at this point?
I'm referring to routes 1, routes 2, routes 3, routes 4, routes 5, and route 65.
Thank you.
Yeah, so those appear to match what is represented in Appendix A.
And furthermore, if you look kind of below on that top table, you see there's a column, a row that says max, average, minimum, and standard deviation.
Yes.
And will you confirm that those numbers correspond to the maximum value, average value, minimum value, and standard deviation reflected in Appendix A of your report for the 15 criteria?
Those do appear to match Appendix A.
And similarly, would you please confirm that on the bottom table of Exhibit 16, that the criteria, the Z-score criteria associated with routes 1, 2, 3, 4, 5, and 65 correspond to the various Z-scores in Appendix B?
Those do appear
For
to
those
match.
routes? I'm sorry, I didn't catch your answer.
Those do appear to match.
So in commissioners, I would like to have admitted into evidence McGee Exhibit 16 as an accurate summary of routes or of the tables identified in Appendix A and Appendix B.
Okay, do I hear any objection?
We object because the foundation has not been laid for the bottom row of that exhibit. And I imagine that Mr. Kimmel is going to want to refer to that bottom row in either additional cross-examination questions or in a post-hearing brief, and we have not established a foundation for that bottom row.
Okay, Mr. Kimmel, you haven't established a foundation for the bottom row. I would agree.
Fair enough. Mr. Worth, I'll refer you to table 4-1. In your expert report. I believe it's 4-1.
I have that.
So we'll establish the foundation for that routes identified as proposed route. The proposed route, let me back up. Table 4.1 provides the evaluation criteria for the various factors associated with the route that NextEra has proposed, correct?
This table represents the route that was proposed to SPP and the impacts of that route.
Table 4.1 represents effectively the route that was proposed and submitted with the application, correct?
No, there were additional changes made following the submission to SPP as NextEra worked with landowners. There, I believe in my testimony, I represent that there were approximately 95 changes made following the submission to SPP prior to submission to the KCC.
Okay. Fair enough. To establish the foundation for this table, I guess we'll move to the proposed route. Let's put it this way: the proposed route that you submitted to the commission as part of the application is summarized on table 4-1, correct?
No, that represents the route that was submitted to SPP following the SPP bid award. NextEra worked with landowners and modified the route. For instance, I believe the route length that was submitted to the KCC was under 94 miles, which is what's represented in table 4-1.
So what you're representing that the route that you submitted in your direct testimony with the application and identified as the proposed route is not actually the characteristics of the proposed route. Is that fair?
Can you rephrase that question?
Sure. I think I understand what I want to make sure that we're on the same page here. You identified, you did a ranking of the various routes by Z-score, correct?
Correct.
And the top ranked route was Route 65, correct?
Correct.
And then you made changes to Route 65 to come up with the proposed route that was submitted with the application for a siting permit?
No, you're missing a step in there. So we selected Route 65 based off of the Z-score analysis and additional study. From there, we did additional engineering and construction reviews with the entire project team, which resulted in some changes to Route 65, which is what is represented in Table 4-1, and that is what was submitted to SPP. That's what's represented in Table 4-1 as a proposed route. I believe
Okay.
Chapter 6 and 7 of the routing study represent changes to the route that happened following the SPP bid, but prior to submission to KCC. So there were additional changes made to the route that is represented by Table 4-1 prior to submission to the KCC.
So, okay, so that you didn't update your routing study prior to submitting it with the line siting application, correct?
We did not go back and update Table 4-1. The changes that were made are represented in Chapter 6 and 7 of the routing study.
And you said that you conducted all this work prior to submitting the proposed route to the SPP?
Everything that is represented in Chapter 6 and 7 of the routing study followed the submission to SPP, but prior to submission to KCC.
So I guess that's a different answer to a different question. I guess and maybe mine clear. Table 4.1, you said represents the routing study, or excuse me, the route that was proposed to the SPP, correct?
Correct.
And that proposed route was submitted to the SPP when?
I believe it was early 2021. I'm not sure on the exact date.
So the routing study that you submitted, that you conducted, was submitted before NextEra received their certificate of convenience and necessity, correct?
We submitted a routing study as part of the SPP bid. The routing study continued on following selection by SPP, and that's what is represented in Chapters 6 and 7 of the routing study. It's the additional work following that.
Up to section 4.1 or up to section 4, you'd completed that work prior to NextEra receiving a certificate of convenience and necessity, correct?
Yes, that is correct.
So let's talk about the route that you originally proposed to the SPP. Okay. That route is reflected in Appendix 4, excuse me, not appendix, Table 4-1.
That is correct.
Okay. Excuse me. So to calculate the proposed route Z-score for total length, the proposed route reflected in 4.1 and identified on the McGee Exhibit 16. The total length that you reported to the SPP was a 94. Is that correct?
I'm sorry, Mr. Kimmel, could you repeat that number?
It was 94.0 miles, correct?
That is correct.
And if you go through the gyrations that we spoke about for calculating a z-score for total length, by subtracting the average route length and dividing that difference by the standard deviation for total lengths, you'd come up with a z-score of negative 9.7.
That is not accurate. The proposed route that you have there underneath Route 65 was not included in the 729 routes that were used to calculate the max, average, min, and standard deviation statistics. So by introducing a new route, all of those statistics would have to be recalculated before the z-score could be recalculated, and you would need to recalculate all of the z-scores for the now 730 routes for all categories to be accurate.
What would be what you're telling me is that you did not calculate the standard deviation for all routes, including the proposed route that was submitted to the SPP. Is that correct?
We did not go back and redo the z-score analysis based on the changes that were made after we selected Route 65.
Do you have an opinion as to the magnitude of the error that would be incorporated into your analysis if you use the standard deviation and average for a particular factor?
I could not weigh in on that without actually doing the math on it. It would depend on the variation introduced by the new route.
So let's just make the assumption that it's not going to have a significant impact.
Well, I'm sorry, that assumption is not based on any testimony before the commission, so I don't think we can make that assumption, and I would object to making that assumption.
I'm asking the witness as the expert in this case to make an assumption based on this hypothetical.
Okay,
I think
if it's part of a hypothetical question to the witness, I withdraw the objection. If it's an assumption that would be relied upon for purposes other than a hypothetical question, then I would object.
Mr. Kimmel, is this a hypothetical situation?
I don't. Number one, I'm asking him to make an assumption. I don't think that Mr. Schulte's objection states a legal objection. I can ask him to make an assumption
In a hypothetical situation.
It's still not a legal objection because I can ask the witness to make an assumption for the purpose of my questioning.
My objection was triggered based on foundation because it was not apparent to me that Mr. Kimmel was setting up a hypothetical question. I thought he was simply making a statement that we were going to assume that there was only a minor error. If that's not the case, I withdraw my objection.
Okay, so
I did not
with
follow that
understanding, we will proceed and go ahead, Mr. Kimmel.
Mr. Worth, you have 729 different routes that you use to calculate the standard deviation for a particular factor, correct?
That is correct.
And given your statistical analysis that you conducted in this case, you'll agree with me that the distribution, the standard deviation of those values is a normal distribution, correct?
It is assumed that they are normal distributions, yes.
Thank you. Because of the normal distribution and the large number of values that are incorporated in it, we can expect that the standard deviation will not significantly change by the addition of one additional value in the population used to establish the average or that standard deviation, correct?
Generally speaking, yes, that should be correct. However, the changes that were made for Route 65 to become the proposed route would have affected, I believe, approximately half of the 729 routes. So that would have resulted in a much larger change in the overall averages and standard deviations if we were to continue to compare apples to apples.
With the assumption that the standard deviation is not significantly changing on the route that you submitted to the SVP.
Mr. Kimmel,
You
I'm not sure about all that question.
calculated a residential proximity score of an 81 for the proposed route, correct?
I believe you broke up there. Can you please restate the question?
In table 4-1, you calculated a residential proximity score of 81, correct?
You broke up again, but in table 4-1, we calculated the residential proximity score for the proposed route to be an 81.
And based on your agreement with me a second ago that the standard deviation and average would not significantly change, if you subtracted that value of 81, excuse me, if you subtracted the average residential proximity score of 57.0 from 81 and divided by the standard deviation of 10.8, you would come up with a residential proximity Z-score of 22.22, correct?
I don't believe that I agreed with you that the standard deviation would not change, but if it did not, that would be a valid calculation of how you would calculate that. But I do believe that the standard deviation would change there as well as the average. So I don't believe that the 22.22 can be assumed to be accurate.
Well, you
wait, let me interrupt here just a moment. Mr. Kimmel, I'm not sure where you're really headed with all this, what the grand purpose is of walking through these gyrations. And we've done a lot of this. If you could very succinctly tell us what this is all about, that would be helpful, as it's now 2:50 and I'm just not sure what the purpose is here, if you could help us.
The proposed includes a residential proximity score, Commissioner.
Yeah.
Mr. Kimmel, you're breaking up. I did not get all of your statement there.
The proposed route has a residential proximity score of 81. NextEra calculated the residential proximity score for 729 different routes here. Those residential proximity scores are reflected in Appendix A. Is that fair, Mr. Worth?
That is correct.
How many of the residential proximity scores in Appendix A are less than 81?
I don't have that calculated.
I will tell you that it's very easy to calculate. And I'd ask you to do so because I think what you would find is that 720 of the 729 routes had a residential score of less than 81.
I object to the form of the question as testimony rather than a question to the witness.
The
I
commissioner,
sustain that objection. Thank you, Mr. Schulte.
Mr. Worth, from your review, please review Appendix A and identify by route number the routes that have a residential proximity score greater or equal to 81. It won't take.
Mr. Kimmel, you are breaking up pretty badly. I don't know what we can do about that, but I do know Ms. Haas is having difficulty getting your full sentences.
He may want to trade first.
Maybe if you turn your camera off, that might help in terms of making sure that we're correctly getting the audio portion. Why don't we try that, see if it works, just briefly. Thank you.
Mr. Worth, will you please identify by route number each route in Appendix A that has a value greater than or equal to 81 for residential proximity score?
I'm not, so I'm going to lodge an objection just because I don't think it's I'll object to the form of the question because it requires the witness to do a lot of work on the stand, which, exhibit DW1, which is a routing study, which includes the appendix, which Mr. Kimmel's referring to, is already in the record, as is the 81 number, which is in table 4-1 of the routing study. If Mr. Kimmel wants to, run that number and include it in a post-hearing brief, he certainly can. I'm not sure that anything will be served by having the witness go through and count them right now.
I will, yes, Mr. Kimmel, do you have a response to that?
I do have a response to that.
All right.
NextEra has indicated that they provide that that they've identified a route in an attempt to maximize the distance of the line from residences. This testimony is to test that assertion. It's a short exercise. Perhaps we can run through it in the next minute. If Mr. Worth would simply turn to Appendix A and confirm with me that the following routes, which are sequentially numbered in Appendix A, have a residential proximity score of 81 or greater. That's all I'm asking.
I'll maintain my objection and further object to the representation that the goal of the routing study was merely to maximize the distance from residences. That assertion, I don't think, has been made as Mr. Kimmel claims.
I will sustain the objection. That I believe that to be correct. If you have the answer, Mr. Kimmel, you might share it with us.
I have a total of 9 of those 729 routes had a residential proximity score of 81 or greater.
If that's the correct
Mr.
number, then it's already in the record under Appendix A.
Mr. Worth, if 720 of the 729 routes had a lower proximity score than the proposed route that you submitted to the SPP, what percentage of those routes had a lower impact based on residential proximity score?
First off, the comparison of the proposed route with the value of 81 to the other 729 routes in Appendix A is not a fair comparison. That route was modified after the analysis was done on the other 729 routes. Some of the changes that were made to that route would have required changes to the other routes that share similar segments. I believe that was approximately half, give or take some, of the routes utilized some of those segments that were modified. So those modifications resulted in a higher residential proximity impact. So all of the score, not all, a majority of the scores, or approximately half of the scores in table or Appendix A, would have gone up in a similar amount from the change from the Route 65 to the proposed route. So you're comparing apples and oranges at that point, because the modifications would have been needed for the other 300 some routes. And then the data would need to be reran if we need to compare that Z-score or that residential proximity score directly to the other 728 routes.
Have you produced, as part of this litigation, or excuse me, this docket, what the route that you ultimately proposed to the SPP, since it's not reflected in 4.1, the Z-score that would be associated with the proposed route that was submitted to the commission?
So first off, table 4-1 does represent the route that was submitted to SPP, but not KCC, because changes were made following that. But no, we have not gone back and redone the Z-score analysis, because that is not typically done in this type of project. You do the Z-score analysis to look at all of the routes. Then you narrow it down. You look at the top certain percentage, and that can vary from project to project. On this one, it was 5%. So we looked at those 5% of routes in more detail, selected a route from there, and then did additional studies on that route and made modifications to that. Subsequent to that, we have also engaged with landowners and made additional modifications to that route, but we do not go back and rerun the Z-score, because you would end up in a never-ending cycle of going back and restarting the analysis. If every time you make a change, you have to go back and rerun the data for 730, 40, because each time you're making a change, it would be a new route that you would have to compare. So you just end up in an endless cycle. So you use the best data that you have available at the point that you make your selection, and then you do additional studies on that route that likely result in changes, whether those be landowner changes, environmental changes, engineering changes. That's typically how these projects go.
So
Mr. Kimmel, I'm sorry, I hate to interrupt you, but we need to stop and take a break and give the court reporter a break, and all of us. So we will resume at 3:15, 15-minute break. Thank you. Please turn off your microphones. Okay, folks. If we can drop the screen, there we go. All right. It's 3:15. Just a few housekeeping things. The court reporter is leaving at 4:45. We want to make sure that we are done with whatever witness so that we can let the court reporter go. At that point, we're going to take a 5-minute break. Then we will continue till 5:45 this evening, just because we're on the second witness and we're just kind of moving at a pokey rate. And we need to ensure with the shortened schedule that we get all the witnesses in. So that said, next break at 4:45 for 5 minutes. And then we will go to 5:45 and then be prepared to see how we go today, but be prepared. Thursday may be a much longer day if we continue at this rate. So just want to advise everybody ahead of time. All right, Mr. Kimmel, I think you were still cross-examining the witness, Mr. Worth. So if we can pick up there.
Mr. Worth, can you hear me? From your testimony thus far, I take it, correct me if I'm wrong, that, or I guess, please identify where you have identified for the commission and the parties of this case the route as proposed to the KCC, the number of residences within 150 feet of the center line of your proposed transmission route.
I believe that was in. One of these documents, bear with me. In my rebuttal testimony on page 6, I note the number of residences within 500 feet of the transmission line.
You said page 6?
Correct. Page 6, line 14.
Where have you identified the residences within 150 feet of the proposed transmission line as submitted to the KCC?
I don't know if we have specifically called those out in my in any of my testimony.
Where have you presented to the agency or the parties the residences within 300 feet of the center line of the proposed route as submitted to the KCC?
I don't believe in any of my testimony that I have called that out. Those are part of the KCC 40, KCC 30, it looks like, discovery request.
Would you say that again?
The discovery request KCC 30.
Yeah, I don't believe I received those. The referring to, is there a, Mr. Schulte, is there a reason why, did you serve all parties with those responses?
Yes, all DR responses were served on all parties.
So, Mr. Worth, in your rebuttal testimony, you indicated that there's 44 residences within 500 feet of the transmission line, correct?
Can you repeat the question?
In your rebuttal testimony, page 6, lines 14 and 15, you indicated there's 44 residences within 500 feet of the transmission line, correct?
That is correct.
Submitted to the KCC. Is that correct?
That is correct.
In Route 65, how many homes are within 500 feet of the center line of the route that you initially selected for evaluation? Is it 33?
Bear with me 1 second. That looks accurate. The Route 65 had 33 total residences within 500 feet.
And for the proposed route that you submitted to the SPP, how many homes were within 500 feet of the center line?
There were 46.
Say that again.
46.
So your adjustment to the routing line from the route that you proposed to the SPP to the route that you submitted to the KCC, you've removed 2 homes from within 500 feet, correct?
That is correct.
And it's fair from your testimony previously that you have not conducted a determination of the residential proximity score for the route as proposed to the KCC, correct?
That is correct.
When you initially conducted your analysis, we spoke previously about the various factors, criteria that you reviewed, and you looked at 25 criteria. Do you remember that testimony?
I do.
One of those criteria include businesses, correct?
That is correct.
And that criteria was businesses within 300 feet of the center line of the transmission, the proposed transmission line to the SPP at this point, correct?
Yes, the businesses were counted within 300 feet of the center line.
And in fact, as part of your evaluation, you didn't actually consider businesses within 300 feet because that's not reflected in Appendix B of your report, correct?
I don't believe that is accurate. We did take it into consideration. It was not included in the statistical model that was weighted. And that was largely due to the lack of businesses in that category. So we had a minimum of 0 and a maximum of 1 business within 300 feet.
And that's kind of the direction I want to go. I want to fully appreciate what you just said right there. What was your criteria for defining what a business is?
A business would be any commercial establishment where business is conducted and is open to the public.
So a commercial establishment would be a business, correct?
Correct. So things like shopping centers, stores, restaurants, hair salons, anything of that type of nature.
You understand, and it's fair to say that as part of your analysis, you did not consider the barns and machine sheds and other business entities when determining how that are associated with farmsteads as businesses, correct?
That is correct. Barns and other accessory structures or outbuildings, as we call them, are not considered businesses in this analysis. However, outbuildings were taken into consideration, and that is one of the criteria that we did look at. Although similar to businesses, it was not weighted in the statistical analysis.
So in your initial assertion, in your initial assessment, you did not consider the location of the transmission line to those buildings that farmers and ranchers use to conduct their business. Is that fair?
That is not accurate. We did take those into consideration, but they were not considered a business structure.
Do you not believe that farmers conduct economic activity, sells goods and services in the state of Kansas?
Being the son of a farmer, I do believe that they conduct business in the state of Kansas.
So I guess I'm trying to understand why you would not incorporate the location of those essential buildings in your initial analysis. Could you explain that?
As I previously stated, we did take those into consideration. We did map those. We did investigate those in the field, and we did take those into consideration in developing the routes and also in the analysis. But they were not weighted as businesses.
As part of the initial analysis to rank the various routes, you did not consider the farm sheds, the farm barns, and other buildings that farmers need to conduct their business, correct?
That is not correct. As I've already stated twice, we did take those into consideration. We did map them. We did include those counts in the tables. So those were taken into consideration. They were just not counted as a business structure.
You said that they're included in the tables. What tables are you referring to?
I believe that would be in Appendix A. There is a category called outbuildings in the right of way.
So the buildings that are not, and when you say right of way, you're talking within that 150-foot area, correct?
That's correct.
Okay. So you didn't consider the buildings that are 151 feet, those machine sheds that are within 150 feet to 500 feet from the center line of the transmission, of the proposed transmission line that you submitted to SPP when conducting your initial assessment of lines to further your analysis on. Is that fair?
So those accessory structures or outbuildings, as we call them, did not count in the statistical Z-score analysis that we did, but we did map them out to, I believe, a quarter mile from the center line. So we had those in our database and took those into consideration, and the routes were developed to avoid those. And while we give preference to maximizing distance from residences, we also try to maximize distance from other structures where we can. But a residence or a business would take precedence over, say, a hay shed or a Quonset shed or something like that.
Or a machine shed or something along those lines. That wasn't
Correct.
considered as important as a strip mall. Is that fair?
I wouldn't say that it was any less or any more considered, because businesses, so a strip mall would not have made it into the analysis, the statistical analysis either, because we weighted those as a 0. So effectively that one was not counted in the statistical model either.
Have you ever reported to the agency or any of the parties the number of angles over 30 degrees for the route that you proposed to KCC?
I believe that was one of the first KCC DRs that we responded to.
I would also like to correct the record. Mr. Kimmel never submitted a request for copies of DR responses to staff. So he may not have received, I think he was copied on some of them, but I don't think he was copied on all of them.
So Mr. Schulte, I'd like to understand that a little bit better. There was documents that were exchanged in the discovery of this matter that were not shared with all the parties?
That's correct. The rules of discovery state that a copy of the request itself must be served on all parties, and then the responses are served on the requesting party and any other parties who have requested to receive copies.
Would you identify the rule, please?
I believe it's in the discovery order. In this case, it may also be in a regulation, but I don't have it before me at the moment.
Your Honor, Commissioner, I just object because this is the first time that I've ever ran across a situation in which, when discovery was served, discovery wasn't served on all parties.
Mr. Kimmel, what are you objecting to?
The fact that I did not receive the discovery that was served on by NextEra onto the staff, the information that Mr. Worth has just indicated was provided to staff.
We provided all.
Mr. Kimmel.
All right, hold on just a moment.
Go ahead, Mr. Schulte.
I was just going to state that I'm looking for the citation right now, but we did provide all discovery in accordance with the rules. I would also note, just for the record, that the attachment to staff DR 30, it lists the homeowners and their addresses within 150 I think the metrics are homeowners within 150 feet and homeowners within between 150 and 300. And that data request was marked as confidential. But regardless, we followed the procedures for serving parties that had requested DRs.
I'm going to renew my objection because information, I don't think the number of homes would be confidential information that is within a certain distance of the transmission line.
All right, Mr. Kimmel, Mr. Kimmel, gonna have staff reply to, or our general counsel.
Mr. Kimmel, did you ever specifically?
Turn yours off.
Did you ever specifically ask for all of the discovery to be propounded that was to be served on you?
Of course, I asked for the discovery that was served on me. Yes, I don't understand that. Are you? I guess my understanding, based on the conversation here.
Could you produce anything that shows the request? Is there anything documented?
The documents were produced as part of discovery in this matter. Are you suggesting that discoveries on certain parties?
I'm having trouble hearing. There's echoing and breaking up and talking over each other.
Okay, Mr. Kimmel, it's my understanding that in order to receive those DRs, you had to request them. Do you have the document that shows that you requested the DRs?
No, I don't. And I'm asking the question, this is the first time I've ever been in a litigation in which all parties are not served with discovery responses. And I'm asking for the rule that allows for a party to not serve discovery responses on all parties.
Okay, we're going to look at our discovery order.
Okay.
All right. Okay.
Thank you.
All right. So we'll look at that, but in lieu of that, can we continue on?
Sure.
Sure. All right. Thank you, Mr. Kimmel.
Mr. Worth, on the discovery responses that you said were served, did you provide the data that would be represented in Appendix B for the proposed line that was submitted to the KCC? And I'll for example, the link through previously mined areas, the transmission line crossings, the stream crossings. Did you provide all that information as part of your discovery response?
Mr. Worth, you're muted apparently.
Sorry about that. I believe some of that was provided in DR responses, but I don't believe everything that is represented in Appendix B was requested.
As part of your, I'm going to renew my objection, Commissioner, and I understand that you're going to take a look at what it is that the rule is. I just can't believe that a party does not serve discovery responses on all other parties, but at this point, nothing surprises me.
Okay. At this point, we don't have the answer. So if you could continue with your questioning
Sure.
of this witness. Thank you.
Mr. Worth, as part of the environmental analysis that you conducted for your report, did you evaluate the impact, the environmental impact of any windmill farms or solar farms that are likely to be developed as a result of construction of this line?
Can you repeat that question?
As part of your environmental analysis reflected in your report, did you evaluate the environmental impact associated with any windmill farms or solar farms that are likely to be developed as a result of construction of the proposed transmission line?
No, we did not take into consideration any other non-directly related project as part of this analysis, and I'm not aware of any future wind farms associated with the project.
Mr. Kimmel, do you have a follow-up?
Yes, I think I've been having some technical difficulties here. Just a second.
Okay,
I
that's fine.
apologize.
All right.
Commissioner, I'll pass the witness. Mr. Worth, I appreciate the consideration that you give me today.
Thank you, Mr. Kimmel. Okay, we'll move to Evergy. If you have questions of this witness.
Yes, thank you. Good afternoon, Mr. Worth. I'm gonna skip over what you've already talked about quite a bit, but which is the factors that you looked at in your routing study and the various factors that you look at, they're given weighting in your scoring process from 1 to 10, correct? I understand that correctly.
That is correct.
And the lower the weighting for an option, the less impact that option has, correct?
Not necessarily the less impact, but it is given less weight in the overall scoring.
Less weight. So if it's given less weight, then it's going to come out as a more preferred route. Is that a better way to say it?
I believe that's accurate. Because the lower the score overall, the better the route is overall. So things that are weighted lower calculate to a lesser extent in the total overall Z-score, if that makes sense.
Okay, then in your exhibit DW1, the routing study, it's page 53 of 311, if you're looking at that version, which is what I have. You indicate that the factor length not along existing transmission line. You find it at the bottom of the page there on page 53 of 311.
Yes, I see that.
Okay, it says that on that factor, it was measured because following an existing transmission line is generally considered to have less impact than a new right-of-way. But when we're talking about less impact, then isn't it possible that the landowners along an existing right-of-way would not agree with that conclusion that it has less impact. It certainly doesn't have less impact on them, correct?
I that statement from a individual landowner perspective, but if you're looking at the project as a whole and looking across all of the potential impacts, I believe that paralleling the existing line does have less impact across the board. But you are correct that it does increase the number of structures and the amount of encumbered land on any one given landowner.
And then on page 58 of 311 of your exhibit DW1, when you're looking at in your table 3.2 here, your routing criteria weights, length not along existing transmission line, you've given that a weight of 8. Are you with me?
Yes.
That's 8 out of 10.
Correct.
And there's only 2 other factors that have a higher weighting there. And then all the other 12 have a rating that's 6 or less, correct?
That is correct.
So when you are doing your study with that type of a weighting of these factors, having the new line parallel to an existing line is going to have a substantial impact on the outcome of your study, is it not?
It certainly is one of the highest ranked factors, so it is going to contribute more to the overall Z-score than others that are weighted less.
Switch up a little bit here. On page 14 of your direct testimony, on line 12, I'll wait till you get there with me. Page 14 of your direct.
We're pulling it up now.
Okay.
Okay.
On line 12 there, you say Route 65 also minimizes paralleling of other 345 kV transmission lines, which enhances the resiliency of the 345 kV transmission system. So in that instance, you're trying to minimize paralleling another line, which is the opposite of what you were doing when you were weighting the factors. Is that correct?
So this is referring to after we identified the top 5%. So we did count length parallel to 345 kV transmission lines, the same as parallel to lower voltage transmission lines. However, there were a subset of routes that paralleled some existing 345 kV transmission lines for a significant distance. And as we were evaluating those top 5% of weighted routes, that was one thing that was brought up as a concern, was the amount parallel to the existing 345 kV due to reliability concerns.
Was that reliability reasoning also applicable then to the 161 kV transmission systems? Would the one being enhanced by not having them parallel each other as well?
So I am not an expert on transmission line planning, but my understanding is that when you have multiple 345 kV, or sometimes referred to as the bulk or EHV transmission lines parallel to each other, that is a more significant risk to the system if a storm event or something else were to happen to take out both of those lines. In contrast, if it's a lower voltage line, there's less risk to the system, is my understanding, if a similar event took out the lower voltage and a 345 kV line. as compared to two 345 kV lines.
So would the concept be the same for both 345 and 161? It's just a matter of degree?
I believe that might be accurate, but I'm not an expert on transmission system planning.
Okay, that fair enough. Did your routing study contemplate a double circuit option and the related structures, span length and all that for the double circuit option they've talked about for the 25 miles where your proposed route parallels Evergy's 161 kV line?
The study that I completed did not look at double circuiting any existing line.
Is it NextEra's intent to directly abut Evergy's right of way along that 25-mile stretch?
Yes, that's my understanding.
And I have marked in advance Evergy Hearing Exhibit 3, which is DR Evergy into, I'm not quite sure if someone can pull that up or how I do that, but it is Evergy Hearing Exhibit 3 that was provided. Or should I do it?
I'm sorry, what were you wanting pulled up?
Evergy Hearing Exhibit 3.
Had that been shared earlier, Linda?
Yes, it had.
Okay.
I have it up if that.
Okay, great. This is, okay. This is a data request Evergy into, which means it was Evergy's data request. And towards the bottom there, if you look under verification of responses, was this signed by you, Mr. Worth?
That's correct.
And in this response, you calculate the distance between the center lines of the two parallel lines to be 125 feet. Is that correct?
That's correct.
Are there NextEra pole designs that exceed 125 feet in height?
I'm not, I don't believe that I'm the correct witness for that. I don't know the heights of the proposed poles.
Okay. That's all I have. Thank you very much, Mr. Ward.
Thank you.
Okay.
Oh, I'm
thank
sorry.
you.
I need to move for the admission of Evergy Exhibit 3, please.
Okay. Any objection? Hearing none, it's so admitted. Thank you. I'm looking to our general counsel, Brian Fedotin. Is he on?
Yes.
All right.
Yeah. In terms of Mr. Kimmel's objection, the discovery order clearly distinguishes the discovery order in this docket clearly distinguishes between data requests in paragraph 14. I'm sorry, paragraph 17 that must be served on all parties, and then paragraph 18, which governs data request responses, which doesn't have that language. So in other words, the order does not treat discovery requests and responses the same way. And standard practice is for counsel to request copies of all DR responses if they wish to have them. So Mr. Kimmel's objection about the document is denied. Thank you.
Thank you, Mr. Fedotin. All right, we will.
Just, Commissioner, can I speak to that just real quickly?
Mr. Kimmel, it's been denied. We would like to move on with our next witness, please.
As I was under the assumption that you were the chair of the meeting, so I didn't know if you were the one that was denying it, or it sounds like Mr. Fenton.
We are denying.
I was explaining it, Mr. Kimmel, but the chair is presiding over this. I was giving the legal explanation, but if you'd like her
Yes.
to technically deny it, she may, to clear up the record. And Chair, maybe if you want to actually deny it on the record, so the record's clear that it's not coming from me.
Thank you, Mr. Fedotin. The objection is denied. We will move forward. So our next witness is, our next cross is IBEW.
I have no questions for this witness.
Thank you. Moving on to staff. Mr. Anschutz?
Yes, thank you, Chair. Mr. Worth, can you hear me?
I can.
I cannot hear you very well, admittedly. So if you could speak up just a little bit, it would be greatly appreciated. I am looking at your testimony, specifically your direct testimony table 3.1. And that would be on page 52 of 311 of your direct testimony. And if you could let me know when you get there, I'd appreciate it.
Are you referring to the routing study exhibit DW1?
Yes, sir.
And you said table 3-1?
Yes, and I believe you're very familiar with that. That's the routing criteria.
Yes.
Okay. Now, there are 25 routing criteria here, correct?
That is correct.
And table 3.2 indicates that only 15 of those routing criteria are actually given weight, correct?
That is correct.
And the reason for that is that it is the subjective decision of Burns and McDonald or NextEra to reduce those 25 to 15. Is that right?
Yeah, there's a variety of reasons why those were narrowed down to the 15. I believe in my previous testimony, I mentioned, for instance, that the businesses were not weighted because there was a minimum of 0 and a maximum of 1. So it did not provide a good data point to help screen or distinguish the routes. So there were several that were not included because of reasons like that. There also were multiple criteria that were combined into a single criteria. The residential proximity score is a good example of that, where residences within 150, residences within 151 to 300, and residences within 301 to 500 feet were all combined into one score there. Another good example would be the sensitive species score, where multiple criteria were combined into a single criteria to be weighted.
How were those factors developed? How does your company develop those factors?
So at the beginning of our study, we collect data on the study area that we have developed, and we take a look at what the potential constraints are. Many of those constraints easily translate into the criteria. Others are simply criteria that we have used across the country in multiple cases. And so we initially develop a list of criteria based off of what's out there, and then we review that as an entire project team and come to a consensus on what the criteria will be.
So some of the criteria, they're not unique to Kansas, correct?
Correct. I would say that a large majority of these are not unique to Kansas. The ones that would be more specific to this area of Kansas even would be like the sensitive species, because those are based on the habitat present.
How many routing studies have you and your company done in Kansas?
I I don't know off the top of my head. I believe I myself have completed more than 10 in Kansas. I know our company has completed significantly more than that.
Okay, and where would you say your company does most of its routing studies? Which state or which area of the country?
My company is based out of Kansas City, so a lot of the studies that we have done have been in the Midwest, but we have done significant studies across the country. So,
Okay, so does your company use the same factors in every case? I mean, what is the overlap from other cases you do with the factors you used here?
no, the factors are not repeated from one study to the next in full. There's likely a lot of overlap because a lot of things are found pretty much anywhere in the country, those being residences, businesses, public facilities, outbuildings, historic sites. Pretty much anywhere you go, you're going to run into those. But we do tailor the criteria for every single study that we do because each study area is unique.
So when you determine the criteria for a specific routing study, as you did here, you don't get input from a state regulator, do you?
It depends on the state. So several states have very prescriptive requirements of what must be measured and included. A good example of that is Texas. They have very prescriptive criteria that you must adhere to and provide. But I would say a majority of the states are not that prescriptive. Some have some general guidelines, and others don't even have citing authorities. So it's kind of a mixed bag.
Does your company proactively seek input from the regulator in the state that's going to be affected by the project?
We have held meetings with regulators on certain projects prior to completing a study, but I would not say that that's necessarily the norm, especially in competitive bid projects.
Can you tell me which states that you've done that in?
I know that we have done it in Texas on projects. Believe we've done it in New York. Those are the only two that are coming to mind from my personal experience that I know that we've done it. Actually, no, Maryland also. So those are three.
And just from my understanding, was the collaboration with those state regulators, was that done at the behest of the state regulator or by your company?
I believe in all three of those examples that I can recall, it was at the request of the client.
Now, in your, I believe it's your direct testimony, and I'm going to make sure that I cite this correctly. I'm looking at page, let me make sure I have it here. It looks like page 5. And you have your direct testimony in front of you, correct?
Yeah, we're getting it pulled up.
Okay, and let me know when you have that if you would.
Is it page 5?
Yes, sir.
I have that.
Okay. Now you see, I'm looking at the latter half of that page. The starts at line 18, where it says first line 14, where it says the route selection process was a multi-step process that included a 5-phase approach. Did I read that correctly? You see where I'm talking?
Yes, that's accurate.
During which phase did your company and NextEra make a decision as to what factors would be used to analyze a route?
So we initially develop our routing criteria in the study area phase. So we develop the study area, we collect the data, we analyze the constraints and opportunity areas, and that is what guides our initial routing criteria. And then as we move on through the preliminary route phase, we develop the weighting scheme there, and which criteria will be used ultimately in the decision process.
So for clarification purposes, can you tell me during which phase that occurs?
So the list of 25 was developed during the study area phase. The decision of which ones would be weighted was in the preliminary route network phase.
Okay, and were these decisions regarding the factors, were they made before the bid was submitted to SPP in March of 2021?
Yes.
Now, looking at these factors again, and I'm looking at table 3.1. So I apologize for making you scroll, but it looks like there's several environmental factors, right?
That's correct.
Okay, and when you actually get to the weighting in table 3.2, we see that there's a number of those that have made it into the criteria weighting, and I'm looking, it's approximately, we have sensitive species score, wetlands, floodplain in their right of way, stream crossings, and archaeological sites within the right of way. So there's several environmental criteria in that weighting study, correct?
There are several environmental criteria. I believe you misspoke when you said archaeological. I believe that's a social criteria.
That's social. I apologize. You're correct. I apologize for that. Thank you for the correction. To the best of your knowledge, there's actually not been a substantial environmental study or undertaking regarding the project, correct?
Can you rephrase that?
So from what you've seen, has NextEra completed any environmental studies? It looks like that these factors have just been considered, but are you aware of anything indicating that any environmental studies have actually been conducted along the proposed line?
Yes. So we have had biologists and archaeologists out surveying substantial areas of the route that was proposed to KCC, where we have right of entry from the landowners. So we have had boots on the ground studies looking at wetlands, streams, sensitive species, habitat.
Do you know when those occurred?
Those have been ongoing. I believe I had it in one of my testimonies of specific dates, or it could have been a DR. All right, I don't know the specific dates off the top of my head, but I'm looking for them now.
Okay, thank you. I appreciate that. While you're looking for that, are you aware that the Kansas Department of Wildlife and Parks, that they have informed NextEra that they will not be able to complete or give their findings regarding environmental impacts until the proposed line is decided? Are you aware of that?
I am aware of that. So the dates of the additional surveys are actually in the routing study, which is exhibit DW1, I believe, and it's in section 7.3.
I see that, and you're referring to page 104 of 311, is that correct?
We're pulling it up in the PDF right now. That looks correct, yes.
At this time, Mr. Worth, I do not have any further questions for you. I appreciate your time in this matter, and thank you for answering my questions.
Thank you.
Thank you. We will move to redirect. No, I'm sorry. I apologize. I skipped commission questions. I'm so sorry. So I believe Commissioner Keen, you have questions?
Yes, I've got a couple. Thank you.
Thank you.
I'm going to turn to the most recent subject that you've addressed, Mr. Worth, with respect to the cross-examination by Mr. Anschutz. I only had one question, but his cross-examination has prompted more. With respect to your receiving as an individual, as a company, providing these routing studies and analysis, with respect to your receiving input from state regulators regarding routing, you see any downside to receiving routing information or collaborating with state regulators in this respect?
No, I do not see a downside to coordinating and communicating with the regulators as part of the state.
Are there benefits?
I believe there are benefits because it allows us to identify potential gaps or requests that the regulators may have down the road that we can address proactively.
Not to put words in your mouth, but could also be helpful in addressing either unique or potentially difficult problem areas or issues?
Yeah, I think that it could be helpful in those respects. Obviously, the regulators and agencies and locals have a better grasp on their specific areas than any consultant could have.
Well said. You certainly reinforced my own bias, I'll say that. Okay, then in your experience then, at what stage in this process have you solicited input or received input from state regulators regarding routing? At what stage does that normally occur?
In my experience, it has varied, and part of that is just based on when the regulators prefer it. I believe in Texas, typically there's some sort of pre-hearing conference that's held. So that's before the actual application is submitted, but usually after a considerable amount of the routing study is complete. I know in Maryland, they prefer early. So at the very onset of the project, they prefer you to come and meet with them.
I appreciate your allowing us to lean on your experience here. Michelle, I really have no intention of surprising you here. Is there any way that you could go back and retrieve page 29 of Mr. Haynes's direct testimony so we could do a screen share on that one more time? If not, I'll have, okay. If not, I'll approach the question in a different way. Very good. Scan down to the question. We're under the recommendations. Okay, very good. For a point of reference for your benefit, Mr. Worth, what we're screen sharing here is page 29 from Leo Haynes's pre-filed testimony. Mr. Haynes is the chief engineer for the Utilities Division of the Commission. And what I want you to focus on with me here is under this summary of recommendations is recommendation number 3, lines 18 through 20. Do you see that?
I do.
And I'm going to again read that into the record. It's number 3. I recommend the commission consider approaching SPP to allow states the opportunity to participate in developing routing parameters to include in a request for proposal for any future competitive bid transmission lines. Did I correctly phrase that from the transcript?
That looks accurate. Yes.
If you could maybe be a little closer to the microphone, please.
Sorry. That does appear to be accurate.
All right. Well, I'm interested in your opinion and potential concurrence with this recommendation.
From my experience, I think it is very helpful for those states that do have specific requirements to help drive the routing study, I guess, to help us develop those routing criteria. I do think that that is helpful in the states that have done that. So I would concur that this would be a good, at least helpful from my perspective as a consultant. It would be helpful if the SPP and the KCC work together to come up with parameters for routing.
And thank you for that. And the suggestion here, of course, is that happened at a fairly early phase in conjunction with the request for proposal. Am I reading that correctly?
Correct.
Okay. Interestingly enough, and I think I'm probably pushing the envelope too hard with Michelle here, in fairness to her, but if we were to continue on into basically, we have 2 lines, 21 and 22 here that are on the screen from recommendation number 4, which is essentially what you're suggesting to bring Kansas kind of into the 21st century by actually having its own route model study. It goes on as on the next page. You need not find it, Michelle, in fairness to you. You can dismiss the screen share if you wish. I'm just providing information to Mr. Worth in terms of the giving perspective of where these recommendations were headed from Mr. Haynes. I appreciate your responses to these questions very much. I have one final one that relates back to the colloquy you and I had at the outset of your cross-examination. I think I know the answer, but I might as well go to the expert and make sure I'm right. When I asked you about alternative routes, and you were saying that given many of the scenarios that you had researched and you had looked at, that they would have analogous problems to this one, in that there could be similar, although different for each circumstance, parallel line issues with different routes. Did I understand you correctly? I'm overgeneralizing terribly, but is that generally correct?
I believe so, yes.
Okay. So I'm taking it that in saying that, you are trying to be, but you are in all instances assuming or taking it as a fact. One point being in the vicinity of Wolf Creek, and the other point at the other end of the line being in the vicinity of Blackberry. Am I correct on that?
Yes, I believe so.
Are you sure?
So those are areas where there are a substantial amount of existing transmission lines. So almost any route in those specific areas would likely have significant amounts parallel to those existing lines. I think that's what we were saying.
Sorry, Denise, I didn't mean to talk over him. Sorry, Mr. Worth, didn't mean to talk over you. Well, I mean, basically the SPP in having the request for proposal set a major parameter, I think, of what they were looking for. And that is they wanted one point to be in the vicinity of Wolf Creek, the other point to be in the vicinity of Blackberry. And so that was a major parameter that all the bidders were anticipating and working toward considering. I think that would be a fair statement.
Yes, that's accurate.
So, and then that would make all bidders an apples to apples comparison, certainly in terms of the beginning point and the terminus, whichever you want to consider there. Any change to that would be probably require a different RFP, wouldn't it?
I would think so. It certainly would require a completely separate routing study if the terminus points were changed.
Yeah, great point. What I'm trying to reconcile in my mind is the fact that there were certain goals that this whole process had in mind that I think we tried to capture within the CCN docket that preceded this. A major one would be relieving congestion, for example, in Western Kansas. That would be a goal. The reason I'm asking you this is that goal may be possible to be reached by a different, no pun intended, route, but that isn't what we're being asked to do here. What everybody's had a goal in mind that it was going to be this Wolf Creek to Blackberry to start with. That's the only point I was getting at. Mr. Worth, I appreciate your testimony very much. I think it's been instructive and helpful on several levels, and I have no further questions for you. Thank you.
Thank you.
Thank you, Commissioner Keen. I turn to Commissioner French for questions.
I'll be really quick. I had several questions along the same lines as Commissioner Keen on the ability for regulators to give input earlier on in proceedings, and pretty much everything I plan to ask has been answered. So let me just ask one final question, and that is, in your experience, Mr. Worth, when that has occurred, would you normally be meeting with staff of the regulator? Would you be meeting with a separate state agency? Would you be meeting with the ultimate decision maker, like myself and the other two commissioners? Who would you be meeting with in those types of meetings?
So in all of my experience meeting with the regulators prior to submission of a route for approval, it has always been with the staff of the regulators, not with the actual regulators themselves.
Okay, that makes sense. Okay, that's the only question I had. I appreciate it. Thank you.
Thank you, Commissioner French. Following up on this, Mr. Worth, does the meeting with staff that you've participated in, does it add substantially to the time frame and become a negative value to add that extra step? Or do you believe that it is, if time is a factor, that it's still worthwhile to have that input from staff?
In my experience, it has not been a significant delay in the schedule. It's usually fairly quick process, and it's usually done fairly early in the process. So there is more time to pivot if we need to for anything that comes out of those meetings.
What about in those other states? We have 120 day time frame by which we must make a decision. Is this true in the other states?
I believe maybe Texas has a requirement. I don't believe New York or Maryland do. I don't believe most states have. I'm thinking that there is at least one other state that I've worked in that did have a statutory deadline, but I'm not recalling which state that is.
Yes, we're compressed from our normal 240 down to 120. So it is very time sensitive. Thank you. I appreciate your responses, Mr. Worth. Now I will turn to NextEra for redirect.
Thank you, Chair Duffy. This will be brief. In the cross-examination by Mr. Kimmel, you testified that there was a segment of Route 65 that was adjusted for engineering purposes after the bid was submitted to SPP. Is that an accurate summary of your testimony?
That change was made prior to the submission to SPP.
Thank you for that clarification. So it was prior to the submission to SPP, but after the Z-scores were run in Appendix A or Appendix B?
That is correct.
Okay. Okay, so now I'd like to turn to Appendix A. And I'm gonna ask you a question about, it's page 113 of 311. It's also marked as A2 at the bottom. Let me know when you get there.
Sorry, did you say Appendix B or A?
It's Appendix A. A2 is it's the second page of Appendix A.
Okay.
Actually, before I ask that question, stay on that page now that you found it. What was the nature of the engineering issue with that segment?
So the segment was, I believe, 38E, and after more detailed engineering looks at the selected route, it was determined that due to the previously mined areas in that area, that it would be difficult to access. So it needed to be moved for constructability reasons.
And now I'm going to ask you my question about the second page of Appendix A. Route 65 is the second route listed on that page.
Correct.
And then the second column lists all the segments that comprise Route 65.
That is correct.
And I see 38E is listed as one of those segments.
Correct.
Is 38E included in other routes that are listed out of the 729 routes?
Yes, there's multiple on this page that I can see that have 38E as a component. I believe it was over 300 of the routes. So nearly half of the routes comprised or included that segment.
Okay. So if you were to change the inputs for Route 65 in order to reflect the changes that were made to segment 38E, you would also have to change the inputs for those other 300 plus routes in order to have an apples to apples comparison and rerun the Z score. Is that accurate?
That is accurate.
And did it appear in the cross-examination by Mr. Kimmel that Mr. Kimmel had done that process to create the bottom row of that exhibit?
No, I don't believe that he had.
Okay. That's all my redirect. Thank you.
Thank you.
Thank you, Mr. Schulte. I'll turn back to commissioners and starting with Commissioner Keen. Further follow-up questions? No. Commissioner French? No. All right. I believe you may virtually step down, Mr. Worth, and thank you. Okay.
they may tell you the applicant.
Okay, so Kara Rye is up next, and we do want to be mindful of our time to ensure that Ms. Haas is out the door. Let me just ask the parties, do you have substantial questions for this witness? If folks could, those who do have substantial and maybe a long cross, please let me know.
The next witness.
Staff doesn't have substantial questions for this witness.
Thank you, staff. Evergy?
Evergy doesn't have any questions for this witness.
Okay, Mr. Kimmel?
The McGee's do not have substantial questions.
Okay, all right. IBEW.
I do not anticipate any for this witness.
Okay, all right. I think we can go ahead. If you please, Ms. Rye, come to the stand, and Ms. Haas will swear you in.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Okay, Mr. Schulte?
Thank you. Ms. Rye, could you please state your full name and business address for the record?
Kara Rye, 9450 Ward Parkway, Kansas City, Missouri, 64114.
And by whom are you employed, and what is your title?
Burns and McDonnell Engineering Company, Inc., and my title is Natural Resources Section Manager.
Are you the same Kara Rye who filed or caused to be filed direct testimony on January 24th, 2023, rebuttal testimony on March 21st, 2023, and response to public comment testimony on March 28th, 2023?
I am.
Do you have any corrections to make to your testimony at this time?
No.
If I asked you the same questions that appear in your pre-filed testimony again today, would your answers remain the same?
Yes.
And on February 23rd, 2023, did you file, or are you aware that a corrected exhibit or a revised exhibit KW1 to your direct testimony was filed in order to remove confidentiality designations?
Yes.
Thank you. I move that the commission enter Ms. Rye's pre-filed testimony into the record, as well as the amended exhibit KW1 in place of the original KW1, as well as exhibits KW2 through KW10.
Are there any objections? It is so ordered. Thank you. Okay, commissioners. Let's start with Commissioner Keen. Do you have questions for Ms. Rye?
I have no questions of this witness. Thank you.
Thank you, Commissioner French.
No questions, thank you.
And I don't either. And we will move to Mr. Kimmel. Questions of this witness, please.
I have no questions, Commissioner.
Thank you. Evergy, Ms. Kafer?
No questions, thank you.
Okay, IBEW, do you have questions? Mr. Wood?
No questions. Thank you.
Thank you. Staff, do you have questions of this witness?
No questions.
Thank you, Mr. Lateef. Going back to commissioners, I'm not seeing any takers there. Okay. And Mr. Schulte, any comments? There's no redirect. Okay. Well, Ms. Rye, you may virtually step down. Thank you for your time.
Thank you, Chair Duffy.
All right. Okay. So at this point, this is a good time, I think, to take a break. Let's take a break right now. And Denise, thank you for your time today. We will see you on Thursday at 9 o'clock.
Okay, thank you.
Thank you. We're going to take a 15-minute break. Now let's make it a 10-minute break. We will come back and be on the record at 4:45. Thank you, everyone. Please mute your microphones. Okay, folks, it is 4:45. We can take down the screen and it looks like everybody is here. Okay, we are, before we start with our next witness, I just want to ask witness Sarah Powers, Dan Mayers, and Chris Olson. Parties, do you believe you have extensive questions for witness Sarah Powers?
Staff has a few questions, not substantial.
Okay, Evergy?
We do not have any questions for Ms. Powers.
Okay, Mr. Kimmel.
Yeah, excuse me. Yes, Commissioner, we have questions for Ms. Powers.
Okay, all right. Let me ask on Mr. Mayers, will there be extensive questions for him? And Mr. Kimmel, why don't I start with you?
I believe we will.
Okay. What about Mr. Kimmel on Chris Olson?
We will have questions for Mr. Olson too.
Okay, all right. What I'm trying to do, folks, is just figure out who we've got an hour left, who we can fit into this time slot best, and maybe complete a witness so that we start fresh tomorrow at 9 o'clock with a new witness. But it appears, well, why don't we just stay with our witness order as we have it? And Ms. Powers, are you there? Yes, you are. Okay, I'm going to ask you to raise your right hand. And are you on mute?
Can you guys hear me? I think we're on a
There we go. Okay, just want to make sure. Okay, if you'll raise your right hand. Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. All right. I will look to Mr. Schulte.
I think
Ms.
Ann Holland-
Kallenbach, I'm sorry.
No,
Okay.
that's fine.
All right.
Thank you.
Please.
Ms. Powers, would you please state your name and business address for the record?
Sarah Powers, and my business address is 700 Universe Boulevard, Union Beach, Florida, 33408.
And by whom are you employed and what is your title?
I'm employed by NextEra Energy Transmission, and my title is Director of Development.
Are you the same Sarah Powers who filed rebuttal testimony on March 21st, 2023, testimony in response to public comment on March 28th, 2023, and rebuttal to public comment testimony on April 7th, 2023?
Yes.
Do you have any additions or corrections to make to your testimony at this time?
No.
And if I asked you the same questions again today, would your answers remain the same?
Yes.
Thank you. Chair Duffy, I move the commission to enter all of Ms. Powers' pre-filed testimony into the record.
Any objection?
Yes, your Commissioner, the McGee's have an objection. The testimony that Ms. Powers has provided in writing does not lay foundation for expert testimony on ag production and in particular farming operations.
Well, I'm going to allow her testimony and overrule your objection, Mr. Kimmel. Okay, if you will proceed.
Thank you. Chair Duffy, I also believe that Ms. Powers is the appropriate witness to answer the questions that Commissioner Keene had regarding oil and gas leases. So if he would like to pose those questions to Ms. Powers when he feels it's appropriate, that would be great.
Okay, so we are admitting her testimony.
Yes, thank you. And with that, I will tender Ms. Powers for cross-examination and commissioner questions.
Very good. We will start with commissioner questions. And Commissioner Keene, do you have questions of this witness, please?
No questions for this witness. Thank you.
All right, thank you. And Commissioner French?
No questions, thank you.
Very good. Okay, let's move to Mr. Kimmel.
Thank you, Commissioner. Good afternoon, Ms. Powers. What education do you have in agricultural production?
My degrees are in geosciences and ecology.
Do you have any education in agricultural production?
I have no formal education in agriculture production.
What experience do you have individually in agricultural production?
My experience in agricultural production is predominantly from my work with landowners who are themselves in that industry.
So you have no direct experience in running a row crop operation. Is that fair?
That's fair.
Do you have any training in regard to agricultural production?
Again, my experience with agriculture production is related to my work with landowners who they themselves are experts in that industry.
So the farmers themselves would be the experts and not you, correct?
In the details of their day-to-day operations, each farm is different and each landowner is different. So in that respect, we rely on them to tell us what their needs are, and then we consult with our project teams on the project as a whole.
You have no expertise in agricultural production, correct?
I am not an agricultural producer.
You have no expertise in agricultural production, is that correct?
Chair Duffy, I'm going to object to this. The witness has already stated that she has no expertise in that area. I think we can move on from that.
Yeah, Mr. Kimmel, you have a response? I would believe.
I appreciate Ms. Collenbeck's acknowledgement that the witness has no expertise in agricultural production. Given that acknowledgement, I would ask that all testimony that Ms. Powers provides in regard to agricultural production be stricken from the record. She hasn't established herself as an expert. She's acknowledged she's not an expert, and that will cut back on our questioning here.
Ms. Collenbeck, would you like to respond?
Yes, we will stipulate that she is not an agricultural production specialist, but she is qualified to testify regarding the siting of transmission lines on agricultural land. And that is what she does at the company currently and for the last several years. And that is what her testimony discusses.
Yeah. Yes. With your comment there, Mr. Kimmel, why don't we give it the weight it's due? And I will overrule your objection, but noting your comment and giving the weight it's due. I do believe you made your point. Thank you. Would you like to continue on with your questioning?
I would, Commissioner.
Okay.
Ms. Powers, excuse me. Bear with me for just a second, please. I'll refer to you to your rebuttal testimony on page 6. In which you state, I'm not aware of any issues surrounding spraying around operational transmission lines. Did I accurately state what you testified to? I'm sorry, Ms. Powers, I think you may be on mute.
Yes, that's accurate.
Who did you speak to regarding the impact of transmission lines on aerial spraying in agricultural fields?
So we have an entire operations division that manages our transmission assets. And we first spoke with those operators to see if we had encountered any landowner issues with operational transmission lines and aerial spraying. They indicated they had not. We also took it a step further, and our lead land agent contacted a number of aerial spraying operators who work in the state of Kansas to get their opinion on whether there would be material issues to spraying around operational transmission lines. And their opinion was that it does not.
And I guess I will object again, Commissioner, that this witness, if she's essentially providing hearsay evidence of what somebody else told her, as opposed to her own knowledge based on her experience or her expertise. And I again ask that the commission strike the witness's testimony.
As I think we've stated previously, Mr. Kimmel, we will give your comments the weight it is due, as well as her testimony. So, okay. And I will deny the motion to strike. Do you have
Ms.
further
Powers.
questions of the witness?
Ms. Powers, you also provide testimony regarding the easement agreements that you're entering into with landowners, correct?
Yes, that's correct.
I'm sorry, we did not catch that, Ms. Powers. If you could repeat your response.
Yeah, I'm sorry. Let me move the speaker a little closer to myself. Yes, that's correct. I did provide testimony regarding the easement document that we use with landowners.
Bear with me. I apologize, Ms. Powers. I'm having a little bit of trouble here for just a second. Your standard easement agreement that you enter into with landowners, are you familiar with that easement agreement
Yes.
filed with Becky Walding's testimony?
I'm sorry, Mr. Kimmel, you cut out a little bit, but I am familiar with the option agreement form that was provided in Ms. Walding's testimony, if that was the question.
Sure. And under that easement agreement that was filed with Ms. Walding's testimony, it did not include the compensation portion of that agreement that was submitted with the McGee's petition to intervene in the certificate of convenience and necessity, and it's been admitted into evidence at the beginning of this hearing. Is that correct?
Yes, the compensation page was not included in the exhibit in Ms. Walding's testimony.
I'm going to ask because the evidence was admitted.
Mr. Kimmel, excuse me, I'm sorry. Mr. Kimmel, you're breaking up again and we're not catching all your sentence.
Ms. Powers, would you please bring up a copy of the easement agreement and compensation package that was filed and admitted into evidence in this matter, that was filed with the McGee's petition to intervene in the CCN?
Would you mind directing me to which exhibit you're referring to, please?
Well, the exhibit that was provided with it's the exhibit that's attached to the application, excuse me, to intervene in the CCN docket.
Mr. Kimmel, if you can identify the number, we probably more easily could pull that up.
And commissioners, this is a document that was previously admitted into evidence. It's not one of the exhibits that I produced because I frankly did not realize that NextEra had failed to include the compensation portion of that easement agreement with the prior witness's testimony. So I'm asking the witness, if she doesn't have it, that's fine. I can pull it up on my screen. And we can talk about it that way.
Why don't you go ahead and pull it up on your screen then? That might be the quickest way to get to that.
Well, shoot, just a second.
Mr. Kimmel, I do believe, okay, you've got it?
You do.
Great. Good. We just had it.
Ms. Powers, the easement, the compensation package associated with these easement agreements provide for a payment based on the 150-foot wide easement across the farmer's field. Is that correct?
Among other things, yes.
For instance, if the farmer has if the 155 easement impacts 3 acres on a farmer's field, that you were paying only for that aspect of the transmission easement portion identified in the easement. Is that correct?
If the 3 acres are the only acres impacted by our project, then we would pay based on that 3 acres for the per acre payment that you're referring to.
And I guess I started this line of questioning with a prior witness. The easement, and I need to follow up with you because I think it's important. Well, it's important. Our witness indicated that you were the person to be asking these questions to. But just to establish what was pre-testified to is that these easements address the entire parcel of the farmer's property, correct?
Can you be more specific? I'm not entirely following your question.
Okay, for the easement agreement defines the property that's being impacted by the easement, correct?
That is correct.
Okay. And that property is defined as the entire parcel of the farmer's ground. In other words, if it's the southeast quarter of a certain section, your definition of property incorporates that entire parcel, that entire quarter section, correct?
So that's only partially correct. In the form version that you have, there is not an exhibit that shows the potential location of the easement, the 150 feet, which is something that we do provide to landowners ahead of the easement execution. There's also the potential that we may need an access easement or a temporary easement on the parcel. That would be defined in Exhibit B. So the reason that that is excluded from this exhibit is because we have not yet received approval from the KCC. So we do not know exactly where the approval for the line is going to be. So we're not able to identify those areas. You should consider the easement to be a living document ahead of the execution. Once we have more certainty as to where the easement is going to be, if we receive KCC approval, we will define specifically where that 150-foot easement may be. And any other access or temporary easements that would be required would be defined in that easement agreement. And that would limit where NextEra Energy Transmission has the right to operate or access.
Based on, I appreciate that response, Ms. Powers. But my question was a little bit different. In the definition of property in your easement agreements, that property is defined as the entire parcel that the owner or the property owner.
Yeah, now he's getting into specifics.
Correct?
Yes, for the purposes of identifying the location, the property is defined as the owner's parcel.
The entirety of that parcel, correct?
That's correct.
And then the easement agreement provides for several different types of easements, one of which is a transmission easement. Another is an access easement. And the third is an overhang easement, correct?
That's correct.
And the compensation that you incorporate into the option easement agreements is based on the area associated with the transmission easement, correct?
I'm sorry, Mr. Kimmel, I missed the first part of your question. Would you mind repeating it?
In the compensation package or the compensation portion of the option and easement agreement, the compensation that NextEra is offering to pay the landowner is based on the area outlined by the transmission easement, correct?
That is correct for the per acre payment, but doesn't necessarily apply to other commercial terms that may be included in the compensation page.
And what other terms are those?
Would you mind scrolling to that appendix that shows the compensation?
Sure.
As long as it's relevant.
Okay, excuse me. I'm going to ask Mr. Kimmel, the relevancy of this line of questioning of compensation. I'm struggling with that.
It goes to Commissioner Keene's question in regard to the costs that these landowners will be incurring, and whether or not they are being compensated. That cost that the landowners are incurring for the transmission easement going across their land is being evaluated by NextEra. That's why it's relevant.
Okay, and that's for the property owner to determine if it's fair.
No, that's not. The relevancy here is addressing the costs that the landowner is going to bear when the transmission line, or if the transmission line is being constructed across their property, and whether or not those impacts are being addressed by NextEra as part of its evaluation of costs and benefits in this docket. This isn't going to take a long time, Commissioner.
I don't see how that.
All right. Well, I'll let you continue a little longer, but I'm really struggling with how this relates directly as to why we're here today. But I'm going to allow a few more minutes.
This easement agreement, as it defines property, the access agreement that is defined in this easement agreement allows for NextEra to construct roads across the property outside of the transmission easement area, correct?
That is correct. That would be defined as the access easement if needed.
Well, the easement that you're getting provides for an opportunity to construct roads across the entirety of the parcel that the farmer owns, correct?
Again, what you're looking at is a form agreement without any specificity as to a property. So I think your interpretation of the base form is probably correct, but that is not the ultimate form that any landowner ends up executing, because we do tailor it to the specific property, and the landowner is given exhibits as to where those easements will be. In addition, if there are specific areas on the property that the landowner wants us to avoid, that's part of the conversation we have with the landowners. And we do also include, upon request, exclusion exhibits that would limit our ability to build access roads as you're describing in those excluded areas. So the missing piece, I think, that you're not seeing in the form agreement, because it is just a base form, not specific to anybody's property, are those details about the individual landowner and their property.
Based on the base form that you have been presenting to landowners, you do not anticipate compensating landowners for constructing of those roads outside the easement area, correct?
That is not correct. Our intention is to pay the landowners for any property that we impact. We have had some landowners request more specific language to that effect, and we do include it. But in practice, we pay landowners for any of the easement area that ends up being depicted in that Exhibit B that shows, both the transmission easement and access easement, or any temporary easements. And for the access and temporary easement, we pay the same per acre amount as the rest of the property. So we don't discount it because it's a temporary easement.
And the same question for the overhang easement. The form.
Chair Duffy, if I could interject an objection here. I believe Ms. Powers has explained that all these items are part of private negotiations between the individual landowner and the company, and I really fail to see the relevance here. The purpose of today's hearing is to assess the necessity for and the reasonableness of the location. And I don't believe that private landowner negotiations are part of that analysis.
Okay, Mr. Kimmel.
Response? Yes, Commissioner, the easement agreement was attached to the testimony, incorporated in the testimony by a prior NextEra witness. If it wasn't relevant, it wouldn't have been attached to that witness's testimony. I'm simply asking questions about an exhibit that was attached to a witness's testimony to fully understand the costs and benefits that NextEra is evaluating in this case.
All right, Ms. Kallenbach, do you have a response to that? And after your response, I will ask the commissioners to go into a breakout room, please.
Yes, yes, we stipulate that Exhibit BW7 was attached to Becky Walding's testimony as adopted by Ms. Blakely. However, Mr. Kimmel is not delving into just this base agreement, and Ms. Powers has already explained that it is a living document. It is privately negotiated with each individual landowner. He is asking her questions that get into the nature of where would you build roads, what would be excluded areas, and that's simply not the purpose of us including the base document.
Okay, thank you. At this point, we're going to go off the record and commissioners into the breakout room. Thank you.
Just commissioners, or do you want counsel in with you?
Yeah, general counsel would be fine.
Okay, thank you.
And we'll wait on Commissioner Keen.
Here, I just submitted him, so he should be coming.
There he is.
Yeah.
Okay, great. I'm going to sustain Ms. Kallenbach's objection. And Mr. Kimmel, this is not beneficial to the reason that we are here today. So if you could move on with a different line of questioning, that would be appreciated.
Sorry, Commissioner. Is the commission instructing me that I can no longer ask questions regarding this exhibit that includes the easement agreement and compensation package?
The compensation package and the easement agreement, I believe the witness and the attorney has already described that it is a living document and it is up to each individual landowner. Whether it's right or left, as it relates to the easement agreement, is not what we're discussing here today. And I believe Ms. Kallenbach was very clear about why we were here, and it is not about easement agreements. Now, if you will proceed on with another line of questions.
Okay, I guess I'm kind of at a loss as to what the confines of my questioning are, Commissioner, because I have a question regarding how NextEra's provided testimony regarding how they're going to compensate landowners for the damage associated with the construction of the transmission lines.
I believe that is something that, yes, you would like to ask that. I think that is a different line of questioning.
Okay, thank you.
Thank you.
In the compensation aspect of the easement agreement, you provide for compensating for damage associated with crops, correct?
That is what is presented in the base form agreement that you are, at least the one that's in the McGee exhibit that I see, yes. It's specific to cultivated crops.
Cultivated crops. And you understand that this transmission line is not only going to propose to cross row crop fields, but also pastures and hay meadows, correct?
Yes.
How is NextEra proposing to compensate the landowners for the damage done to their pastures and hay meadows that are not in row crops?
Sure. So I think at a high level, our goal in every landowner interaction is to be a good long-term partner. So if there is damage to a landowner's property of any kind due to our activities, our goal and our best practice is to compensate them. So the compensation agreement that you have that defines how we compensate landowners for cultivated crops is not the only mechanism that we use. And I'll defer a little bit to our attorneys without providing a ton of detail. I can tell you that we do have agreements with landowners where we have compensated them for other types of damage, including damage to pasture land, as you suggest. There's a number of different criteria that we've found landowners care about, depending on their land use. But we are very responsive when a landowner indicates they have concerns about damage. And I would at least initially say that the details of those negotiations and how specifically we compensate them would be confidential. But I'm happy to explain, in more detail to the commissioners as appropriate.
Okay, I don't quite understand the confidentiality portion of your testimony, Ms. Powers. Could you explain that? What is about that?
Chair Duffy, I believe I could explain it if given the opportunity.
Yes, please, if you can answer the question.
Thank you. Yes, the company believes that all specific landowner negotiations and the contents of those should be kept confidential because they are a matter of private negotiation. So to the extent that Ms. Powers can discuss generally what activities the company does to restore hay meadows or pasture land, that is absolutely fine. To the extent that Mr. Kimmel wants to know amounts of damages paid to a specific landowner, I think we would object to that as being confidential.
That question has not been asked as far as what specific damage was provided to a particular landowner in this case yet. My question, I guess, for Ms. Powers would be, you understand that the commission has raised concerns with the impact of the construction on roads and bridges in the various counties that were being that you've proposed to construct this transmission line, correct?
So I'm not an expert in the road and bridge crossing agreements. My area of expertise, and I think the scope of my testimony would be limited to landowner impacts. But I think
I guess.
Oh, sorry, go ahead.
No, I'm sorry. I didn't mean to interrupt you. I thought you were done.
No, I mean, those specific construction related impacts, I would defer you to Dan Mayers for those questions.
And my question was, are you aware that the commission has raised concerns with the impact of construction on roads and bridges in the counties that have been proposed to, that the transmission proposed to traverse?
Not in detail, but I'm aware that those concerns have been raised in general.
And I'll represent to you that it's my understanding, at least, that the trucks that will be carrying the equipment for the poles and other equipment that will be installed can weigh over up to and maybe exceed 80,000 pounds.
Chair
Are you
Duffy,
aware?
excuse me, Mr. Kimmel, I'd like to object to this. Ms. Powers just stated that she's not the appropriate witness to talk about roads and bridges. I think that those questions should be deferred to Mr. Mayers, as she suggested.
I will agree with Ms. Kallenbach that Ms. Powers just stated that she was not the expert there and on roads and bridges and construction damage, and that Mr. Mayers, who is our next witness, is the appropriate person. So I would ask you, Mr. Kimmel, to hold those questions for the next witness. Thank you.
Ms. Powers, how does NextEra propose to compensate landowners for compaction to pastures and hay meadows?
So that is a concern that we have had raised by some of the landowners, particularly when it comes to pasture. And we insert a provision very similar to the one that you see for row crops that provides a compensation amount for compacted areas to compensate the landowners for any potential reduction in crops over a period of time due to the compaction of that area. And those specifics, again, would be specific to that landowner, what they care about. And I believe Mr. Mayor can also give you some details about methods that we use to try and reduce compaction. But if it occurs, we will insert, or if the landowner raises that concern, we will insert a provision in the easement agreement, like I said, very similar to what you see for crop compensation, that would address compaction compensation.
Thank you, Ms. Powers. I'll pass the witness.
Thank you, Mr. Kimmel. Okay, so I turn to Evergy and Glenda Kafer. Do you have questions of this witness?
I do not. Thank you.
Thank you. Next, IBEW. Do you have questions of this witness?
No questions. Thanks.
Thank you, Mr. Wood. And staff, questions of the witness, please.
Yes, we have a few questions. Hi, Ms. Powers. My name is Hassan Latif. I'm one of the attorneys for staff of the commission. I have a few questions for you, just to clarify some of the issues that you raised in your testimony. So in your testimony, you talk about NextEra's team negotiates with landowners And where possible, those negotiations include micrositing the line to a mutually agreed location. Am I correctly representing some of the discussions you have with landowners?
Yes, sir.
Okay. In the situations, I guess there's some give and take in those negotiations, and that not all those negotiations lead to a resolution where both the landowner and NextEra agree on the proposed location.
Not all. I mean, as Mr. Wirth talked about in his testimony, there's a lot of things that we have to take into account, but we do try and make a point to visit the property in person when possible to accommodate any landowner requests to relocate equipment or relocate the easement. And I can't recall exactly, but I think that we've done in the neighborhood of 100 pole relocations due to landowner requests. So while we can't accommodate 100% of the requests, we do try very hard to accommodate everything that we can.
So our question is if there's a situation where there's no agreement reached between NextEra and the landowner, and you have to pursue the land through eminent domain, what is the default side of the line? Does it go back to what the original proposal was, or does it go to the microsited, or is it just a case by case basis that you're guys doing it on, or is there a default that you guys would have to do for eminent domain?
Yeah, and that's a great question. I would say we don't necessarily have a default route. You know, my responsibility sort of ends when landowner negotiations are no longer occurring. But I can tell you that in the siting process, if we've had the opportunity to microsite and come up with a route that gives us more certainty as to what's feasible, that's the most likely route we'd include in condemnation proceedings. But it would certainly be on a case-by-case basis because the things that landowners care about varies by individual.
Okay. In the situation where if you're locating poles that have guidelines on them, is NextEra or the homeowner responsible for the management of the vegetation around the guidelines, or is I just going forward after it's installed? I don't know if there's an answer. That's a question that's come up for you before.
No, it's a great question. Generally speaking, NextEra is responsible for the maintenance of the line and any vegetation that would occur in the line. There are many circumstances, however, where the landowner chooses to farm or ranch in that area and wants to maintain the vegetation on their own to maximize their use of the property. And in that case, obviously, we work with them to do that. But we would not expect the landowner to be responsible for maintaining vegetation that does not suit their personal land use on our behalf.
Okay. So I just wasn't aware that the NextEra would then be handling the maintenance of the vegetation. So is it like an annual maintenance, or is it something that I don't know if you have like a policy on that, on how that's maintained?
Yeah, Mr. Mayor may have more detail, but in my experience, vegetation management is once or twice a year, we would enter the property and do any mowing or trimming that's required. There may be special circumstances where a landowner has planted fast growing trees or something like that require more maintenance, but typically it's annual or semi-annual unless there's some special circumstance.
Okay. I had a specific question about one of the statements in your testimony. It's in your response to the public comments on page 6, lines 1 through 3. And I can read it into the record unless you have it there.
We're just pulling it up. We'll be right there.
Sure.
We've got it. Thanks.
Okay. So it's in that first 3 lines. The landowner should exercise caution while working around the energized transmission line, pole guys and anchors, and leave sufficient room so as not to endanger his or her equipment or self. So when you are working with the landowners, what kind of how do you counsel them on how to be careful around the poles or the guidelines and things like that?
So we would actually refer them to Mr. Mayor's team on construction and operation, but effectively from like a landowner relationship perspective, we would make sure that they have a contact. We always try and coordinate with the landowner. Again, we're long-term partners. We want to be good partners. We typically will make sure we're aware of what kind of crops, for example, they may be planting or what activities they want to engage in on that property, what type of machinery they plan to use. And then we would coordinate with our construction, operations, and maintenance teams to provide any needed guidance on how those activities could continue safely, just because it is an energized transmission line. And while I'm not aware of any incidents, our priority is certainly safety around the line. So it's, again, somewhat of a case-by-case basis, but we do provide access to our operations team to help provide landowners with any guidance that might be necessary.
Sure. Do you have any special discussions you have with landowners who have livestock who are grazing, and about the interaction between livestock and the poles or the guidelines or things like that?
No, we have a lot of our line runs through active ranch land, and there really aren't any special considerations for the ranch operator. The special considerations are more on the NETE side, making sure we close gates and things of that nature, but it's a very compatible use.
Okay. I don't think we have any, we don't have any other questions. Thank you so much for your time.
Thank you.
Thank you, Mr. Latif. I'll turn to commissioners. Commissioner Keen, do you have questions?
No questions, thank you.
And Commissioner French?
I have no questions. Thank you.
And I just have a brief one, Ms. Powers. So when you talk about vegetation management, as you did with Mr. Latif, and you said is that a third party that you contract with, or is it specifically your company on the ground here in Kansas?
Mr. Mayor would be the expert on that, but in my experience, we typically have in-house operations staff.
Okay, very good. Thank you. Is there any redirect, please?
I just have a very brief amount of redirect, Chair Duffy. Thank you. Ms. Powers, do you recall when you were being questioned by Mr. Kimmel that he raised some questions regarding your expertise in agricultural production?
Yes.
And you are currently leading the land and geospatial team for NextEra Energy Transmission, correct?
That's correct.
And in that role, you routinely engage with landowners during the land acquisition phase of development. Is that right?
Yes.
Is it correct to say that NextEra Energy Transmission and its affiliates own over 1,000 miles of 345 kV transmission lines across the United States?
That's correct.
And is it fair to say that those 1,000 miles of line are located in a variety of landscapes, some of which could include land use for farming and ranching?
Yes, and they do.
And so you have familiarity based on your experience with the company with the concerns often expressed by landowners with respect to siting transmission lines on agricultural or farming or ranching operations.
Yes, that is our job.
Chair, I'm going to simply object to this line of questioning. This is unbelievably leading questions. She's already testified she has no expertise in agricultural production, and now that she's trying to be rehabilitating the witness for her lack of expertise that's already been acknowledged. It's inappropriate, and it's frankly, I don't get it, given that we're not have an opportunity to recross. It's simply unfair, given the stipulations already made.
Okay, Mr. Kimmel, we will strike her testimony from this last redirect from Ms. Kallenbach from the record. Thank you.
Thank you.
Is there anything further, Ms. Kallenbach, for your witness?
No, nothing further.
Okay, I'm looking at the commissioners. I see Commissioner French, but I don't see Commissioner Keen. Do you have any questions at all? Redirect questions?
Right, he's saying no.
No. Commissioner French? No.
Right,
Okay, very good. Thank you, Ms. Powers. You may step down virtually. All right. All right, everyone. We successfully completed this witness today. Are there any objections from party here today from the parties to start at 8:30 tomorrow morning instead of the 9 o'clock? so that we can get in an extra 30 minutes. Is there any objection from parties? Please let me know.
No objection from staff.
Okay, I'm not hearing any objections. Okay. Ms. Kafer? Are you good? Okay.
No objections.
All right, great. And from commissioners, there's not, I'm assuming, Mr. Kimmel, Mr. Wood. Okay, it looks like we will start tomorrow morning at 8:30. We will start, and there will be no court reporter, so this will be again recorded as it was today. So thank you, everyone. We will recess for the day. And have a good evening.
Commissioner, would you
Yes, Mr.
clarify?
Kimball.
Would you clarify tomorrow's hearing is supposed to end? I believe you said 1 o'clock, but I want to
Yes.
make sure that that's correct.
Yes, 1 p.m. Is that,
1 p.m. Thank you.
will that allow you time, Mr. Kimmel?
I would prefer if we stopped at noon. Hopefully we'll be through.
Maybe 12:45. Would that work for
Yeah,
you?
basically what I think we should probably go with is if we're done with a witness, then we can just address it at the time, but I just wanted to.
Okay, so what we will do is we will proceed till 12:45. All right. Thank you, everyone. We'll see you tomorrow.